Megan Fox.
And Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox writes at PJ Media.
Eat Tucker.
That was your best.
Damn it, man. I cried for 2 days.
Megan, thank you very much for that.
So, I can explain the bed thing.
If you don't show up and vote, up your ass. I don't care if you're in the hospital. Crawl to the stake. Crawl there.
It's like Jesus going into the temple. He's like, I got a whip. Get out! Get out! The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood in his toe thumb.
Megan Fox.
Megan. And honestly, Megan, if you don't like it, I'm sorry. She's the devil.
Megan Fox. Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go? Holy sh!
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's
Pissed off the wrong woman.
oh my God, I have been assaulted when Megan Fox runs wild on you, brother.
She's the devil.
Not for publication.
The story.
I'm Megan Fox. Thank you. Cheers.
Good morning, everyone. It's way too early to have the camera on. I am not dressed. I'm in my jammies. I have no makeup on. Yeah, I'm not turning on the camera for a while. I'm gonna have to ease into my morning here. It's 8:30, 8:40. Oh my goodness. It's too early for this. I must love you guys a lot because I could be sleeping right now. I could be cozy in my bed under my down blanket. I could be snoozing, snoring along for at least 2 more hours. And I'm not. What am I doing? I'm here watching lawyers who can't brush their hair, can't look decent for court for some reason. We're watching the Jennifer Crumbley trial. She's going to be cross-examined today. Looks like things are getting going in the courtroom. I don't know. Do we have volume? No, not yet. No volume. Looks like Attorney Smith's hair is a little bird's nesty. Yesterday, get this. Yesterday, somebody actually got footage of her brushing her hair in court. So now we know that she actually has a hairbrush, and so she can use it. She does know how to use a hairbrush. Let me see if I can find that video. Somebody tagged me in it yesterday on Twitter, and I was laughing so hard. I think it might be the first time we've ever seen, here it is, that we've ever seen an attorney brush their hair in court. Check it out. So now we know that Attorney Smith has a hairbrush, and yeah, she needs to use it on her client's hair. That would be good, because poor Jennifer Crumbley looks like she hasn't had her hair brushed. the entire time she's been in prison. Yeah, brushing your hair in court is better than not brushing your hair, though. I know some of you are like, why is she doing this in court? And I think, well, wherever you must do it, just do it. All right, how are you guys doing in the chat today? Archie Ruckus Cam is ready to get started. If when we hit $100 today, we'll unlock Archie Ruckus Cam. And I have a special treat for him to keep him in his bed today. I'm yawning. Hold on a second. I'm so tired, you guys. I froze a peanut butter treat for him. And so it should take him longer. Yeah, I froze it, Brad. I froze the Kong tire with peanut butter in it. Well, I put it in the freezer an hour ago. So hopefully by the time we hit $100 in super chats today, it'll be totally frozen, right? It should be. It shouldn't take more than an hour or two. Anyway, that'll be fun. The Archie Ruckus Cam was very entertaining yesterday. Oh, by the way, he totally destroyed that carrot toy. He ripped the cover off of it. So now it's just a block of foam with holes in it. Kimay says this stream is already turning into a hair stream. Oh, wait till I do my hair on stream. I'll end up having to do my hair and makeup on stream today. So. Oh, Lord. Yeah, don't forget to hit the like button. I got up super early to do this. I got out of my warm, toasty bed to do that, to sit here with you. And I'm very tired. I'm drinking my coffee, but I need more. More coffee! What are you guys doing today? How are you today? How's everybody doing in chat? Oh, the locals chat is open. By the way, there's a members-only locals chat. How are you, locals? Good morning. Good morning, my friends, my dear ones, my favorite children over there on locals, my memers. How are my meme farmers doing today? This trial is really hard to meme. For God's sake, it's terrible because it's so depressing. A quick recap is Jennifer Crumbley is on trial. She's the mother of school shooter Ethan Crumbley, who's already been tried and convicted for the crime, for the murders. And we're going to start spinning this early? Really? Really? Are we really going to start spinning this early, YouTube? I swear YouTube hates me. All right, where did I put the twat waffle overlay? Let's see if that will work on the Law and Crime logo. Where are you? There we go. There's one of them. I think I have another one. Did I delete it? That would have been stupid. I thought I had more than one. I have this. That's not right. This must be the only one I have. I thought I had two different ones. All right, anyway. What was I saying? I was talking about something. Oh yeah, locals. So the memeing is kind of difficult. Although I was promised some Archie Ruckus memes. I have not seen any of those yet. If they make any, though, I will. Well, I've only seen one. I showed it yesterday, but I was promised more Ruckus memes. And hopefully we'll get some more of those today. All right. I am only here until 12 o'clock today because I have a massage later that I am not going to miss. Nothing could keep me from it. So what I'm going to do is redirect you to Recovery Addict. Oh my God, YouTube. Seriously? And why is it behind? The hell is happening here? All right. We're still just wandering around the courtroom. Oh, I forgot to tell you. So you guys know my mom went into the hospital. Well, my dad was sitting in there with her. She was in for some tests, and my dad was sitting in there with her, and the nurse was like, "You don't look good. I'm going to take your blood pressure." Next thing you know, my dad's being rushed into the ER. So both my parents are in the hospital at the same time. Yay, us. 2 parents in the hospital at the same time. At least they're in the same hospital. He's not real happy to be there. He didn't want to be admitted, but his blood pressure was super low. They think he may have taken too much blood pressure medication, like forgot that he already took one and then took another one, because his blood pressure was 50/20, which is not good. He also has some kind of infection. So, yeah, prayers for my dad and my mom. My mom's doing okay. They caught a couple of big seizures on the monitor, so they have some more answers now, and I don't know what they are yet, but we're waiting to hear. I know, thank God for good nurses. You know, good nurses can save your life, and that nurse did save his life because nobody else noticed, and she did. And next thing you know, she had him in a wheelchair and was running him to the ER, like at a literal sprint. So that woman I should send her some flowers. She's a very good nurse who saved his life. And I still don't really know what happened, other than I think he took too much of his medicine because my mom wasn't at home making sure that he takes all the right pills, So, yeah, it's not good. It's not good, but he's okay. I talked to him and they got him fixed up, and I saw him yesterday on FaceTime and we chatted for a little bit and he looked better. Yeah, we need to nominate her for a Daisy Award. Squid, that's actually a good idea. I'm going to actually call the hospital and find out where I can submit a letter for her. I'm going to write her a nice letter and give it to her manager, because what a wonderful thing. She didn't have to take time out. He wasn't her patient, but awesome. Speaking of awesome stories, while we're waiting for court to get started, I saw this on Twitter yesterday, and it made me think, there are really good people out there. I know that we focus a lot on the bad things that are happening, but there are some really good people out there, including the nurse that helped my dad. And then this girl, I want you to see this video. I love this girl so much. What a sweetheart she is.
I just want to start this off by saying, if you see something, say something. I did an Instacart order yesterday, and I'm a little emotional right now, but I did an Instacart order yesterday, and it was a daughter ordering for her older dad that couldn't shop for himself. I do the order. I'm going the extra mile for this customer, like I always do, but for whatever reason this time I was going even farther and checking the back and everything. And I take the order, go to drop it off, and she's like, just go ahead and put it on the porch and he'll get it. I was like, all right, cool. That's what I normally do. I get there and something was telling me, no, you got to help this man out. And he came out and I was like, okay, well, let me help you. And I got the groceries, and you're not supposed to go inside someone's house. But I used my judgment and I brought the groceries inside, and put them down wherever he wanted me to put them. You're not supposed to, but I did. And you're just supposed to take a picture and leave. And I could not just leave. I go to message the lady because I was very concerned for her dad, that he just looked sick and I didn't know what to do. So I messaged her and I said, if I say that the order is complete, I won't be able to message you, and I want to tell you this. And I said, it's very unprofessional of me to say something, and I wasn't going to. I never talk. I always just put the groceries down and leave. This time, for whatever in my head was like, you gotta say something. You gotta say something, Jess. So I said, he's not doing good. He's sick. There's a propane tank in there. I was in there maybe 5 feet and I got dizzy. And I said, there's gotta be a leak. And I was like, he might not be doing good because of this leak. And I just didn't know what else to say. And she was like, all right, I'll have my son come out. She changed her tip from $14 to $100, which I'm grateful for, but I'm crying because of what she commented this morning. And I'll show you. Commented, thank you so much. Once my son went to check on my dad, it turned out it definitely was leaking. You definitely saved my dad and my younger son's life. So that being said, I'm just an Instacart worker, but if you see something, say something, and I did, and I'm so happy I did, and I'm so happy that he can live a better life.
I want to hug this woman. First of all, you're not just an Instacart worker. You're a gem of a human being, and I wish I could give her a hug and tell her you're meaningful. You are amazing. You changed their lives, and you're not just anything. This woman, I love her. I just adore her. I think she's just precious, and she has beautiful freckles. Don't you love freckles? I just think that was such a great story, and I wish I could just tell her, you're not just anything. You're amazing. You're amazing. You're a reflection of everything that we should all be. Love your neighbor as yourself, period. And I just love her, and I think she's fantastic, and I hope she realizes that she's a hero. And I just love her. I just loved that so much. And I've had people like that, do things like that for my parents, like this nurse who just saw that he was not doing well. And next thing you know, she's saving his life. So it's amazing. What is this? Oops, wrong button. First super chat of the day. Julie O says, picture this, Megan, 2.5 years in jail with no hair products and probably only Pert Plus 2-in-1. And you only get a black comb from school pick day. I could do something with that, though. I could do something with that. Look, there's no reason why she can't use that black comb to pull those straggly pieces of hair back from her face. She could have put it all back into a ponytail. We have got to get those straggly pieces off of Jennifer Crumbley's face. It's too late now, though. Hopefully the jury will understand that she's been in prison this entire time. Yeah, how does Lori Vallow come to court with her hair curled? I really don't think that Jennifer Crumbley is doing it on purpose, you guys. I think that she's destroyed as a person. I think that she's not capable of caring about any of that. But her attorney should be doing that for her, should be helping her with that. Boosh McFadden, why was she crying? Because it was an emotional thing for her. She was worried that poor man was going to die. And some people are more sensitive than others. Quit ragging on her for being an emotional person. This judge said, be here at 8:30. And everybody's there, and where is she? Where's the judge? You know what, Judge? You got me out of bed this morning. You said 8:30, and we're all still sitting here like a bunch of, circus clowns waiting for you to come and take the bench. It's 8:56, ma'am. The hell? I really don't like that. Why would the judge tell everybody to be there at 8:30 and then keep everybody waiting around? I'm so freaking bored and tired. Yeah, I was on time. Why can't she be on time? I didn't watch Peter Tragos's recap, and I should have. I heard it was good. Yeah, I could have slept a whole extra half hour. This blows. Maybe I'll recline my chair and take a nap. You want to hear me snore? Oh, Lord. All right. Well, let's do an analysis of all the hair in the courtroom at the moment. Let's see. Oh, we've got a couple of shaved heads. We can skip over those. The blonde lady on the prosecution table, she looks like she could use a deep conditioning treatment. She's got those bleached highlights that are not doing so well for her on the top. That's where it gets the most dry, is up at the top at the crown. So you got to keep the deep conditioning going when you're using highlights and bleach. She could use a treatment. She also could use a hairbrush. Her hair looks like it hasn't been brushed either. All right, here comes Jennifer. All right, her hair is different today. It's looking a little better. Are those straggly pieces still in front of her face, though? Yesterday, she was wearing what looked like I don't know. Everybody said it looked like a bathrobe. It was a sweater, like a cardigan. Today, she's wearing a suit, which is probably, no, they didn't get that. She didn't get the pieces out of her face. See, I would have put those other pieces back up, too. Those shackles are so useless. They just do that to humiliate her. And it's very upsetting. All right, we're getting a close-up of Smith's hair today. She still has like a bird's nest at the top left there in the back. You know, making the back of your hair look good is really hard. It is really hard. So maybe we're just too hard on these attorneys because, hell, I don't know what the back of my hair looks like. I look at it once. I don't look at it for the rest of the day, so it probably looks terrible. I mean, who knows? The only people who know are people standing behind me. It's hard to see the back of your head. Why the shackles? They do it for everybody, but I think it should only be done for violent criminals. Because I don't understand how you can have somebody who's never been charged with a violent crime and you're shackling them. The shackles should be purposeful. They should be for a purpose. And that is to keep someone who's a violent danger from hurting anyone. But Jennifer Crumbley's never hurt anybody violently. Finally, Judge Late and Gay, this one. A whole half hour late. The jury never sees her in the shackles. They don't bring the jury until after.
279-990
Finally.
Good morning. Karen McDonald on behalf of the people.
Thank you, Mark Hughes on behalf of the people.
Governor David Williams on behalf of the people.
And good morning, Shannon Smith on behalf of Jennifer Crumbley.
You may be seated, as seems to be the theme. Issues came up at the end of the day yesterday at the close of the defendant's direct examination, at which point I invited both sides to submit anything that needed to be dealt with.
Speak up, Judge.
That you wanted me to consider for purposes of going forward with the cross-examination, correct?
Yes, Judge.
Okay, and so in the early morning hours, as is our habit in this case, I received a filing by the people. So I want to let the people make a record of that.
Thank you, Your Honor.
You can move the podium if you like.
That's right, Judge. Thank you. Judge, as the court is aware, the issue of flight has been important from the start of this case. It was part of the bond motion allegation has always been by the prosecution that the defendant was fleeing from prosecution, in contrast to the public statements by her attorney that she was not returning, that she would not turn herself in. We recognize that that made her attorney possibly a witness in her defense regarding flight. We pointed that out. We pointed out repeatedly. We asked the court to include that as part of the waiver. She consistently waived her right to have her attorney act as a witness on her behalf. Yesterday, she testified that essentially her defense to flight is, I was in touch with my attorney. I was taking the advice that we were going to turn ourselves in, and I was just waiting on direction from you. Speaking about Ms. Smith. Judge, under the case law in Michigan, in particular, I think how is helpful, she's waived the privilege. She cannot use that as a sword to present in her case as a
Son of
defense
a
to
gun.
flight, and then say, you can't see those messages. We're entitled to see if those messages are in fact consistent with her attorney's public statements and her testimony.
Yeah, they want her.
What we've done is
They want her
have
attorney's
Justin
messages.
Have another member of his team pull out those messages, put them in a
Unbelievable.
sealed envelope, and bring them to court today. And we'd like they're short, Judge. I think there's a total of 23 messages. And what we'd like the court to do is review those and determine whether the court believes that they are relevant to the issue of flight and whether the defendants were turning themselves in.
Okay, well, there's been a number of phones with a number of extractions. I think I like Mr. Williams to go even further back because there was this people's notice about assertion of privilege, correct?
Yes, Your Honor.
Okay, so can you describe that for the record?
Judge, so what happened was we had a total of
This was before the trial.
Yes, Your Honor.
Okay.
I raised it with the court on January 12th, I believe. It might have been the evening of the 11th when, frankly, I personally was reviewing files in preparation for trial. What we have is 6 cell phones. They were all extracted, downloaded into a program called Cellbrite so that we could review the evidence on those phones.
Okay, four of those were in the possession of the defendants and one was the shooters. Is
Yes,
that correct?
Judge, what we have is we have their 2 phones that were seized from them right after the shooting.
Correct.
And they were found with 4 phones. That's 6. And there's also the shooter's phone.
Okay.
So the total of 7, 6 associated with the defendant. We were and so in reviewing those, when we determined that there were potentially communications between counsel and the defendant back at the beginning of the case, those were stripped out by the sheriff's office. So we would not see those, would not have access to them, would not come across them.
Okay.
When I was reviewing photos that day, I was looking for a particular photo. I came across what appeared to be a screenshot of a message. And even from the screenshot, there were a couple of words that stood out to me. It was clearly relevant. I could not see who it was to and from. I opened it. As soon as I did, I could see Shannon Marielle at the top, and I closed it.
Okay.
That was inadvertent. But because I saw the timestamp on that.
Yeah, sure it was.
It was clear to me it was potential.
Sure.
So I brought that to the court's attention, to the defense's attention, and said, do they want to assert the privilege? And they said, yes, you can't see that. We did no further investigation. And so now the defendant has testified and she has waived the privilege. She's now relying on her attorney's advice and testifying that that's the basis for her claim that she did not flee.
Right.
I understand.
Yeah.
Your Honor, I have not seen the prosecution has uncovered.
Well, they haven't seen it either.
Okay. I don't even remember, obviously, the texts there were. I have no memory of this. But what I will say is when I had my client on the stand and I was asking her what her intentions were, I was asking her what her plan was, and I thought her testimony was going to be, I planned to go to Novi on this day at this time. I didn't plan for her to say, my attorney told me to do this. That was the plan we had. That was what I was in touch with Ms. McDonald about, but she wouldn't call me back.
Okay, I don't know why you keep telling us that.
Well, I'm just saying, I didn't mean to open the door, so I would ask.
Oh,
I didn't mean
geez.
for my client to open the door. I would ask the jury just be instructed that whatever was discussed with the attorney be struck from the record and move forward is.
Wait a minute, struck from the record, what she already testified to?
Yeah,
That is not happening.
okay, then I object, Your Honor. I don't think that my client open the door to all privilege being waived. And to be honest, I don't even know what they're talking about. So until everybody sees it,
Okay, well,
Oh, Lord.
everybody to see it?
no, I don't. I'm objecting to
Oh,
anyone
God.
waiving it.
Everybody's seeing it. Though he's specifically saying that there are potential texts between you and your client. So an investigator may have extracted this information, or presumably the prosecution has not seen it. But if it's a communication between you and your client, presumably you have seen it at one time.
I don't know that it's between me and my client. It says Shannon Marielle on there. I don't know which of the phone numbers they saved. I don't know.
Okay,
I
don't
have
know
no text on my phone, so I don't know. I went through to look through my own phone. I don't have anything. I don't know what they're talking about. Even the screenshot he sent, I don't know where that came from.
Well, Judge, then
Do you know
obviously,
which phone it's from?
yes, it's from the defendant's burner phone. And we can tell that because of the context of the other messages on the phone.
Okay, so it's her phone.
Her phone, but I don't know who. At that time, Marielle and I were both in touch with Mrs. Crumbley, and
It doesn't matter who it is.
yeah. I'm just saying I don't know if Marielle sent texts. I don't know who the phone number is that's called Shannon Marielle.
Okay, but I guess the thing we're grappling with here is whether or not your client, obviously the privilege belongs to her. The privilege is like the theme of this trial, right? So the privilege belonged to her. So really the question is whether or not she waived the privilege. I would have to say that this would be a dangerous precedent. To be honest, Mr. Williams, when we ended the day, as we do every day with upheaval, I assumed that your concerns were the fact that she testified that she went to bed at 11 o'clock, took 4 Xanax, and then was later asked when the police came into the room, this is an exact quote, were you aware there was anything going on? No, we were not. And that would have been at 1:30 in the morning for the body cam. So I thought that's what your concerns were directed at.
So, Judge, I think the testimony was there were a swarm of officers on scene by 11:16 a.m. And then back if the
Was there? Okay.
PM, I'm sorry. Yeah.
Okay, we were, I'm put in a difficult position because some of these transcripts are not immediately available, but
Just deny this stupid request.
on the verge of resigning based on my requests of them. Whole testimony of David Shaw. Didn't David Shaw say he was there before midnight, got the call at 11:30, was on call, lives 20 to 25 minutes away, was at the building an hour and a half to 2 hours before entered where the defendant was at 1:33.
So right,
So
Kimmy.
Mr. Kirtley testified that he called 911. That was at 10:43 p.m. That there were officers on the scene within 5 to 10 minutes. And then as soon as they found the license plate, there were swarms of officers. That is what happened. I'm not sure about the other testimony.
What time was the first officer on the scene?
It was before 11.
It was someone before Mr. Shaw.
Yes.
Oh, okay, so I told the wrong officer. What's his name? Kirkley?
May I just, so Corporal Shaw was a member of the Detroit SWAT team. So he
Oh,
was
he was a
recalled.
SWAT, okay.
That's right, Judge. So he was recalled once officers were already on scene instead of a perimeter.
Okay.
The testimony that came in through Mr. Kirkley, the individual who called 911, was that he called 911 at 10:43. Then we watched the video where he walked into the building. At the end of the video, you see the 2 Detroit police officers pulling up on scene shortly before 11 o'clock. His testimony was that he met with them and then there were swarms and swarms of officers.
Okay.
And so, Judge, it's relevant just in the fact that the defendant is texting anyone at 11:16 p.m., but it's especially relevant that she's commenting on her status and now saying the reason I didn't give myself up was because my attorney told me not to.
Well, I already agreed with Mr. Keast last night that he would, I guess the thing is you can't use your shield as a sword. So I already agreed with Mr. Keast yesterday that he could ask the defendant, you said that you were asleep by 11 o'clock. isn't it true that you were texting your lawyer as of 11/16? So that's already a ruling of this court.
That's the big
question
lie
now
that
is
they
whether
caught. That's the
or
big
not
thing.
I'm going to go farther than that, based on the privilege and
Oh my God.
dangerous precedent. But
Judge, I think the case law is clear. Defendant didn't have to testify and she did not have to rely on her attorney.
Oh, here we
I also
go.
think Ms. Smith's argument that she was just going to say she was going to Novi, well, she would not have known that on her own. That was clearly information she got from her attorney. So what she wants to say is, Judge, I didn't know what to do. I was relying on my attorney. I wasn't fleeing. And the question is that in fact what she had been told, or was she doing that on her own? We'll only know that if the court reviews these messages in camera. It doesn't mean they're admissible. What it means is the court will determine if they're possibly relevant, let us see them, and then of course we'd have a discussion or a ruling on whether or not
She
they're
should not
actually
allow
admissible.
this at all. Say no. She already said no.
okay, what did you say? You know, I've seen some of the extractions, piles of extractions from here. So I guess I don't know what you'd be referring to. I don't know that I'm willing to do that. That sets a dangerous precedent.
Yeah, you should say no.
I don't think it does to do it in camera.
Shut
Privileges can be waived.
your
And
mouth.
if the defendant
Privileges
has-
can be waived. It's a theme of the trial, but the problem is then I'm making a determination about what's in and what's out in the middle of the trial, right? And
No.
and potentially invading her privileged communication with her lawyer.
Judge, I'm not asking the court to make a call whether it's in or it's out. I'm asking the court to simply look at it and see if it goes to the issue of flight, then allow us to see it, and then there would obviously be an argument of whether it's relevant and admissible.
So if you're asking me to review it and see if it goes to the issue of flight.
Yes, Your Honor.
Okay, because that's another thing that I was thinking about. What if she makes some admissions to her lawyer about this case?
Captions are on.
Those
They're just
then,
not working
Judge,
right
just
now.
about the case, we would not be entitled to see those.
Okay. All right, what else, Ms. Smith? What else?
I have nothing further, Your Honor. My client does not waive privilege. That's the position she's taking. So whatever the court says.
The question is whether she waived it on the stand. What were her exact words?
Judge, she said, the question was, Ms. Smith, all right, so what, okay, so you know you're charged, which by the way, Judge, they knew they were charged. They suspected they were being charged on December 1st. There are text messages not to their attorney on December 3rd at 11:30 a.m. saying we have been charged. So she knew she'd been charged. Ms. Smith said, so you know you're charged and you know they want you. What was your plan at that point? Well, I was in touch with my attorney, Ms. Smith, me, you, answer, Ms. Crumbley, you. And I was taking your advice that we're going to turn ourselves in. And then further on, Ms. Smith, okay, ultimately on the night of the 3rd, were you aware on Friday afternoon that you could go into court that afternoon? What was your awareness? Defendant, I was not aware that we could go into court that afternoon. I was just waiting on direction from you.
All right, I'm going to take a brief recess.
All right. I can't believe she's considering this. This is absurd. This is absurd.
You may be seated.
The judge knows that this is a dangerous precedent. The judge should not be allowing privileged information, the prosecution, to use text messages between Jennifer and her lawyer. That's absurd. This is disgusting. What is the deal with prosecutors who just are determined to step all over the rights of defendants? She has the right to privileged communication with her attorney. I don't think she waived that right by saying she was waiting for a message from her attorney, and now they want to go in and see, oh, well, were you? What were the messages actually? I mean, why are they putting her back in chains? Where are they taking her? What? I don't understand. Does she have to leave the courtroom every time the judge does? What is happening here? Well, maybe she has to go to the bathroom or something. Oh my God. My mic is always hot, you guys. There's nothing I can do about it. I have it set low, so it's probably because the court audio is so low. But I have my microphone turned down as far as I possibly can. So don't complain. Stop complaining. I'm in no mood for complaining from the chat. I got up at the ass crack of dawn. I did not get my extra half hour of beauty sleep, and it shows, which is why the camera is not on. And I'm still in my jammies. So I can't believe the judge is actually going to consider this. Her instinct is to say no, and she should just go with it.
Denied. Sit down.
You know? This is silly. All right, while we are waiting for the judge to make up her mind on whether she's going to violate the rights of the defendant, let's go to YouTube and Peter Tragos did a let's see. He did a recap about the attorney that I kind of wanted to watch. Yeah, not the reaction, but hold on. It wasn't super long. I think it was like 9 minutes. I'm going to see if we can find it. It was about Jennifer Crumbley's attorney. Where is it? That's weird. Did he delete it? Hold on. Shoot. I'm not seeing it. It was titled something like, "Is her attorney as bad as we think she is?" Or as bad as everybody thinks she is. And I'm not seeing it now on his page. That's strange. There's Delphi, Adelson, Koberger, Boone, Daybell. The heck? Well, that's annoying. I wanted to watch that. And now I don't see it. It couldn't have been a month ago. It was like in the last couple days. So where the heck is it? Was it live? Oh, it could have been live. Hold on, let me check the live. Ah, yeah, there it is. It was alive. Okay, hold on. Ooh, it is. It's an entire hour. Okay, well, we're not going to watch the whole thing, but maybe we could watch some of it.
Okay, so we're going to roll with what we got. So many questions about the defense attorney. Also, questions about
I'm going to take the twat waffle down.
And the judge. And as I've watched this trial, full days here and there, sometimes clips, but it really is a different kind of style than a lot of the styles that we have watched on a lot of other trials. So I do think that's important to talk through, answer questions as to why that might be. And I know a lot of people have really strong feelings on this. Nobody is going to say these victims weren't victimized or don't matter or, this isn't justice and things like that. Nothing that happens is going to make these victims feel better. We know that. Unfortunately, we've covered other cases with similar facts and similar situations with the Parkland trial, and there's just no easy way to discuss it. But we're going to go through a lot of what the defense attorney said, how they act throughout this case. But I do think that keeping the victims in mind with some of these actions is important, because it's one thing to zealously represent your client, to fight hard for your client, to do everything you can for your client, and to have a certain style. But you do have to always remember real victims going through impossible situations. And I do think she has commented on that and tried to be as sensitive to them as she possibly can. So I think that's important as well. So we're going to jump right into this. We're going to start with kind of going through some of the antics of the attorneys and the judge, but we're also going to talk about factually what's going on, what's being proven. And we're going to spend a lot of time on Jennifer Crumbley, the defendant's testimony that happened today, summarizing it. I'm going to weave in, now that we have the benefit of her testimony, at least direct examination, as we talk about some of the evidence the prosecution has presented, how she answers for it, and how this is basically going to come down to the jury weighing the evidence, who's more credible if the prosecution said something happened or was said, and Jennifer Crumbley said something happened or was said, and they are at odds. How does the jury determine who is more credible, number one? And number two, the big question here, what rises to the level of criminal activity, criminal negligence, gross negligence to the level that it should be a crime? There's no doubt in my mind that there was negligence here. They could have done more. They didn't do more. Bad things happened. They didn't prevent it. They were at least some of the people involved that could have protected and prevented this from happening. And civilly speaking, it is a slam dunk, as easy of a civil case as you could possibly have, with the burden of proof being more likely than not, more probable than not, the greater weight of the evidence, 50.1%. However you want to describe that burden, to me, that is what we're dealing with and what we're looking at in a civil case. And this is very different. This is a criminal case. So we have to.
Yeah, that's the big problem the prosecution has. They could have brought this civilly real easily with the lower burden of proof, but they're trying to go at it criminally, and I don't think it should work out for them.
Keep that in mind as we go through the trial, and the proof is beyond a reasonable doubt, and the punishment is prison. Like the jury's going to know that. They understand. So that's really important as we go through it to understand, are they culpable? Absolutely.
And how much time have they already been in prison now? They've been in prison for ever since this happened. They're both in prison. Time served. Time served.
Absolutely civilly. Are they culpable criminally? That's something that's going to be a big decision for this jury to determine. And I think it comes down to the way the prosecution presents the case, what they say they have to prove, and do they prove it?
Yeah, and if this case had not involved a gun, we wouldn't be here. If Ethan Crumbley had knifed students, if he had taken a knife to school, we wouldn't be here. If he had made a bomb, we wouldn't be here. This is all political garbage because it was a gun. This is what the state does before they want to pass laws to limit your gun rights some more.
And in opposition to that, the way the defense attorney argues the case, what she presents. And we're going to go back to opening statements and kind of discuss what they said there. I'm not going to play clips of opening statements, but it is important to realize what each side said they were going to prove in opening. And the state said that they were going to prove that they were grossly negligent, that they basically didn't care about their kid. They were too busy for their kid. They saw all the warning signs of depression and mental instability and mental health problems, and they did nothing about it. They refused to take him home from school. That's the story we've been told from the jump. They were there. They called a parent-teacher conference because of some drawings that Ethan Crumbley, the shooter in this case, had drawn. And the parents refused. They were too busy. They had to get back to work. They didn't want to deal with it. That is basically what we were told happened. Now, Jennifer Crumbley has testified to something very different than that, and we'll get there. But the prosecution, that's what they said. And the defense argued that these were loving parents. They had a great relationship with their kid. They did everything for them. Ethan was a pretty normal kid. There were no warning signs. There were no major issues. And when they went to the school to meet with them about these pictures, the school said it wasn't that big of a concern. You don't need to take him home. So this family, who the dad, I guess, struggled to keep work, but he was driving for DoorDash, and mom had to get back to work, dad had to get back to work, and that's what happened. And the school thought nothing of it until 2 hours later when the worst imaginable thing happened. Now, the allegations from the state about the Crumbley parents buying Ethan a gun, going to the shooting range with him, teaching him how to use it, not protecting it properly, providing ammunition, all while knowing the mental health issues, the depression, the instability, the violence that he had exhibited in the past. So that's basically how the stage was set. We also know that Jennifer Crumbley's lawyer has tried to keep a lot of the pictures, videos, journals, lots of things out of this case that are just horrific and so prejudicial. And the judge has kept a lot of that out. Now we'll talk about opening doors and things like that. And we're going to work our way through this methodically. Some of the video clips will be, 1.5 speed, which is as my style. Some of them will not. But I want to show as many clips. I've got like 9, 10 different clips queued up. Some of them, multiple parts we're going to play. There's no way I'm going to hit everything from a 6 or 7 day trial. But I do want to answer a lot of your questions as we go too. So if I don't play a clip, but you have a question, we can still answer that question most likely. Trick said she loves Jennifer Crumbley's lawyer. So I've seen feelings on both sides. Michael RN is a member again or upgraded. I can't tell from this, but I know you've been a member in the past. Kirsty, welcome. Miriam, welcome. Starting to sit and had most take on how the spring the question was going to go and what this was going to be like.
Your Honor, this court, upon the defense's request, instructed the prosecutors not to show emotion. You instructed the prosecutors to tell our witnesses not to show emotion. And you instructed us to let our victims know. I understand the ruling, Your Honor. I do. You're concerned about influence of the jury. I take no issue with it, but it was a difficult thing. It's difficult, and we're doing it. And then to have not just the defendant, her lawyer, sit there sobbing. So I just want to finish, Your Honor. I just want to finish. I think if that is the instruction, we are trying really hard to respect the court's instruction because I understand the reason for it.
Okay, I didn't tell people not to show emotion.
So, and just right off the bat, okay, the background of this is the defense attorney, they accuse the defense attorney of sobbing while they're playing certain videos or making certain arguments or showing certain pictures, things like that. The defendant crying. They don't want them to try and have the jury agree that they feel bad for them or garner some sympathy. Okay. The judge is a little annoyed because it makes her sound cold to say nobody can show emotion because it's very emotional. It's very difficult. We're going to hear her talk about that. Okay. But the prosecution brings it up to, I think, try to affect the future actions of this defense attorney because this was really early on. And she doesn't want her sitting there crying throughout the whole trial. So the first thing I'm going to mention, as Mo says, she feels the defense attorney is unprofessional in front of the jury. I remember people with Mark Eiglarsh. Somebody said she reminds me of a female Mark Eiglarsh who was very animated, did things. He came on the channel and explained how he did things on purpose to bring attention to this. And he really wanted to raise his voice here or go real low here or be emotional about this or not emotional about that. Lawyers have certain styles and how they act when they try cases. And I also think that I'm going to talk a little bit about the unorganization, or at least the appearance of that with the defense attorney in this case, because a lot of people ask me about that as well. And I want to have that, as a juxtaposition to Greg Anderson, the plaintiff's attorney in the Take Care of Maya case, who was also a little unorganized and discombobulated and fumbled on this or that.
Court's coming back. Court's coming back. Hold on. I didn't know that she was sitting at the table sobbing. That's kind of funny. And they were complaining about it. Julie, thanks for the super chat, says the dean at school said the backpack was heavy when teacher handed him the bag, but nothing was checked and he did not mention to parents either the day of pew pew, but okay, let's jail the parents. Yep. Yeah, I don't get it. Oh, well, the judge is still not back. Big surprise. All right, we'll keep on going with Peter until the judge comes back.
Talked about it back then, and he said he does it on purpose. His wife, I think, in an interview said he does it on purpose. Sometimes it makes the jury like you, be like, oh, this lawyer's not some, buttoned up professional. He's just one of us. And, it's not easy for him to keep it all straight, just like it's not easy for us to keep it all straight. And it's endearing. There's some of that with this attorney. Now, most of the comments to me, and I'll just say what people are tagging me in, is mostly negative about this attorney. And it comes down to a lot of the things we praised Mark Eiglarsh or Greg Anderson on that they're condemning her for. And sometimes it's because if you hate the client, you hate the attorney. So I get that. Other times it can be very different, right? You can be unorganized in a way that makes it rise to a level that is unprofessional and inappropriate, which I don't think Greg Anderson or Mark Eiglarsh ever did. I thought they both did a really good job in their trial. And so that's going to be the difference when we look at this attorney and how sometimes I think she did cross lines. And I think it's not lost on me to be able to watch this trial and see over and over again how she's doing certain things to show emotion. Because people have asked, have you ever cried during this or cried during that? No, I don't. I've never cried in a trial, but getting choked up when you see certain things or hear about what your client's been through is normal for attorneys. I don't know if she was sobbing or not, but the prosecutors have definitely said she was sobbing. That's where it does kind of cross the line in trying to garner sympathy from a jury where that's not something that can come into play. And we'll talk about some other things she did and said that potentially are crossing the line. So let's continue to listen to this sparring. And the judge does sometimes feel like she's working for the attorneys or the attorneys are telling her what to do and not the other way around. But I do think she has a calm demeanor. I don't think she gets flustered. And I do appreciate the way that she is making calls and trying to keep people in line. But one of the things that's blowing my mind is the speaking objections throughout this trial, which we'll talk about as we listen to some of these clips.
But there have been times in this courtroom during trials when people will show facial expressions or things like that or make comments. I understand this is a very emotional situation for everyone here, right? If someone was audibly sobbing.
Okay, here she comes. The judge is coming back now.
Unhung hero. When is the school going to be held accountable? Never. They got immunity, I think. That's what I heard.
Calling people versus Jennifer Crumbley, case number 222799990, Effie.
Good morning again. I want to indicate that I've done some research on this matter. I think that the privilege that the defendant holds is her absolute privilege and protects her constitutional rights. So I think this is a very serious issue, and reviewing these records could set a very dangerous precedent. However, I also note that the prosecution is requesting that the review be for a limited purpose on the issue of flight.
Oh my God, she's going to do it.
Else.
She's going to do it.
That, and this is how indicates that a waiver is to be predicated not only when the conduct indicates a plain intention to abandon the privilege, but also when the conduct, though not evincing that intention, places the claimant in such a position with reference to the evidence that will be unfair and inconsistent to permit the retention of the privilege. It's not to be both a sword and a shield. And that's really what I'm grappling with. The claimant here will be the prosecutor. And I think if I didn't review these texts, that it could be potentially unfair to the claimant that being the prosecutor on this limited issue.
Ridiculous.
I can't tell you how reluctant and how much I do not want to do this.
Then don't do it.
Because I think that the privilege is so important.
Don't do it.
I'm
You're the judge.
told that this is going to be a limited review. The
Oh my
hearing's been here
God.
Since 8:30, and they've been here for 2 weeks, and I'm very conscious of that. So I am going to review the text for the purpose of determining whether or not there is reference in any way to flight.
Your Honor, the text, as you said, my client has the privilege over. I'm asking that my client and I be able to also review whatever's being submitted in camera.
Oh, okay, well, here's the difficulty I have. If you go through my phone right now, you can find texts back to when the earth cooled. It's really hard to believe that you don't have texts from 2021 between you and your client.
Your Honor, I don't. After a year, all of my texts delete it automatically. And I have it set to that because otherwise I get so many. I use my phone for personal and business. So
Okay,
they
what's
delete after a
your
year.
position on her receiving an
Well-
unredacted copy of these texts?
The other thing is, I don't know if those were even sent to my phone. It says Shannon Marielle. I don't know whose phone it went to.
Okay, here's the problem. Her testimony is, I was waiting for instructions from you.
Okay,
She
but
said
at
you.
the time, both of us were representing Mrs. Crumbley. So
Judge, if I may, if they're not to counsel, then they're definitely not privileged. So that's one of the reasons I have a screenshot.
Oh my
one screenshot
God.
I saw. If that's a fake for some other person, a
Ugh.
friend, girlfriend, whatever it is, then absolutely it's not privileged.
well, at that
If
time,
it
I
is
know
with
was
counsel,
aware. I don't
it
know.
needs to be reviewed. One other issue, Judge, this is a very narrow time frame. This is after noon on December 3rd, up to the point when they're taken into custody at 1:30 a.m. on December 4th. I haven't seen these, but I know it's a total of 23 messages, and I know how thick this is. So this is a very, very limited number of messages.
What is your position on Ms. Smith receiving an unredacted copy?
I have no problem with that. I think, Judge, she probably got it in the Celebrate reports before they were stripped out for
Oh,
us,
yeah.
but I don't know for sure. I have no problem with her getting a
So
copy when the court.
that's a good point. Even though they extracted any privileged communication between the defendants and their counsel from these texts, you and Ms. Lehman did receive an extraction that included attorney-client communication. So I believe you are in receipt of these and have been for 2 years.
I don't believe that's true. I've never seen these, but I don't believe that's true. I believe I received the Celebrate data that the prosecution has been using throughout this case. I don't believe I received a copy that included my communications. I believe they were stripped out before I got them.
Judge, it is possible that they were stripped out before they were brought. I want to be careful that I don't misrepresent. I do know that the screenshot would have been in there because that's what we saw in our version.
Okay, so at a minimum, the screenshot
Yes.
would have been provided. Okay, to me, the screenshot is now on the table for sure. Because I guess I should say that because of what happened the week before the trial, they're aware that the prosecution is aware of that communication. So at a minimum, the 2-word text is coming in. Okay, so I'm gonna have a copy made from Ms. Smith of these texts. You don't have any objection?
I don't, Judge.
All right, and I'm gonna review them and determine whether or not any of those texts are relevant on the issue of flight alone.
Thank you, Judge. May I approach your clerk?
Yes, all right. Okay, and if you're correct that they're brief, I will be brief. The jury's waiting for us, okay?
All right.
All right. Here, she's going to go and review privileged information. What?
Can she stay?
Basically, she can.
Captain's going to take it out.
Okay.
You may be seated.
All right. We will go back over to Peter.
I would hope that they exit. And as you said, you know the reason for it. I didn't tell anybody not to show emotion. I guess some emotion is involuntary. So I guess I'm asking what you're asking.
I think it should apply to both sides.
Judge, first of all, I was not sobbing, and this is horrific. This is horrific.
I've never seen this before.
It's horrific. That's why we asked the court not to play it. This is horrific. I don't know how the prosecutor.
But-
She's watched it 100 times. With these witnesses, it's horrific. I don't know. I don't have this video. I have to go to their office to watch it. No, I haven't, because it's not necessary. It's not relevant to my client's case. We've already litigated.
First off, she said things like that multiple times that she like didn't view some evidence because it's not relevant to her client's case. I'm sorry. If you're going to take this job, okay, it's horrific. It's very difficult. It's not for everybody. I think we've been over that, right? Being a criminal defense attorney is not for everybody. But you have to look at what's going to be presented. Even if you think, how do you know it's not relevant to your client's case? First off, if you've never seen it, number one. Number two, how, hold on one second. Number two, I realize it's difficult to watch and nobody wants to watch it, but you should watch it if it's going to be played in your client's case. So I did think that was a little bit weird personally.
Maybe she didn't think it was going to
We're
be
doing our
played.
best. We were not sobbing or making a scene. In any way, all my eye makeup's still on. I checked my camera.
I'm not having.
I need to run to the bathroom. I need a break.
Okay, we're going to break this.
I'm sorry.
Walls are cardboard in here, so.
I'm sorry.
Okay. All right.
I'll just tell you, me personally, I would be very frustrated with her saying things like, I don't think she's a bad lawyer, by the way. I know a lot of people saying she's in over her head. She sucks. She's the worst lawyer. I think she's making some pretty decent points. I think her opening statement was better than the state's opening statement. When I first watched
agree
that,
with
before
that.
all the other shenanigans happened, I was like, some decent arguments there. I think she's going to do a pretty good job. And I think she's made some certain points, and I'll wait to talk about Jennifer Crumbley's testimony until we get there. But I would not be able to stand her saying stuff like, all my eye makeup is on. I checked my camera. I need a break. As if she's going to take a break, whether or not the judge says she can. Sometimes that can be very frustrating. And I think the prosecutors are getting very frustrated. And there's been some sparring in front of the jury. I don't know how that's going to go against an attorney like this. And I've gone against some attorneys like this. Most of them are male that are bombastic. Somebody used that word. There's over the top, hyperbolic, a little, it's like passionate for no reason. Not that she's passionate for no reason. And the way you deal with them is professionalism, understanding, not raising your voice, not speaking over her, letting her say her piece or him say his piece, and then making sure the record is clear. And very calmly objecting every time they do the things that they're doing that are frustrating. There's more stuff coming later that I'm going to use as examples, but I kind of do want to set the stage here. You're welcome, Izzy. Yeah, this is really interesting. It was just, there was so much going on that it was hard for me to actually get to this trial.
Everyone here is human, right? Everyone here is human. I understand that. I'm striving really hard to both sides of your trial. And if people will at least try to protect themselves, to exit if it's excruciating, which I know it is. I'm not a robot. I'm trying to keep myself from sobbing. I'll do it at 6 o'clock tonight. Okay.
I appreciate that, Your Honor. That's all I'm asking.
Okay.
Your Honor, we don't have the option to leave the courtroom. We're trying our best. We're trying. I promise you, we're trying our best. Thank you.
She has put us here, right? And we're going to probably have a conversation. How long do you think the next witness is? I'm bringing lunch in.
Next witnesses can be back. I anticipate very quick question.
All right. So that's all for that clip. And then I'll run through some of the evidence. They presented school surveillance videos. That's some of the stuff that's difficult to watch. That included a moment-by-moment timeline of where the shooter went. They talk about how the parents came because there was a horrific drawing, help me, blood everywhere. The meeting was only 12 minutes. Again, they definitely present the evidence in a way that the meeting was only 12 minutes because the parents didn't have the time to talk to the school about what was going on with Ethan, and they wanted to get out of there, and the school really wanted them to take Ethan, but they didn't want, hold on a second. But they didn't want to take him. They begged the parents to take him. They wouldn't take it. They just left. And they abruptly ended the meeting and were kind of rude. That's how the state presented it. Okay. And then not 2 hours later, again, the rampage started. They talk about texts and call logs and photos and journals. Actually, not all the journal, but different things that he drew and things that would definitely let them know that Ethan's mental state was deteriorating. His only friend left a little while before this happened. They should have known. All the signs were in front of them, but instead they're buying him a gun, taking him to the shooting range, showing him where everything is, not protecting the gun appropriately, and therefore it's their fault. On cross, again, Ms. Smith, the defense attorney, I'm going to give her some props that she did a good job on cross-examination of a lot of these witnesses saying, do you know if Jennifer Crumbley ever saw this? Did she ever see that? Does she have any knowledge of this? Or is Ethan, who's at the age where he probably is hiding things from his parents, is he talking to people, making these drawings, hiding these things from his parents as well? And that they shouldn't have known or couldn't have known. And if they didn't know and they didn't see the signs, how were they supposed to know? To him, he was this great kid. That's how it's being presented to the jury. All right. So here is one of the worst clips of the entire trial. And somebody tagged me in a tweet that we're going to use to play this portion. All right. So this is one of the most outrageous things I've ever seen in any trial. In front of the jury, the defense attorney is, again, discombobulated, a little unorganized, a little frustrated, which, again, she has audibly said in front of the jury multiple times, this isn't how they gave it to me. They just gave this to me. I didn't have enough time to look at it. It's so confusing. The way the state's presenting it is confusing on purpose. It's hard for me to keep up. It's hard for me to even make objections just because I don't know what he's showing in front of the jury. Again, I think partially to garner sympathy and showing that this big bad state is not giving her client a fair shot. And they're confusing things on purpose or hiding things on purpose. And she got so frustrated at some point that she really let it go when she did this.
Okay. I am so sorry that this is a mess. Okay. On March 19th, I've got it up on the screen. This is when Jennifer Crumbley and James Crumbley are talking about Ethan acting like or seeming like he was way hungover that day, correct?
Correct.
And it appears from the text that Jennifer is asking if he's okay. She says, how is he?
Correct.
Okay. Why is this doing this now? I am going to kill myself.
Oof.
Okay.
Yikes.
Literally, with victims sitting in the gallery, that's what she says. Because she is frustrated with how difficult the evidence is. The text messages are not coming up on the screen. When I tell you, listen, slip of the tongue is one thing, whatever. maybe dropping a curse word in front of the jury and apologizing or something like that, fine. But first off, to have that in your vocabulary is like wild to me, that people still in today's day and age have that in their vocabulary when something is frustrating them. Is appalling, horrible, insensitive, not something you should do. Okay. But to say it in a professional environment like this, to me, again, I think she's trying to exert to the jury how
I
difficult
disagree
it is,
with
how unfair
Peter.
this is, how the state has all the tools.
I disagree. Don't tell people what they should have in their vocabulary. This is America, sir. I love you, Peter, but this is America. And people can say or joke about anything they want. Now, should she have done it in a courtroom? No. But don't tell people what they should or shouldn't say. Don't say you should never say that. Like, each person individually should choose the things that he or she should never say. But I'm not going to sit there and go, oh, you should never say that word, or you should never. This is America. Some people have to keep saying things in order to uphold the First Amendment. Things that are uncomfortable, things that are offensive, things that are rude must be said to protect your First Amendment rights to speak. And the Supreme Court has ruled on this. Cohen v. California. This is not debatable. She has a right to say it. You might not like that she said it, and she shouldn't have said it in a courtroom, fine. But to say, I can't believe people still have this phrase in their vocabulary. What? I'm not politically correct like that. I disagree totally.
Tools, and it's so hard for them. And she just did slip of the tongue and say something that she probably says in her everyday life to try and explain to the jury how frustrated she is. But that is crossing the line in a way that I don't think I've ever seen or heard before.
Okay. So he woke up acting like
And
he
you
had
can see
way
the
too
state
much
was
to
talking
drink
like,
last
"Did you
night,
say that?"
complaining about a headache. That's what James said back to Jennifer, correct?
Correct.
And okay, Your Honor, I need like a minute, and I'm so sorry. Now I've got exhibits that are doubles on the page, and I'm having a really tough time with the exhibits. I apologize to the jury. Can I please have a minute?
Okay, well, I'm probably not going to excuse them because, are
Can
you
you
able to
help
do
me get this
Are you
done?
able to do it while they're here? Because
Yeah, I'm trying to just get it
next
done.
time I excuse them, I'm going to send them home. I was hoping to finish this witness. I have this task completion thing.
So again, in front of the jury being like, oh, I don't know who that garners, like Greg Anderson did not do this, right? So some people have said, like, is she
That's true. He
doing
did
this on
not.
purpose like Greg Anderson or whatever? I don't remember him ever doing something like this. She apologizes to the jury so much for her behavior in the courtroom, which again is not something you really want to do as an attorney. It's a good thing to do if you do screw up, of course, take ownership and apologize, but you don't want to be screwing up quite that often. If you're the defense attorney on a case like this, especially something as serious as this. So I don't love to see that. Then she's basically looking for a lifeline from the judge, and the judge is like, no, can you just try to do it now and get the evidence put together?
I like to.
And the jury is seeing all this.
You know what, we can just leave it 2 pages on the screen. So right now it's got on page 441 is on the left, 442 is on the right. Okay, so starting with 441, this is where the text says, well, he was really worked up and out of control, so I can see why. This is after they're talking about.
Okay, so you get the idea of what it's like and how she didn't get a bailout. Okay. The school counselor talks about the notices from the school, the teachers expressing concern. Jennifer Crumbley said it was never really anything serious. They never expressed concern about his behavior in a way that would make you think that. Yes, he would get bad grades sometimes. His parents would punish him because they're good parents. Basically, they'd punish him. They'd take his cell phone away. They'd take his video games away if something like that happened. The jury watched a video of Jennifer and James Crumbley talking about how he's the perfect kid. He never got in trouble at school, things like that. They did get him an attorney, and they did some things like that, which to me is not really damning, although some people always like to use it as damning, but I really don't think it is. The Oxford Dean of Students testified that the Crumbleys didn't take their son home, even though they were told he needed counseling as soon as possible. And again, to me, some of this is interesting. Some of this discussion is really interesting. So,
uh-oh, spinning. Stop spinning. I forgot to change this off of auto. That could be the problem.
if somebody brought you in and they're like, your kid needs counseling as soon as possible, I think there's a way for both of those things to be true, where somebody could say that to you, but they don't necessarily mean take him home.
Again? Okay. I don't have the bandwidth for this today, and I mean the emotional bandwidth. YouTube, just get your shit together, please. The hell?
Right now and take him to counseling right this minute. They could say, like, listen, this kid needs counseling, get that set up and get him in with a counselor. And that could mean next week, that could mean next month, that could be a week later. I can understand how the parents might not think it means right now. Now, the question is, did they say take him home right now? And did the parents say, absolutely not, we got other crap to do, we don't care about this? Because that's the state's kind of theory. And the parents are saying, no, that's not how it happened. They didn't tell us to take him home. They really didn't tell us to take him home. Judge Matthews is the judge whisperer. That's interesting. If I didn't know better, I would swear SS was a high school student fumbling a mock trial assignment, comes across as such a ditz, acts like a petulant teenager when she doesn't get her way, ridiculous, ineffective, unlikable.
She is
Again,
kind of unlikable.
Some of her, if I was against her in a case, it'd probably be really frustrating at times. I do think she's making some decent points, but overall, you guys always, and that's why I was excited to do this, because I wanted to hear what you all as the lay people thought as the potential jurors that we always say. By the way, hit that like button if you guys haven't already, and make sure you subscribe to our channel. Please, we want you involved in the discussion for things like this. What do you think about her? Would her actions, even if she was making good arguments for her client and making good points, would her actions and her demeanor and her attitude, would that be a turn off to you as a juror? Would that make you not like her? I don't know how old she is, but she has a criminal defense private website that she is, an attorney. And
okay, I'm going to skip over the questions. Well, if YouTube lets me. Boy, YouTube's being shitty right now. Come on.
layman can understand.
Let's move on. Go to the next clip. Hello, any day now. I'll try a refresh.
Website that she is, an attorney and has been an attorney for more than 5 minutes. Whoa, that woman. Whoa. Thank you, Peter, for everything that you do.
A $500 super chat.
We're responding to literally just sitting here, the amount of messages we get from victims in the community. And I just think just to be an abundance of respect and caution, if we could just not say things like that. I'm not accusing anyone of any malice or any bad intent. I'm just asking that we just not engage in that, because this is hard enough for the people who are sitting here now and who will be sitting here next week.
Your Honor, I am not joking around about anything.
Okay, I think it was just emotions are very high.
Yeah, it's just a slip of the tongue. Calm down.
It's wild. I'm trying to adjust the volume on this video, but it's like the judge is so soft and she's like, I think it was just a slip of the tongue. And then the attorneys are literally screaming at each other. So I boosted the volume. If they scream, sorry, we're going to get through this clip. It's only a couple minutes.
Yeah, how come the prosecution isn't being
I'm not making an objection
criticized for how they're behaving?
I'm not having an emotional response here. I am simply asking that we be respectful to victims. That's it.
Your Honor, I am being respectful. So that is implying I'm being disrespectful. Me saying I'm going to kill myself, I didn't mean in any way to offend these families. It was absolutely not related to them. This shooting is awful. It's the prosecution that's parading all of this up here and putting
Parading?
the
The shooting is the result of the defendant's gross negligence. That is the case.
They are the ones putting the everything.
So then that was another shot that she took, that it's the prosecution that is parading these videos and pictures up there to garner an emotional response from the jury. And again, that is a frustrating comment. And this is outside the presence of the jury, by the way. And the state, again, he gets so responsive and angry and is like, that is the courtroom. That is the case. The gross negligence that caused this. And I get it. And I feel it And I understand that's the case that they're making, but just my opinion, I think a response that was, Judge, we are only presenting evidence that Your Honor has found to be relevant, admissible, and appropriate to prove the case we are here for. We are not making any parading.
Rita, I agree with this. Rita says, I think prosecution is being dramatic. I don't like female prosecutor. I do like defense attorney. She seems real, not incompetent. I think they're both unlikable. But I think that the prosecution is making mountains out of molehills, which is really frustrating and juvenile, and they should stop it. They should stop it. Yeah, everybody knows what a slip of the tongue is. Everybody knows that sometimes you say things that you wish you hadn't said.
We're not parading any exhibits around. We're not trying to get an emotional response.
Let's not make
out of
a big
everybody.
deal out of it.
This is the evidence we have in this case that Your Honor has allowed to come in. That would hit this defense attorney so much harder, in my opinion, than just, screaming back at her, basically, which I feel like is what he did. Thank you to all of the members that are gifting memberships. It's awesome to add new people into the fold, and we've got a ton coming during this live.
Whoa, everybody needs to go home. Everybody needs to go home. All right? I understand that we're not putting victims through anything. I'm sorry, but that just because everybody's disagreeing doesn't mean everyone is inappropriate. We aren't putting victims through everything. We're prosecuting our case. We're trying to do it in the most efficient way.
And I think that female prosecutor, again, had kind of a better response there at the end, but the judge is like, everybody needs to go home. We've had enough. We've had enough.
It's funny.
And then this clip is from the next morning, I believe. Yeah.
Unhung Hero says the state is always going to pull shenanigans. Well, guess what? I don't think they should be allowed to. I think that they should be stopped from pulling their shenanigans. I think a good judge would say, sit down, and stop acting like a dramatic theater kid in high school. Everybody knows sometimes you say things under pressure that you don't mean. So shut up and sit down and let's move on.
Jennifer Crumbley's attorney comes in and apologizes for.
I think YouTube's mad at me because I have two videos playing at once. I've got this one and I've got obviously the court stream playing on another window. And I think that's why it keeps doing this. It's frustrating.
That female prosecutor, again, had kind of a better response there at the end, but the judge is like, everybody needs to go home. We've had enough.
Oh, for fuck's sake. Damn it. All right. This is clearly not working.
We've had enough.
I've had enough.
And then
I can't deal with this. I'm going to nuke America.
I can't take it. I can't take it. I can't take this anymore.
I don't like them putting chemicals in the water that turn the friggin' frogs gay.
That's correct. YouTube is turning the stream gay, I think. What are they
doing? Clip is
doing?
from the next morning, I believe. Yeah, when Jennifer Crumbley's attorney comes in and apologizes for that statement.
Your Honor, on Friday, I think it was very clear beyond a reasonable doubt. I have difficulty and cannot use.
How about how she said, I think it's very clear beyond a reasonable doubt, which is very interesting way of explaining yourself, or saying, Your Honor, I think it's very clear of what happened. She said beyond a reasonable doubt. It's just kind of in her vocabulary to argue that way, which I thought was interesting.
Technology. In my frustration, I made a comment that.
No, I don't think Joe Biden actually said that. I think that was AI. It's still funny, though, because.
I can't deal with this. I'm going to nuke America.
But then again, you can never tell what it is he actually said, because he says some crazy ass shit. I need a button that says, I have hairy legs. That would be funny. Remember that story that he told about having hairy legs and children touching his hairy legs?
Families, and I did it absolutely by accident as I was struggling with my computer. I am apologizing for that comment. I want to apologize to the jurors, to the audience, to all involved, and specifically to the victims and the families of the victims. I truly did not mean to say the comment I made.
I believe that.
Thank you.
We all believe
that was it. I thought that was good. Again, you don't want to have to do that as a defense attorney, but when you do screw up, sometimes you've got to do it, right? Okay, now we're going to jump into kind of a strange, I don't know how much we'll listen to of this, but I want to listen to a few minutes of Jennifer Crumbley's lawyer cross-examining her, what do you call it? It's not a mistress, right? When it's a male, a mister, the person she was having an affair with, I'm not sure what to call him. But she was trying to make the argument that he was pressured by police. They were threatening him.
You call him a cuckold, Peter. That's the name for someone that you're sleeping with who is not your husband. Or is that the husband? Is the husband the cuckold or the cucky? Which one's the cucky? No, the cuck is the husband. What do you call the guy? Yeah, I don't know. That's a good question. I may have to look up in the Urban Dictionary.
The big bad police are always trying to pull one over on the defendant. And again, it just kind of shows the theme of their case is to get the jury to feel bad for Jennifer Crumbley. I really believe that's what they're trying to do, or part of what they're trying to do is show that she is also a victim of these circumstances and what happened to them and her family and what her son did. It's also interesting they're calling it the shooter or her son the whole time and not using his name. I don't know if that was based on a pretrial order or what, but we'll listen to a few minutes of this before we listen to some of the prosecution's when she argued in the prosecution is examining this witness. I think is going to be interesting too, just to hear some of the battles and the sparring between these attorneys.
Very beginning, the first time you talked to police, you told police that you and Mrs. Crumbley had an extramarital affair, correct? You told police from the very beginning your relationship with Mrs. Crumbley involved a sexual relationship, correct? And so when you're
By the way, this is something that they fought really hard to keep out of the trial. And then now they're like, yeah, it can all come in. That's fine. There's a couple different ways to look at this. Either number one, it's gamesmanship. And she's like, oh, keep it out, keep it out, keep it out. But then they build it into their arguments and their theory of the case so they can use it. And the prosecution may not be as prepared.
Urban Dictionary calls him a manstress. A manstress, that's a terrible word. I think another word you could use for a man who's sleeping with a married woman is a bull. But yeah, we need a better word for that.
Right? That's one way. Or she really is unorganized and doesn't know her theory of her case, doesn't know what she's going to argue from one day to the next. And that's not great, obviously. That's not great. But I don't know which one it is. Right?
Cuckold is the guy watching his wife. Yep. Get laid. Or somebody who knows his wife is sleeping around and they're fine with it.
I don't know which one it is. But there are multiple things that she has opened the door to. And somebody asked the question, so Pitt staff, no, I don't think she's trying to get a mistrial. I do think she's doing the best that she can. But somebody asked, say, will you address the opening the door? So opening the door is like, you keep this evidence out, right? We don't want this evidence out or in. The journal is a good idea or a good example of this. But then you use parts of the journal to impeach.
Hold on. It looks like she's got the text now. So Shannon has the text, or is her name Shannon Smith? Something Smith. I wrote it down. Yeah, Shannon. Looks like they are going over the text messages now. And the cameraman's probably going to get in trouble for zooming in on these. So far, I can't read any of them. Oh, I'm sure Redditors are zooming in and posting. Shannon's hands appear to be shaking a little bit. The papers are shaking. I hope that doesn't mean bad news. Well, if she lied, she lied. I guess we're going to find out now. Here we go.
Your Honor, calling people versus Jennifer Crumbley, case number 222799990, F8.
Good morning again.
Morning.
Good morning.
I have reviewed the extraction provided by, I believe, the Oakland County Sheriff's Department and a sealed envelope to The prosecutor, I reviewed all the text. I made a copy for Ms. Smith. And Ms. Smith, do you have an objection to anything in the text chain?
No, I don't. I would ask that if the text chain is used, that it just be admitted as well.
Yeah, okay, so I am going to maintain a copy of the text chain in my own personal file. All right, and I'm handing a copy over to the prosecution.
Oh my God, she's gonna use it.
Thank you, Judge.
Can we continue the trial? What do you think?
Absolutely. Can we have just a minute to look at it?
Okay, yeah, it won't take you more than a minute, but yes.
Well, are you gonna rule on it? Why are you giving it to them? Are you letting them use it? I don't understand. Why are they getting it? Unless she's letting them use it. I don't understand this. I guess is she admitting it? Because why else would she give them these text messages?
Step out in the hopper, please.
Oh, for fuck's sake. Speaking of, don't forget to go over to the merch store and pick yourself up a sweatshirt. I have a bunch of, oh, for fuck's sake, sweatshirts, t-shirts, mugs, all kinds of fun things at the merch store. And hit that like button, by the way.
They're reviewing them. It should not take long.
I just lost my right earbud. Was that the court stream audio, or is it me? That sucks. I hate that. Now I only have left ear. No, she said, if you're going to admit them, I ask that you admit the whole thing. But then the judge didn't respond and then handed him over to the prosecution. So I'm assuming she's going to listen. She's going to admit it. Oh, for fuck's sake. Side hugs. It's a cuddle puddle. Oh my gosh, Kirnath, how can you, aloha, by the way, and how can you wake up at 4 a.m. and just lay there in bed for 2 hours listening? I don't give up my sleep like that in the morning for anybody, so thanks for doing it. Wow. Kirnath says, Christian side hugs. Side hugs. Oh, I'm sorry you have insomnia, Kirnath. But you live in the most beautiful place on earth. You live in Hawaii. I used to live in Hawaii for a short time. I lived at Eva Beach in Ocean Point. That was my first house. I bought a townhouse in Hawaii. And we planned on moving there. And just when we were about to go, after I had set up the house and I had been there for like 2 months, 3 months, my husband got a good job in Chicago. So we had to move back. Well, look who it is. It's the IT goatee.
Hello.
Hello.
Sounds like you kind of picked up after listening to Mr. Navarro.
Are you going to comment on the new Maya trial documents that no one has commented on yet? The reason why nobody's commented on them is because they're boring right now. It's like just they're asking for a stay of execution. They're saying to the judge, don't make us pay this now because we're going on appeal. And we want to wait to have to pay until the appeal. because technically, if the
Once the
judge
final
doesn't,
judgment enters,
right,
it goes to interest, and then they start having to pay like $12,000 a day while they're waiting on appeal. That'll take 2 years to finalize.
right, I think it's 20,000 a day, but it's a lot, whatever it is. So
Lots of money.
I don't think the judge has ruled on that yet. And when he does rule on it, that's when everybody will start talking about it. Right now, it's just a really boring stay of execution. It's very rote and usual. But there is news on the Maya Kowalski front, by the way. There is big news. Jay Hatch's lawyers are busy continuing to harass the Kowalskis. They have now submitted a FOIA request to Jack Kowalski's old fire department where he was the chief, digging for dirt and information on Jack Kowalski. It never ends. And I will have a copy of that FOIA very soon. Illinois law is 5 days. They have 5 days to give it to me. So I'm going to get the FOIA request that Jay Hatch gave to the fire department. And we're going to see what it is that they're digging for and why. And I don't know if they know that their FOIA request is FOIAble, but it is. And I'll have it within 5 days. And pray for Maya, by the way. I have heard that she's not doing too well. She's not feeling well, and the stress is really bad. And you would think that this would finally be over for them, but Jay Hatch is not stopping, and they're just going to continue. Yeah, what WTF are they looking for now? No idea. No freaking idea. I guess we'll find out. Oh, good. Okay, yeah, Brad. Brad has the stream for us.
So I appreciate your patience. And we are going to continue with cross-examination. All right, Ms. Crumbley, could you raise your hand? You swear to affirm the testimony you're about to give is a true self.
I do.
So you can put your hand down. And
This is also a local stream, so it doesn't have the copyright.
My
on
name
it.
is Jennifer
Oh,
Crumbley.
wonderful.
JENNI.
Her hair does look better today.
CRUMBLEY.
It still looks
does.
greasy.
Yeah, but she can't help that because they don't have good products in
in
jail.
As a parent. But before I do, I want to make sure that you understood the oath that you just took.
I do.
Okay, you understand that you took the stand under oath and you have to tell the truth.
I do.
You understand that was the rules yesterday as well.
Correct.
All right, we're going to come back to that.
We're going to go back to that.
You've been described by your attorney as a hyper-vigilant parent.
Correct.
Okay, do you agree with that?
I do.
In fact, you called yourself a helicopter parent before.
Yes, I was.
So you told us you've spent a lot of family time together.
We did.
Now, I'd like to talk to you about what your digital footprint shows.
Okay.
What the evidence on your phone shows.
Okay.
Now, it's true, you agree with me that having horses is quite a time-consuming hobby.
It can be.
Okay? It was for you.
It can be.
And that's what you said yesterday.
Yes.
Okay. And you were at the barn for between 3 and 5 times a week?
More like 3 times a week.
3 times a week
Yeah.
for a couple hours a trip?
Correct.
Okay. It's also an expensive hobby.
It is.
So your banking records show that in the year of 2021, you spent over $20,000 on the horses. Is that correct?
Probably.
Okay. And that's not including cash. That's just from Capital One and Flagstar Bank.
Correct.
In fact, you told a coworker that half of your salary basically goes to the horses.
I might have, yes.
Now, except on rare occasion, you didn't bring your son with you to the barn.
He was not into horses. I would ask every time I went to the barn, but he didn't want to go.
So the answer was no.
No.
Okay. And at least as far as your horses being boarded with Kira Pennock from June of 2021 to November of 2021, your son never went with you. Is that correct?
I think he went once when my in-laws were in town and we met them at the barn.
Okay. But there was nothing stopping you from taking him.
No, he just didn't want to go.
Okay, it's a family atmosphere.
It can be.
Okay, like the Halloween party that she had, that was for families.
Yeah, most of the kids there are young.
Okay, in the winters, you were on ski patrol as well.
Correct.
Okay, and that can be a bit of a time-consuming hobby.
It can be.
All right, and you would be on ski patrol between 1 and 2 times a week?
It's a total of 10 hours a week.
10 hours a week. Okay, so how many days?
I did doubles on Saturdays, so 1 day a week for me.
Okay, so you told this jury yesterday, you depicted your affair with Mr. Malash as a 1 time a week meetup at a Costco parking lot. Is that your testimony?
Correct.
Okay, but it wasn't just that, was it?
Nope.
Okay. In fact, there are numerous photographs sent to Mr. Malash.
Okay.
Yes or no?
I'm sure there was.
Okay. Numerous messages exchanged with him.
Correct.
And it wasn't just during the week, Monday through Friday, was it?
No.
No. In fact, that's what you said yesterday. But in fact, it included trips.
There were actual business trips that he met me on.
Okay. And included other individuals.
Yes.
What's Adult Friend Finder?
So where you can go on and meet people who meet certain tastes that you're looking for.
This is 429. And you had the app Adult Friend Finder on your phone.
I do not believe I had the app. on my
Okay.
phone.
It was found on your phone.
Okay, well, I guess it was on my phone.
Okay. And there were messages from you to other individuals.
Correct.
Your Honor, I would object that this is going outside of the scope of the affair with Brian, but.
I don't think the court's ruling on opening the door was confined to just her extramarital affair with Brian Walsh.
Well, I guess with regard to Mr. Malash, I determined that the defense opened the door. I don't know that I determined that the defense opened the door as to other.
She depicted herself as having 1 extramarital affair for about a 6-month period of time, where she met with him 1 time a week. That was her testimony yesterday. We have evidence to the contrary, and I think it's important.
It's gonna get exciting.
All right,
It is what it is.
all right, well, go ahead, but
I won't delve too far
Okay, yeah,
into it, Judge.
really, this jury has been here a long time, and
I respect their time, Judge. I'll be brief.
You might have blushed.
So, Mrs. Crumbley, I'm sorry, this is not a laughing matter. Mrs. Crumbley, on Adult Friend Finder, we see messages from you in at least of August of 2021, August the 4th, 2021.
Okay.
Okay, and you don't dispute August the 10th of 2021,
No.
August the 11th of 2021.
No.
And more importantly, November 21st, 2021.
No.
Okay, and more important than that, November the 28th, 2021.
No.
Okay, you don't dispute that evidence was found on your phone.
I don't dispute it.
Okay, and you don't dispute that it wasn't just you and Mr. Malash meeting after work hours. It was with you and Mr. Malash arranging with other individuals to meet after work as well.
No, I only met with Brian during work hours. The times that we were at the hotel, I was on business. We did arrange for other people to meet us there.
So Sunday, November the 28th. You remember that day? It was the day after you took your son to the shooting range.
I don't remember it.
You don't remember that day?
No.
2 days before the high school attack?
No, I don't remember what I did that day.
Okay. Well, you were pretty specific in what you did on November the 27th with the firearm. You remember that?
Correct.
All right. Now, November the 28th, 2021, you spent your time arranging a meetup with somebody on Adult Friend Finder.
I never met anybody with an Adult Friend Finder that day.
Arranging a meetup.
Oh, okay.
I'm not just talking about the time that you spent physically with somebody. I'm talking about the time that you spent and devoted your energy to setting that up.
Okay.
And you'll agree with me, it's not just the time period at the Costco parking lot or the time period at the hotel or the time period on the trip, correct?
That's the only time I met with people.
Right. But that's not the only time that you devoted your own personal time and energy and focus to that, is it?
I guess I don't understand what you're asking.
Okay. Well, these meetups didn't just happen by themselves. You had to set them up.
Correct.
You weren't driven there. You weren't dropped off there. You set them up with somebody else.
Correct.
And that took your time and your energy and your focus to do so.
I don't believe it took too much time and energy, no.
Now, you told this jury that when your son texted you that he was seeing demons and bowls flying off the shelves. That was in the spring of 2021. You recall that evidence, right?
Correct.
You don't dispute that that was on your phone.
No.
You don't dispute that at some point you read those messages.
No.
And you don't dispute that your son said at least one time, "Can you please text me back?"
Correct.
You don't dispute that when you're at the barn, your other messages show that you can take pictures, send pictures, and receive pictures.
Usually I'm at the barn. If I take pictures and I try to send them, they don't go through right away, or I won't send them until I hit a spot where I actually have service.
So in Exhibit 423, the Facebook message chat between you and James, the chat that you deleted, there are a number of pictures that James sent to you from the barn of a horse in a conversation about that particular horse. Do you
Okay.
dispute that?
No.
Okay. And in fact, dozens and dozens of pictures of the like.
I'm sure, yes.
You're sure, okay. And those pictures were sent to you with a timestamp on that Facebook message chat.
Okay.
Do you dispute that?
No.
No. Okay. And then you responded in that same time frame. Do you dispute that?
No.
No. So that conversation with that picture that was taken at the barn was occurring while one of you were at the barn.
I'm sure it was.
Okay. Now, you don't deny that your son wrote in his journal that he asked his parents for help. You don't deny that evidence that was admitted.
No, I don't.
Okay. And you don't deny that he wrote in his journal that he now had access to the 6-hour 9mm handgun.
I do not deny that.
And you don't deny that the 6-hour 9mm handgun was in fact the murder weapon.
I don't deny that.
And you also don't deny that that gun was gifted by you and your husband to your son on November 26th.
Describe gifted.
How about when you posted on Instagram his new Christmas gift?
Correct. And I explained yesterday that it was for him to use at the shooting range. We didn't just hand him a gun as a here you go, son. It was something he could use when we went to the range as a family together.
You don't deny that in April of 2021, you described your son as being depressed.
I didn't describe him as being depressed. I noticed that he was acting depressed.
You used the word depressed.
Yes, he was acting sad. He was acting depressed.
Okay. And you know what depressed means?
It means a lot of different things.
Well, to you, it meant depressed, and you wrote that.
Right.
You don't deny in April of 2021, the evidence shows that your son told his only friend that he had asked you for help.
No, I don't deny that.
Okay. And you also don't deny that he told his only friend that you laughed at him.
I do not deny that.
Now, yesterday you told us that you took those messages in the spring of 2021, which, by the way, is at the same time you started your affair with Mr. Malash?
Around that time.
Okay. So in the spring of 2021, when you sent those messages, or when you received those messages, you indicated it was messing around.
It was.
It was messing around. In your mind, messing around. That's what your testimony was.
Yes.
Okay. Even when he said, "Can you please text me back?"
I didn't see his text message, so I didn't text him back.
Even when your phone logs show missed calls.
Can you ask that again?
Even when your phone logs show missed calls from your son in that time period.
No.
Now, you said yesterday about these messing around texts. You agree with me that there's no indication in any text message, either between you and your son, or any Facebook message between you and your husband, in any of those exhibits, in fact, anywhere on your phone, that indicated that any of those messages were a joke.
No, there weren't.
There weren't. And we're talking about hundreds of messages between you and your son, and thousands of messages between you and your husband.
Correct.
And you don't deny that you never once took him to see a therapist or counselor.
No, I did not.
You did not. Now, you testified that, actually, Mr. Malash testified that you would meet during work hours, and we've established that it wasn't just confined to work hours, but we're permitted to leave as you please.
Correct.
Okay. And your boss actually testified that no problem if we needed time off.
Correct.
If you had a family issue, no problem, you can go.
Correct.
If you were sick, no problem, stay home.
Correct.
Okay. In fact, you could work from home on an as-needed basis.
Correct.
In fact, on November the 30th, you didn't even ask your boss if you could leave. You just told him you were leaving.
Correct.
And you told him when you were coming back.
Correct.
And you told him when you were coming back after receiving a phone call from the school asking for an immediate meeting.
Correct.
Because that was at what, 10:05 a.m.?
Around that.
Okay. Now, had you ever been called? You have the TV on, please, Mrs. Lane. Had you ever been called?
It takes some time for all three of them.
Sure, Judge. I have a few more questions I can ask before we get to these.
Okay, go ahead.
Have you ever been called to the school on an immediate basis before?
No,
Have you ever been told that your son had suicidal ideation before?
I was never told he had suicidal ideation before.
Okay, that's your testimony. But you've never been called to the school once for a meeting, I need to see you now,
No,
correct? Okay. So even before you had made it to the school, you had told your boss when you were coming back.
correct.
So you could already put a limit on that meeting.
Not necessarily.
Well, you said, I'll be back in about an hour,
Okay,
right? That's your words.
about an hour.
Okay, those were your words.
Correct.
This is Exhibit 74. Do you see it?
No, she doesn't.
Oh.
It's not on here. That's. Yeah, it takes a minute.
Is it?
Yeah.
You see it?
Yeah.
Okay. This was sent to you. So Sean Hawkins called you at 9:24 in the morning, correct?
Correct.
Okay. You called him back at 9:27.
Correct.
You had a 5-minute phone call.
Correct.
And then in that phone call, he texted you the picture with it was drawn out, and he emailed you this original picture.
Yeah, he texted me the modified one and then later emailed me this one.
Later is at 9:32.
Yeah, like after I asked him for it.
You looked at it.
I did.
Okay. You told us yesterday you found it, I think your quote was a little concerning. What struck you about this?
Originally, when I saw the modified one, I was kind of angry at my son because we just talked about his missing assignments in geometry and his E the night before. Then when I got this one and opened it, it was concerning. I honestly thought the guy on there was a poor drawing of Batman, the way the thing in the cat. I thought it was a cape. I didn't know.
You thought that was a cape?
I did. I didn't look
Okay.
at
What
that
did you think
closely.
of the gun?
I thought it was a gun.
Yeah. What about the fact that it is identical to the gun that you got him for Christmas a couple days before?
I mean, honestly, it just it looks like a gun to me. I didn't even notice.
Well, you took a picture of the gun. You posted it on Instagram. You know what it looks like.
I do, but I didn't analyze it.
You saw Sergeant or Special Agent Brandon's testimony. He described how it's identical. And you told us yesterday how your son was a good drawer.
He's a very good drawer.
Okay. What about the thoughts won't stop, help me? Did that ring out to you?
Yes, that was what was concerning to me.
Blood everywhere, and there's a bullet. And actually, you were the one who bought the bullets on November the 27th.
Correct.
You later came to learn that those bullets were used in the shooting.
I did.
Okay. So you said yesterday it was a little concerning. Yet, you told your husband emergency in all caps.
Correct. That's why I left to go to the school and I
you said-
texted him.
And he wrote back, "My God, WTF."
Correct.
And then you told him he was distraught about last night.
Correct.
Distraught's an intentional word you chose.
Correct.
Not sad. It's not a little anxious about school or his future. It's not talking about a video game. Distraught has a meaning.
Correct.
And you chose that word to send to him.
Correct.
So you went to that meeting, and this was November the 30th of 2021. And at that point, you'll agree with me that you knew prior to that day, the November 26th purchase day, that your son was wanting to get a 9mm. That's what you said yesterday.
Yes, I knew that they were talking about getting one because they had
Okay.
rented it in the past.
And you knew that he had shot one in the past.
Yeah.
Okay, and you knew that a 9mm is significantly more powerful than a 22.
I did not know that until I actually shot it.
Okay, well, your dad took your son with James to the shooting range when they visited in July of 2021.
Correct.
And they talked about how powerful the 9mm was because they rented one.
Okay. I don't know.
Yes
if I,
or
was,
no?
I don't know if I was part of that conversation, but if it was, it didn't register to me.
It registered. Okay, you knew at the November 30th, 2021 date that your son's friend had been taken without notice to your son.
Correct.
You said, I'm sorry, incorrect or
I said
correct?
correct.
Correct. And you knew that when your son's friend was taken. Your son was extremely upset.
He was upset, yes.
He didn't go to school for a few days.
I don't remember that.
Okay. Well, if the school records show that he was absent for a few days after that, would you deny that?
I wouldn't.
And would you deny that he missed school because he was so upset?
I don't know if he missed school because he was so upset or maybe he was sick. I don't know.
Now, you told us yesterday and you acknowledged that that individual, that child, was like a second son to you.
Correct.
So he was the only one that your son hung out with.
Outside of school, correct.
Okay. Well, who did he hang out with inside of school?
He named some names to me. I've never met them before, but he told me some group of kids that he sits and eats lunch with and he talks to in class.
Did he ever visit their houses?
No.
Did they ever visit your house?
No.
The only other peer to visit your house was this student who left the state around Halloween 2021.
At that time, correct.
We're talking about that time in October, in September, in at least August, July, June, May, all
Of
2021.
2021, correct.
2021, thank you. Now, he left on Halloween, and you knew that your son was planning to hang out with him on Halloween,
Yes.
okay? But his friend didn't show.
I had texted his friend's mom the day before trying to confirm if he was still coming over. And that's when we found out that he was driven to Wisconsin and taken to that school.
Okay, so you're telling us you found out the day before Halloween?
Yeah.
Okay. So that didn't stop you and James from going to a Halloween party at the barn.
I don't believe it was on Halloween.
Oh, that's what Kira testified
It
to.
was the Friday before Halloween.
If there was a picture with a date stamp on it, would you deny it?
No.
Okay. And it didn't stop you from after you left that party without your son. You went to another Halloween party.
We did.
And your son was home alone at that point.
Yes.
So you talked to us a little bit about your son's hobbies in 2021. But in November of 2021, so we'll start with November the 1st, 2021. You know that those hobbies were non-existent. And I'll go one by one.
Okay.
So you told us about bowling.
Correct.
Bowling the team wasn't in session at that point in time, was it?
No, I think actually at that time he decided he didn't want to do bowling that year.
Okay, so he stopped bowling the
He did.
sophomore year.
He did.
And it wouldn't have been bowling season anyway.
I guess not, no.
So one hobby you talked about yesterday, that was not in existence in November 2021.
Correct, but we did still go to the bowling alley with him.
Okay. And you said that he worked, but would you be surprised to learn that he only worked a few shifts post-COVID?
No, not surprised at all.
Okay. So he wasn't at work every day.
No, he worked Tuesdays and Thursdays and sometimes Saturday mornings.
Okay. But not very often.
No, not very often.
A handful of shifts post-COVID, which of course, March 2020 is when things shut down.
He was working on a weekly basis.
And you knew that he didn't have any friends.
That's not the right way to put it. I knew he had friends, but no, he did not have many friends.
You had never met another peer his age who he refers to as a friend.
He actually had friends that used to come over prior to 2021 that he was still in contact
We
with.
went through defense exhibits yesterday from 2019 to 2020. I'm talking about 2021, at least from the time period where he sent you a message that he saw demons in the house.
Right. In
It is not
2021,
unusual
only friend
to
that
not
came to
know your
our
kids'
house
friends.
Was the one that was
Right.
on the thing.
So you knew to
I
be
haven't
true
met a bunch
in
of my kids'
November
friends from school.
2021 that he had no peer support.
I don't know what he had in school. He told me he had friends in school that he talks to.
You never met him.
No.
And he didn't have any clubs at school.
That's way different than close friends.
No, not that year.
So you told us yesterday that your son wanted to design video games.
Correct.
Okay. He wasn't in a robotics club or a coding club at the high school.
He did take a coding class prior to 2021, and he was in a robotics after school activity in middle school.
Talking about in
I'm
2021.
just telling you, he's been in that before.
Now, despite what you have called yourself as a vigilant parent and a helicopter mom, you never decided in at least November of 2021 to look at his phone.
No.
Okay. That's despite what happened in the spring of 2021, right?
What happened in the spring of 2021 did not concern me.
Oh, this lip tint
The
is
one thing
red.
that seemed consistent with your son,
I don't know if
to
I'm
you
gonna
at
like
least,
this.
is his desire to obtain a weapon. Is that right?
I wouldn't say that, no.
He had a consistent desire to obtain a weapon.
Not to me, he did not.
Okay. You didn't know about the 9mm?
Oh, I knew about it.
Okay. You didn't know about the 22s?
I knew about them.
And in fact, you posted on Instagram that he got himself a 22
Correct.
in June of 2021.
Correct.
And from that time up until the November 26, 21 purchase, he was wanting to get a 9mm.
I know him and my husband had discussed getting a 9mm. I'm not part of those conversations.
But you knew about it.
I knew, but not that he was so, however you described it.
I said he consistently had a desire to obtain a weapon.
I know they consistently talked about it. Correct.
Okay. They didn't just talk about this is a gun. He talked about how he wanted the gun. You don't deny that.
No.
In November 26, you said you weren't there for the gun purchase.
No, it's not.
Okay. But are you telling us you didn't know it was going to happen?
I did not know they were going to the gun store that day. No.
Okay. But you knew that you were going to eventually get him a 9mm.
No, I did not know that.
Okay. So you're telling us that was a surprise purchase to you?
It was a surprise to me that they went to the gun store that day.
Okay.
It was not surprising to me that they purchased a gun that day.
And it didn't upset you that they bought a gun?
No, it did not.
It upset you that they cut into your Christmas tree shopping time, but it didn't upset you that they bought a gun?
Correct.
Why should we be upset that our husbands buy guns?
And you told us that
They
it
do
was,
that. That's something
your
husbands
words,
do.
James's responsibility to take care of that gun.
Correct.
Now, you don't deny that, at least according to the cell phone evidence, the photographic and video evidence, you're the last adult to have possession of that gun.
Correct.
You were with him at the range on November the 27th.
Correct.
You saw your son shoot the weapon.
Correct.
You saw him shoot the last practice round before the shooting on November 30th.
At the range?
Yeah.
Yes, correct.
You saw how he stood.
Honestly, that didn't mean anything to me at that time until this whole case came about and I've learned what a shooter's stance is. So
He knew how to use the gun.
yes, he did.
Okay.
He's used one before.
In fact, he showed you how to use the gun.
Correct.
Okay. And the stance he took, you saw from the Oxford High School video, was the same. You saw that, right?
I don't know. I can't compare it. I don't know.
But you entrusted this responsibility. Will you agree with me that owning a firearm involves a great deal of responsibility and trust?
I do.
And you entrusted this responsibility to your husband, James.
I did.
If you look at Exhibit 423, that's the Facebook chat thread between you and your husband. It's pretty clear you didn't trust James with much. Would you agree or disagree?
Depends on what you're talking about.
Okay. Well, you didn't trust him to get out of bed on time.
Correct.
You didn't trust him to cut the grass when it was time to cut the grass.
He would cut the grass when it got to a length I didn't like. I didn't trust him.
You didn't trust him to update you on his whereabouts.
There's a reason behind that.
You didn't trust him to not turn off or turn on the Ring camera in your home.
Correct.
You didn't trust him to keep track of your son.
Oh, I trusted him to check my son.
In those messages that we'll see in Exhibit 423, asking him, where is your son, over and over and over again, does that signify trust or distrust to you?
That was when my son was walking home from school. Not that I did not trust my husband with my son.
And you didn't really trust your husband to hold down a job.
It's not that I didn't trust him to hold down the job. He had a hard time holding down one after COVID.
Okay, and in those messages, you are constantly asking him about work, how much money he's making, and what he's doing to obtain employment.
Correct.
Okay. But this is the person you entrusted with a deadly weapon.
I did.
Why did you buy the Patriot defense rounds?
Where are those are that's the ammo. That was the ones my son told me to purchase. I didn't know anything about it. I'd asked him and he told me to purchase them.
So you told the jury yesterday, I think you repeated it again today, that the gift was for target shooting only.
Correct.
Okay. Yet you bought 100 rounds of ammunition.
Correct.
And you only shot 50 while you were there.
Correct.
And those 50, at least according to some statements you made throughout the investigation, you put somewhere.
The box of them, yes, I did. I hid them.
Now, on November the 27th, when you came home, you posted pictures of the gun and targets to your Instagram account.
Correct.
So she
And
made an
according
effort to hide the
location data,
bullets.
Your location data, you left.
I think that's when we went. Well, I don't know. I must have. Yeah.
Okay, well, you don't deny that.
I don't deny
Okay.
it.
And your husband James was gone all day, according to his location data.
I think so. Yeah.
Okay. And you saw in the evidence that in the picture you posted, there's an ATF pamphlet on handgun safety for children.
Correct.
Did you read that?
I looked it over. Correct.
Now, on Exhibit 74, here, I'm going to get back to this meeting for now. Exhibit 74, you don't deny that you could have left work for the day.
No, I don't deny that.
And you don't deny that you didn't tell the school officials, Mr. Hopkins and EJAC, about the gun purchase on the 26th.
No, we had stated that we went to the shooting range I went to the shooting range with my son on Saturday.
You didn't tell them that you had gotten him that Christmas gift.
I didn't think it was relevant. No.
You acknowledge that you never told Mr. Hopkins and EJAC that it wasn't just a friend, but it was the only peer that you had ever met and left.
I probably said his best friend.
You acknowledge that you didn't go home to look for that firearm after the meeting at the school.
We wouldn't have a reason to.
So that the answer is, and you acknowledge that?
No, I acknowledge that.
Okay. And you acknowledge that you had already made plans for the night to go to the bar.
Yes, I do.
Okay. And you acknowledge that you had the time to stop at your house before you went back to work.
50 rounds is like what?
I would have, but I didn't have a reason to.
2 boxes? 2 boxes?
Now,
That's 50
you had
rounds,
told us
right?
that you had never taken your son
2
to any
tiny
sort of mental
boxes
health
this big.
professional.
No.
But you know how to obtain that help.
Correct.
In fact, you have prescriptions related to that.
I do.
So it's not that you didn't know who to call or how to call. You didn't.
Correct.
Correct. Okay.
I object to his tone of voice.
Yesterday, you talked a little bit about
It's aggressive.
how you express emotion.
Correct.
He's
And
talking to
that
her like
the
she's a
counsel
piece
asked
of
you about
shit.
your nerves when you testify.
I don't like it.
You're capable of emotion.
Oh, it's
Yes,
one
Okay,
box.
Okay.
Even
and in
worse.
fact, you had some.
If I were the
explosive
defense
emotional
attorney,
fights with your
I would
husband.
bring the box out and be like, is this 50 rounds?
And that was
This
in the
is
home
50
that you
rounds.
shared.
Correct.
Okay. And with your son, we
Correct.
saw pictures of that home.
Correct.
And you told us that your son was at an age where he wouldn't text you back, I love you.
It wasn't a text me back, I love you. It's like in passing, like, hey, Ethan, good night, I love you.
Well, yesterday you told us that your son was at the age where he wouldn't text you back, I love you. Those
Well,
were your words
that,
yesterday.
yeah, but more or less like just saying it in passing. He didn't. He wouldn't say it back. I say good night, Ethan, love you, and he'd like, good night.
Okay.
For him to text me that he loved me was abnormal.
Abnormal.
Correct.
Okay. But you didn't respond to that text until
Hemplin,
44
Texas, thanks for the
minutes later.
No, it
gifted
wasn't a meeting at
memberships.
Okay. And if you go
Welcome to
through
the
your
Fox
entire
Den, 5 of you.
Your entire text message thread between you two, the word love pops up how many times do you think?
Between me and my son?
Yeah.
I have no idea.
Okay. 3.
Okay.
The first is in reference to the game chess about a year before.
Okay.
And the other 2 times are right before your son committed this act and after the shooting when you responded. Does that surprise you?
No.
Your Honor, I would just ask if there could be a foundation for the dates of those texts, because I feel like we got just a few texts.
Okay, well, I think he did you specify the date?
I did.
Two of the times were before and after the shooting, and the other time was when?
About a year prior. I could pull the date if council would like it.
And I'm also wondering if what the data he's relying on is coming from Jennifer's phone where she deletes all her texts, or if it's coming from the shooter's phone. Because the prosecution's asking questions, I just want to know the foundation.
Oh, sure. Let me clear that one up. It's from your son's phone. So all the messages would be contained there. You don't deny that information would be accurate.
No, I don't deny it.
Okay. Now,
What time?
you told us that
Well, she said he asked if the chess one was a year earlier, and the other 2 were close in time to the shooting.
the day of the shooting.
Yeah, I know.
I'm asking.
Those have been admitted in evidence.
Do we know?
What's the question?
Okay, but he's asking about the text overall, which have not been admitted into evidence, and I don't know that the text chain has all the texts. There's no foundation that what Mr. Heese is looking
Judge,
at.
in cross-examination,
If
if
He's
the,
asked if that wrong, would you argue with that? That's what he's asking. I mean, there are people.
I know, she just doesn't know what.
hold on,
it is.
counsel can't testify.
Yeah, she can testify. Well, there are people that end every conversation with one of you.
Yeah,
Okay, so, and there are people who don't.
Locals is memeing.
So
You finally found
is
something
asking
funny to
what's
meme
wrong with
about.
them, and would she be surprised that
We'll
comment
wait for the
comes
next
here?
break.
Yeah, I'm just asking, I get that, and I get that it's not common. I'm just asking. what
Judge, this is
period-
argument.
I'm just
Counsel can
asking
argue
what
whatever she wants to.
period of text this is from.
Well, you got redirect.
Okay, well, she doesn't know what he's even basing his questions on. It's
How,
not point.
okay, it is inappropriate for counsel to
Okay, she
suggest to the
said,
court
I
what
don't
she
know.
or does not know.
She can say, I don't know, but she can also say, I don't understand the question. She
Okay.
can say that too. Mrs. Crumbley, if you don't understand the question, ask Mr. Peace to clarify it.
Okay.
All right?
All right, thank you, Judge. Now, yesterday, Mrs. Crumbley, you talked about going to planning mode.
Yes.
Okay. And that was in reference to counsel asking you about emotions and how you express emotions.
Correct.
So I want to talk to you about your planning mode and your priorities from the time that you were arrested.
Okay.
Now, your phone calls were recorded from the time that you were arrested until now. Do you know
Correct.
that? You
Yeah,
know that, right?
I knew that.
You know that, okay. And your priority on your first phone call, December the 4th of 2021, was on your animals and the cash recovered from the art studio. Do you deny that?
I don't deny it.
Do you deny that it wasn't until 10 days later and 14 calls later that you even mentioned your son?
I was.
Do you deny it or not?
I don't, but I was under the impression that I couldn't mention him because I could get flagged at the jail.
Well, you mentioned him in later conversations.
I did.
Okay. In fact, in one, a year later, March 25th of 2023, you said he just needs to man up. Do you recall that?
I do not.
Okay. Do you not deny that you said it?
It sounds like something I would say.
In December 2021, your concern was about a GoFundMe. Do you remember that?
No, I do not.
I'm going to play this for you.
This lawyer is giving Ethan Shapiro meets Binger vibes. Funny.
This is impeachment, Judge.
Unhung Hero, thanks for the super chat. You're getting us closer to that Archie Ruckus cam and frozen peanut butter treat. Defensive ammo, 2 boxes or 1 box of target ammo.
Well, there's no, Jennifer, that's.
I know there's a lot of people that call the lawyer about my horses. So, I mean, I'm just not, listen, I'm throwing shit against the wall and see what sticks.
What's that?
I'm just throwing shit against the wall and see
Oh,
what
I
sticks.
know.
Okay, that was
I can't
between
hear
you
any of
and your
that.
dad.
Correct.
Okay. And you asked him to set up a GoFundMe to pay for the board of your horses?
I did, yes.
I love it how they always try to use GoFundMes against people.
You
Like,
were
why can't she
concerned
raise
about
money for her horses? Why? Why can't she raise
Other
money?
things related to yourself around that time, weren't you? Is
yeah.
this still planning mode?
I believe so.
Okay. And
For
you were arrested
reference,
December the 4th. This
here is a
December
purse pack of
22nd.
tissues next to a 9mm Luger box of ammo. Thanks, Kimmy. Purse pack of tissues. That's how small the box is.
How many calories in a bowling sandwich with white bread? American cheese.
So this big.
With American cheese. Yeah. Get some mayonnaise on it?
The closed captions are on, but they're not working. Brad, are the closed captions on?
And peanut butter jelly white bread. Okay, so you're looking at bowling right now. Is that what your lunch and dinner is?
For the most part, yeah, there's the other stuff, my cereal is now something that I actually
Well,
eat.
there's American cheese, yeah, American cheese.
And an apple and a banana. Because they like just carb loading me, and I want to make sure I stay at like 1,000 to 100 calories.
No, I know bananas 100 calories.
Is it okay? What about an apple?
Yeah. So the sandwich is 140 calories. Oh, 240.
Okay, that's 300, so good. It is
Yeah.
And then peanut butter jelly and white bread.
Still planning mode?
Well, I wasn't planning there, no.
Okay. Now we're talking about how you describe planning mode. You describe that in context.
No,
to
Kim,
statements
we
you
can't.
made to the police. on
There's
November
nothing
30th,
we can do about the court audio.
Right? That's the context you use the words planning mode in relation to.
There are no captions either.
So,
They're not
You told
enabled.
us that the last phone call on December 31st, that was still you in planning mode. I want to make sure we can have a depiction of what that is. And here's one from January 15th, 2022. Planning mode in relation to.
Correct.
Okay. So you told us that the last phone call on December 31st, that was still you in planning mode. I want to make sure we can have a depiction of what that is. And here's one from January 15th, 2022.
No, it's not an issue of that, it's an issue of, that bank's gonna be always, they have issues with their online stuff, and they have issues with, just all kinds of stuff. I don't know, how can that bank for these people, it's like, so. That child deposit thing? The what? Child thing the government does? I just got, because I lost access. For some reason, I don't know if I had access. Well, I had access basically to view only. And it was hard to see everything on there. And then also I lost access. And then it took me, I lost access like a couple days before Christmas. Yeah. Okay.
Okay. Is that still planning mode?
We were talking about filing my taxes if you played the whole thing.
You were asking about your child tax
Correct.
credit. You're still going to get that $300.
My dad was doing my income taxes for me.
Now, when we started, we confirmed that you understood the oath that you just took.
Correct.
And that same oath you took yesterday.
Correct.
Okay. And you don't deny that you had $6,000 in cash in your purse the night you were arrested.
No.
You don't deny that your purse with the cash and 4 cell phones were in a plastic tote.
Correct.
You don't deny that that plastic tote was contained in a different plastic tote.
Correct.
You don't deny that your backpack with clothing items was found in a different plastic tote in a different area of that studio.
Correct.
Okay. And you don't deny that you knew you had been charged with involuntary manslaughter.
Correct.
In fact, as early as December the 1st, 2021 at 6:10 p.m., you were talking about how you're being charged with involuntary manslaughter.
That was what I was being told by a family that was texting me. That's what the charges might be announced as. Correct.
Okay, and one is to Mr. Malash. There's a text to your cousin about you are being charged with involuntary manslaughter. You don't deny receiving that.
No, I don't.
That's Wednesday, December the 1st.
Correct.
Right? And you sent your neighbor a message on Wednesday the 1st of 2021, 6:55 p.m. that you were reading, they may charge us.
Correct.
Okay. And December the 2nd, 2021, you wrote, they're saying involuntary manslaughter.
Correct.
Right? You don't deny that?
No.
And of course, you looked at different news articles about that the next day.
Yeah.
Later on.
Thanks,
that day.
Sarah. Fixed income contribution to a new mic.
You texted,
I don't know if it's the
after
mic's
all of
fault.
these messages and news articles, on December the 2nd, 2021 at 2 p.m., we're fucked. You wrote that to Mr. Malash.
Correct.
Okay. And then you wrote,
I think I just might need a mixer.
announcing charges at noon on December the 3rd, 2021 at 8:17 a.m.
Correct.
And you wrote that to Mr. Malash, you wrote that to Kira, you wrote that to your dad, right?
Correct.
Okay. So you don't deny any of that?
No.
Okay. Now you told us yesterday that you popped 4 Xanax?
I did.
Okay. And your husband popped 4 Xanax?
Correct.
You said you went to bed about 11 o'clock.
It was around that time.
Okay. And the evidence that we have admitted show that you set your alarm for 6:30 a.m. and 6:45 a.m.
I don't know if it was me who set it, but it was set for that time.
Okay. And from the evidence, it shows when it was set too.
Correct.
Okay. And it was set a little after 11 p.m.
Okay, correct.
Yes? Okay. So yesterday you said, I want to say it was after 11 about going to bed. I want to say it was after 11, maybe around 11 o'clock when we finally went to bed. I prescribed Xanax for anxiety, and we each took 4 because we knew we were going to turn ourselves in the next day, and we hadn't slept in 4 days and we just wanted to sleep. The question was, okay, so you each took 4? Your answer, we did. And the next question was, okay, so the next thing, the next piece of evidence we saw that was coming in that art studio, do you recall that? Your answer? I recall my husband screaming, "There's people with guns against interface officers." Question, what were you doing prior to hearing your husband screaming? Answer, we were sleeping. Question, okay, were you aware that there was anything going on? Answer, I was not.
Correct.
That's your testimony.
Correct.
Okay. And you know when you say something that isn't true, that's called a lie.
Correct.
Okay.
Thank you, Sarah. Happy birthday in advance for new equipment. Yeah, my birthday's coming up in April. Gonna be a big 4-8. 48 coming up.
130. Council,
Brad,
what's that
what are you doing?
Is it
The entire thread.
perfect? No
Here you
judgment. Oh, here you go.
Judge, does the court have a copy?
Is this today's?
Yes, Judge.
Okay. Any objection?
No.
Okay.
Mrs. Crumbley, you knew the police were there.
4:30 is admitted.
Thank you, Judge.
Not until I woke up, no.
Not until you woke up.
Correct.
Okay. Now, we heard testimony yesterday, or throughout the trial, that 911 was called at 10:43 p.m. You recall that?
Yeah, I saw in the video, correct.
Okay, and on the video, the first officers arrived before 11 p.m.
Correct.
Okay. And either you or your husband, we couldn't tell from the video, but you tell me, was it you or your husband out there smoking?
That was my husband.
Okay. So your husband walks in shortly after the 911 caller walks in the building to call 911.
Correct.
That was on the video.
Correct.
Okay. And officers arrived. And then we've heard testimony from Mr. Kirtley, who had a studio there. We heard testimony from Sergeant Hendrick, who was in the fugitive apprehension team, as well as Corporal Shaw with the Detroit Police SWAT team, about the amount of officers there.
Correct.
You recall that?
I do.
And you recall hearing the testimony that Corporal Shaw's team, their SWAT team, they actually used a 35-pound steel ram to bash in a door at the studio next to where you were at. You recall that testimony?
I do.
Okay. And your testimony was that you were asleep when the officers arrived.
Yes, I was.
Okay. But you had an alarm set for 6:30 in the morning on your phone, and that phone was found powered off, hidden in a tote, contained in a different tote, in a place away from the bed.
Correct.
You don't deny that?
No.
All right. And there are certain messages in 430. I'm going to go through them with you. This is actually to your attorneys. At the time, you had 2 attorneys. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. That's it. December the 3rd, 2021, 6:04 p.m. Did you recall that?
I don't, but I don't deny it.
Okay, you don't deny it. Okay. Your next message, the other phone broke. That's December the 3rd, 2021 at 6:04 p.m. The response was, when you can, we would like for you to call us. That was from either Ms. Smith or at the time co-counsel Mary Elaine.
Correct.
Your response, I'm sorry, this is from Mary L. Thank you. Shannon is calling you both shortly. Okay. At the top it says to and from. I'll make sure I identify for the record. From Shannon, Marielle and I are going to come get you guys in the morning. We do not think it will help to make a statement that you're coming back now or that it will be tomorrow a.m. We can say that we told everyone you were coming back, and as of tomorrow a.m., you are back. That's Friday, December 3rd, 2021, 7:02 p.m.
Correct.
Right? Okay. So that's after James had already moved the car around and backed into the parking spot.
I believe so.
All right. From Shannon, we can show them that everything we said was going to happen did happen. That's Friday, December 3rd, 2021 at 7:02 p.m. Right?
Right.
Your response, okay, that's at 7:03 p.m. From Shannon, I'm going to drive home from my office right now and call you guys in about 40 to 45 minutes so I can get all the bond factor information written down for Marielle and me. That's Friday, December 3rd at 7:36 p.m.
Correct.
Okay. Your response, okay, we'll be waiting, 7:37 p.m. Shannon, I'm going to call in 1 minute. That's at 8:54 p.m. that Friday night. Your response was okay. You recall?
I don't, but I don't deny it.
But you don't dispute the records.
Correct.
The next message you send was, think we might have found, don't know, just heads up, please check. December the 3rd, 2021, 11:14 p.m.
That was written, but I do not believe it was written by me.
Okay, you don't remember. Well, you told us you don't remember any of these text messages. You just
Right.
specifically
I
don't remember this one?
read through it, but
You don't deny that this was on your phone, what we refer to as the burner or track phone.
correct. We
You don't deny that.
were both using that phone at the time because my husband's broke.
Okay. And then you wrote in quick succession, don't know, 11:16 p.m. We might have been found, 11:16 p.m. Laying low, 11:16 p.m. You don't deny that these are the records?
No, I don't.
Okay. Response from Shannon, oh shit. Friday, December 3rd, 2021, 11:16 p.m. Now we know from all of the objective evidence, the testimony, the video, everything that the officers testified to, they were on scene before 11 p.m. You don't deny that.
No, I don't.
You don't deny that there were hundreds of officers on scene.
I don't know how many were on scene.
Okay. How many did you see when you got pulled out of the art studio?
Honestly, I don't know. It all happened so fast. I knew there was more. There was a few. There was more than a few, but not.
You saw the body
hundreds.
camera footage.
Right.
I do want to make a point so everyone's aware. This exhibit was just made admissible this morning.
Correct.
Okay. So we actually just received it this morning, and when you testified yesterday, you didn't know this exhibit was going to come into evidence.
Correct.
I want to talk to you now about the night before the shoot. November the 29th, 2021. You had testified that you got into a fight about grades with your son.
Correct.
Is that because you checked Power School?
Yes.
Okay. During that fight, did you lock your son out of the house?
We did not.
You don't deny that he was outside of the house?
He did. He did walk out of the house. He was upset.
Okay. You told us that you took his phone.
We did.
That's not true, is it?
What? That is true.
On
We took
November the 29th, 2021, your son filmed a 19-minute video while he was outside describing what he was going to do the next day.
What time was that taken?
10 o'clock.
I don't know if he got it back. I know we took the shooting range away and we took his gun away. So I don't know if he got it back.
Now, all of the times that you were at the barn, there was nothing stopping you other than you told us he didn't want to go, right?
Correct.
There's nothing stopping you on November the 30th, 2021 from taking him home.
Correct.
Nothing stopping you. You know, actually, I want to go back to what you just said. You took his gun away.
We took the shooting range away.
You said you took his gun away.
No, I said we took the shooting range
She
away.
also said we took the gun away. She did say that. She may have misspoke, but she may have meant phone.
Your son could have been with you those 3, 4, 5 times a week when you were at the bar.
He could have, yes.
Your son could have been with you on those times when you were with either Mr. Malash or somebody else.
No. He could not have been there when she was boinking some guy in a Costco parking lot.
I wasn't with Mr. Malash at those times.
Okay, the other individuals then.
I wasn't with them either at those times.
According to the
I
friend
might
finder,
have messaged people at those times, but I was not with anybody at those times.
he could have been with you on the Halloween party.
He did not want to go. It was a bunch of little kids.
And on November the 30th of 2021 at 12:51 p.m., you could have been with him,
I could have, yes.
and you didn't.
Nope.
Nothing further.
Redirect. Thank you.
Yeah, I wouldn't give my 15-year-old a gun, but I'm not.
Two areas of questions.
But other
for you.
parents do.
Mr. Keys played some recordings. Who were you on the phone with in those recordings?
And my dad.
Okay, so
It's
you
not
asked
illegal.
a couple of questions about calories, and then what was the other one?
I guess a child tax credit.
Okay, how often did you speak with your dad?
During the summer, it was every day. They went back to work. It was just on the weekends. They're both teachers.
And how many hours a day do you spend with other people?
Sometimes it's none. Sometimes it's when they walk by my cell, I'll talk to them, but I'm locked down 23 hours a day. I get 1 hour out by myself. I talk to my clergy lady legally, so I see her. Sometimes I talk to the church priest, or I'll talk to my attorney. But it's about the most human contact I get.
So I guess one of my questions is, when you do talk to people, you talk about, are there more conversations than just those?
Right, there are.
And then that night on December 3rd, going into the 4th, after 11, there was one phone being used, is that right?
Correct.
Whose phone was being used?
It was my burner phone.
Who was using the phone?
My husband was using the phone.
Okay, were you also using it?
No, I was using my other phone. So he started using my burner phone. I used the one with our regular phone number to do anything on.
Okay, so these messages are from the burner phone.
Correct.
To myself and Mario.
Correct.
So the ones after 11 o'clock, so at 11:17 or whenever these texts came in, what were you doing?
When I saw the video of my husband going to the car and having a cigarette, I knew I was probably sleeping at that time, because I did not like us not being together after what happened to us on the 30th when the police came to our house. So if he went out to have a cigarette, it was most likely because I was asleep.
Okay, when guns were in your face and we saw that on the video, before that, had you been asleep?
Yes.
Are you absolutely sure about that?
I'm positive.
Okay, I have no further questions. Thank you.
I'm going to excuse you for about 10 minutes, and we'll see where we're headed. Okay?
All rise for the jury.
All right, you may be seated. You can rejoin your attorney.
So I didn't think that cross was that damaging to her. And he never used those text messages that he was, so desperate to get in. Did he? Did I miss the text messages between her and her lawyer? Because I didn't hear anything that was like,
Your Honor, at this time the defense rests, and we're ready for closings.
Megan, you're muted. You're
again?
We
No, I'm not.
At this point, we would need at
It's
least
not.
30-minute. Counsel said she had 2 other.
I'm not
witnesses,
muted.
But we can be ready in 30 minutes.
It was Miss.
Can you hear me?
Mrs. Crumbley's parents.
Because the mute button's
Those are
off.
very short witnesses, so.
That's fine. But
I wouldn't know how long.
I can't hear you.
Okay.
That's
She said
weird.
2 more other
I
witnesses.
don't have
I'm
any
not
objection to
muted.
having 30 minutes. I'm just saying we're ready to go to closing, which is good news.
Everybody else
I'm
can
not
hear me
surprised
except you.
Because she was planning on resting, but she didn't tell us that, which is fine. But her client just testified to some things that we really do want to incorporate into our closing. So.
Okay, well, that raises a couple of questions. One, okay, so
Wait,
you asked, are you
that's weird.
calling anyone in your level?
that's what I want to speak with the prosecutor about.
One
Judge,
moment.
in light of-
Hold on.
Sorry.
Okay.
I'm so sorry. This is a lot.
Okay, well, if you guys want to break to this.
If
Yes.
we could, Judge.
Okay, so
If we
they
could.
have a right to rebuttal, so I'm going to.
Okay, things are changing a lot, sorry.
Okay, so
Got
I'm
nothing
going to
else.
have
She
that
rests.
discussion.
That's
But as I indicated yesterday, I think that we've been back and forth on
Brad,
jury
if you pop out of the
instructions.
studio, oh, he
And I
can't hear me.
submitted to you, I don't know, about 5 days before the trial, what I believe would be the final instructions after consultation with you. And there might be some fill-ins, there might be some things, so I need to know what those are. I make the attorneys sign in law that they agree to them before closing, so.
Your Honor, just so I can make sure I have the absolutely most updated copy, Would you, Ashley, would you email it to me?
Yeah,
Okay,
we
I'll,
can email it to you, we can have trouble. but
I
we
just,
have-
well,
we
I have
have
so
it.
many files,
We
I
have
just
it.
wanna make sure that I'm looking at the right one.
We-
And I think
we do have it.
I think we're actually good on those, so.
I thought before we started, we agreed upon the instructions. I recall that.
Oh, we
The first
did,
day.
but you know, sometimes.
I just need to double check we pull out, like defendant not testifying,
Right.
like the simple things.
Yeah, some small things can change, okay? So, good.
I don't understand how the defense can be done already.
Let me know if you're gonna have rebuttal.
I would have recalled that school counselor.
Determine what we do next.
Thanks, Sharon.
I did not see her though go after the school counselor, and they said she didn't do a very good job when the school counselor was on the stand. So her entire defense is just Jennifer Crumbley, which I don't think was a terrible idea, but I mean, I don't think she went after that counselor hard enough. But I didn't see it, so maybe I'm just going off what I heard from other people say.
I thought you were doing what I was talking about.
If the school counselor didn't see it, I have a 12 awful on my face. If the school counselor didn't see it, how is Jennifer supposed to see it? I don't understand that at all. Don't you like this lipstick color? So I got this new stuff. It's this Korean lip tint. Have you guys ever used, girls, I should say, have you ever used this Korean lip tint stuff? My daughters are obsessed with it, so I thought I would buy some and see if I liked it. It's by Bayfree. I put it on my Amazon store. I really like it. It comes in all different colors based on fruits. This one is cherry. Over the last couple of days, I've been trying them out. I used, so there's like apple and watermelon and what are the other ones? Peach. Peach is like really light. This one's I thought this was going to be too dark red, but I kind of like it. So what's great about the lip tint is that you get to, it soaks into your skin basically and dyes it for the whole day. So even if the gloss wears off, you still have color. Now, I don't like matte lipstick because it makes my lips too dry. I have dry lips and I don't like matte color. So then I got this gloss by e.l.f. because I was looking for paraben-free makeup. And this one is Hydrating Core Lip Shine. And it's in, what color is this? Lovely. It's called Lovely. And it has like a, I don't know if you can see this, but it has like in the middle of it, like a little gloss thing in the middle and then lipstick on the outside. I love it. Smells like watermelon, doesn't really taste like anything. And I like it. Other stuff I got an e.l.f. contour palette, which I used for cover up and for contour. They haven't sent me the blush yet. I ordered an e.l.f. blush as well. I got this highlighter, which is from Bayfree in this color. It's also a moisturizer, but I kind of don't like the way it smells. It smells like ginger, which I like the smell of ginger, but it reminds me of sushi. And I kind of don't want to be thinking about sushi when I'm putting something on my face. But I will say that the scent kind of like goes away after a while. So it doesn't bother me all day. But it is nice and moisturizing. So I like it. I like it. So that was some of the new makeup that I got. I got some, I ordered some moisturizer and also some cream blush. And I only use cream makeup because my skin is so dry. I only use cream makeup. I love it. So, not that any of you care about this, but it's just what's on my mind. Oh my goodness. It's not a bruise kit. No. This is a bruise kit. Where's my bruise kit? I have a bruise kit. I bought one for the Johnny Depp trial. Ah, there it is. Here's my bruise kit. Now, this is a bruise kit. You need the purples and the greens and the blacks and the yellows to make a convincing looking bruise. A contour kit is something totally different. It gives you the nice shadows, on the cheekbones, hides the double chin, which is something I really need. So, and it's all paraben free, so you don't have any plastics in it. Night Owl, this is the argument that those of you who believe she's guilty are making. There is no evidence that he showed any signs of mental instability. They did not prove that. The prosecution already rested its case. They did not prove to me that they knew that the parents knew that this kid had mental instability. And in fact, I was told, but I didn't see this. So you guys who watched the entire trial, let me know. Was there a psychologist on the stand that said Ethan Crumbley is not diagnosed with any mental instability? If that's the case, how could she have known that her kid was mentally unstable when the doctor says he's not? I don't understand that. What is the evidence you have that he showed signs to his parents, not to his friends, not to the school counselor, but to his parents that he was mentally unstable? What are the where did that happen? He sent text messages to his friends saying he needed help. Those friends did not tell his parents. Should they be on trial right now for negligence? He wrote things on documents in school that said that indicated that he had problems. Did anybody at the school tell his parents? No, not until it was too late. Not until it was too late. Okay, those of you saying she ignored him, I didn't see any evidence of that. That may be the case. Maybe she did, but I didn't see any evidence of that. I saw evidence that he's a 15-year-old kid who, is like most 15-year-old kids and doesn't want to spend a whole lot of time with his parents.
I do think that this defense attorney did not do a very good job of actually protecting her, attacking the points that are needed in the statutes or anything else.
Yeah, well, maybe she will in the closing. Let's hope.
No, because you can get away with saying a bunch of things in closing, but in your defense of your client, going back to all of those things that the lawyers were saying, attacking the individual points, saying the school had the burden of protecting Ethan and protecting the other kids, and proving any of that. I didn't see anything that
All right, Sarah says he was hearing voices in a text to his mother while he left home alone and mom ignored him. She explained that this was a family joke they had with him saying from the beginning that the house was haunted and that she wasn't paying attention to that anymore because he was making a big deal out of it. And he even sent her a video alleging that the door closed on its own and she could see that he was closing the door. So this was like a family joke. Probably was, and they also bought him a Ouija board, which I said I didn't think was a good idea. I don't think you should buy your kids Ouija boards or anything, but this, she had an explanation for it that is believable to me. Does it rise to the level of beyond a reasonable doubt that that she was grossly negligent? I don't think so. And the way the state has behaved here, not to mention she has been in prison now for almost 3 years. How much more time do you want a woman like this to serve? She's already lost her son. She's already lost her reputation in the community. What more do we want? Why do we want to punish this woman? So why do we want to do that? Where are all the criminal trials for the 15-year-old gangsters in the city of Chicago running around every weekend, shooting people in the head, shooting toddlers? Where are they? Where are the absent parents? You want to talk about absent parents? Well, Ethan Crumbley had 2 parents living in his house. None of those kids in Chicago have parents. Where are their parents and why aren't they on trial? Why aren't they on trial? Ask yourself that question. Why are the Crumbleys on trial? If they were a different color, would they be on trial? Because there's a whole lot of violence going on in the inner cities by Black and brown kids, and I don't see any of their parents on trial for criminal negligence. Do you? And if you open this door, are we just going to prosecute the white parents, or do we prosecute everybody? Are we going to start prosecuting everybody whose kid takes a gun and hurts somebody? I just think this is nonsense, is what this is. Now, if you wanted to go after them civilly, you have a good case. There's a good case there for civil negligence, but criminal negligence, Come on. Come on.
I got a funny
Sarah,
anecdote.
hold on. Sarah says every case is specific. You can't compare apples and oranges. Just secure your firearms. Well, they did, but they didn't secure them well enough, apparently. They had a gun safe. They kept the gun in the safe. She hid the bullets. Like, I agree that they probably could have had a safer system. However, they didn't have any indication that he was going to use the gun to hurt people. There was not until the day it happened did they have any indication. And on that day, it was the school counselor and the principal who dropped the ball. It was the school counselor and the principal who said he's not a danger to anyone and you can leave him here. What are they supposed to do? They're supposed to read minds. They're supposed to be like, well, no, we disagree with the school counselor and the principal, and we're going to take him home right now. Well, maybe they could have done that. But how is that negligent when you're being told by the people who are in charge that your son is okay to stay? Sorry, Brad. What's your what were you going to say?
Anecdote.
Anecdote. Thank you. I almost said analogy, and I was like, well, maybe that works too.
So Tuesday is when we left Miami, and Sam was mentioning, oh, Miami's so beautiful. And then we flew into Midway, and she goes, God, Chicago looks like such a shithole.
It is a shithole. It is.
She's like, we just came from Miami, and it looks so cool, and, the high-rises all look so nice and clean. And then you fly into Midway, and it's just row house over row house that looks unmaintained.
And it's the worst. No, Midway, and by the way, Midway is outside of the city of Chicago. It's like, well, no, it's technically Chicago, but it's like outside of the city.
Very much South Side, but
it's South Side, and the South Side has always been so trash. Like that's where I come from, is the South Side, and it's just trashy. You traveled there in the absolute worst time.
Oh yeah, when it's gray and bleak.
When everything's gray and dirty from the first snow in Chicago until like June. Everything looks awful. You got to have leaves on trees for Chicago to look nice. I missed a couple super chats. Kylie needs a holiday. Thanks for the super chat. Says time for mummy free time. 2:50 a.m. here in Australia. Well, wonderful. I like to stay up that late sometimes too, just so I can be alone. It's true. Trishy 818 says, Megan, your hair is so cute. Oh, well, thank you so much. Hair comments get treated like super chats, by the way. Okay, Kim D, thanks for the super chat, says, since I'm the one who first mentioned it, here's to help with whatever is needed. I feel bad because I appreciate you so much. Well, don't feel bad. I'll be fine. Thank you. I appreciate that. We are now about $60 away from Archie Ruckus cam and a frozen peanut butter treat. All right. Let's see. What am I going to do? So we have a half an hour till I have to leave, which is probably going to be right at lunchtime. Or did they just break for lunch just now? Is that what that break was for? Or are they going home? Are they going home? God, I wasn't paying attention. I wasn't paying attention. Are they going home? They might be because the defense rested. Should we back up and see what happened? Because I wasn't listening. Did anybody hear? Were they going home? Oh, he wanted time for closing. Are they going to close today?
That raises a couple of questions. One, okay, so you rest. Are you calling anyone at all?
That's what I want to speak with the prosecutor.
One moment. Hold on.
Sorry.
Okay.
I'm so sorry. This is allowed.
Okay, well, do you guys want to break into this?
Yes.
Okay, so they have a right to rebuttal, so I'm going to.
Okay, things are changing a lot, sorry.
Okay, so I'm going to allow them to have that discussion.
Okay.
But as I indicated yesterday, I think that we've been back and forth on jury instructions. And I submitted to, I don't know, about 5 days before the trial, what I believe would be the final instructions after consultation with you. And there might be some fill-ins, there might be some things, so I need to know what those are. I make the attorneys sign in law that they agree to before closing, so.
Your Honor, just so I can make sure I have the absolutely most updated copy, Ashley, would you email it to me? Okay,
yeah,
I'll
email it to you, we can have to go.
I have so many files. I just want to make sure that I'm looking at the right one. And I think we're actually.
God, she's so disorganized.
I thought before we started, we agreed upon the instructions.
recall that.
Oh, we
The
we
first
did,
day.
but you know, sometimes.
I just need to double check we pull out, like defendant not testifying,
Right.
like the simple things.
Yeah, some small things can change, okay? So, did you get it? Do you want to get back to me shortly and let me know if you're going to have rebuttal?
Yes.
Yes, sir.
Okay, because that will determine what we do next.
Sounds.
Thanks.
So they broke for rebuttal, or they broke to discuss if they want to do rebuttal,
If they want to do rebuttal,
and then
get ready for closing. So
Yeah.
closing is probably going to be today, is what I'm understanding. Does anybody else think it's really strange that these types of criminal cases are only given 7-8 days? And then we watch a trial like Maya Kowalski, a civil trial that goes on for 33 days.
Yeah.
You know, like I don't understand how they set the timing for this stuff. But I want to address this question that Night Owl had. If it was your kid he killed with a gun the mom bought, you'd all think differently. I believe that you can go after her civilly. You can go after those parents civilly, and that's the appropriate venue. Civil lawsuits. The state going after these parents criminally is a very bad and dangerous precedent. We're talking jail time here, and they've already been in jail for almost 3 years. So how much more time are we going to give them? Are we going to send them to the electric chair? What is the appropriate punishment for this? I've already talked about what she has lost and what they have lost, which is quite a lot. They've lost everything. They've lost their privacy. They've lost their son. They've lost their name. They've lost their reputation. They can't live where they live anymore. They're going to have to change their entire lives. What more do you want?
and now that she's lost her marriage, because
Right.
obviously all these
Unless her husband knew
instances of
about it.
I doubt it.
Yeah. I mean, what is it that you want? What kind of vengeance do you need for this? The guy who did the crime has already been tried and convicted. He's the one that did this. And Ethan Crumbley was tried as an adult. Now, this was brought up on Joe's stream the other night, which on his 24-hour stream in the second part. I think the second part.
Mhm.
They have been tried. He has been tried as an adult. So the state wants to have their cake and eat it too. They have tried the shooter as an adult, not as a minor, which means he gets a bigger sentence, a longer sentence, and he's probably going to go to an adult prison, a 15-year-old. And that also means when you try someone as an adult, that means that the state has recognized that you were with full knowledge and you made the decision to do the crime. And you had full knowledge and full responsibility. Yet at the same time, the state is also saying, except that now the parents are criminally negligent too because he was a minor in their care. Well, you can't have it both ways. And I wish that the defense attorney would make that argument to the jury. Because you cannot have it both ways. Stop trying to give the state more power to put you in jail. I know a lot of parents who have been good parents and one of their kids went off the rails. We're going to put every parent on trial when one of their kids goes off the rails? I don't think that's okay. I think that's a bad precedent, especially because I've seen a lot of good parents who have raised some kids who are not so good. And I don't know if that was their fault or if they're just some kind of genetic anomaly or something went wrong in their childhood that was not avoidable. I don't know. But I think it's a really scary thing for the state to intervene and start pointing fingers and blaming. I didn't hear any evidence in this trial that showed me gross criminal negligence. Is there civil negligence? Yes. Yes. But beyond a reasonable doubt, jail time criminal negligence? Screw that. Nonsense. So yes, so they can be held. I would, if it were my child that were, God forbid, that was murdered by somebody whose parents gave him access to a gun or didn't take the proper precautions, the proper place, the proper venue is civil court. And you better believe that I would absolutely do that. But again, we also have to consider that there are some things, some kids that do things that no one could have foreseen. And I don't see how anyone could have foreseen this except the school counselor and the school people, the teachers who knew there was something going on with him and they didn't bother to tell the parents. Why aren't they on trial? I don't understand why they're not on trial. And civilly, I would go after them. I actually am angrier at the school than I am at the parents. I would go after the school. You know me, I'd go after the government. I'd sue them. Sue everybody. Lacey Ann says, no matter how a child is raised, they still make their own decisions. That's true. And I mean, look, I as a parent, I worry all the time. Did I do the right thing? Have I been too harsh? Was I too lenient? You ask yourself these questions all the time. Do I particularly like Jennifer as a parent? Not really. I think that she was, I don't think she's doing the greatest job, but a lot of people in the chat have said I had a worse mother than her and I never killed anybody. So where is the line? Where do we draw the line that the state can or cannot come after you criminally for the actions of your kid? I would like to know where that line is, because I think that this is an overreach by the state. And if the parents of the victims wanted to get justice against the parents, then they could go after her civilly. They could go after both of them civilly. That's within their rights. It's a very slippery slope to have the state wielding their power against anybody they want. And this case has political implications all over the place. And they're actually changing laws after this. They've now made a law in Michigan. Wasn't it, Brad, you found it yesterday, that they have to, locking laws about locking up your
There's new
guns.
mandatory locking laws.
Great. Yeah, this is exactly what they wanted, was to use this case as a high-profile case to get laws shoehorned through that just take away more of your Second Amendment rights for people who are not abusing those rights. And that's what they do. That's just what the state does. Yeah, the line is where any prosecutor wants it to be after the fact. That's right. And I don't think that I don't think they should have that kind of power. Did I get this one already? Oh, no, I didn't. Hemplin, Texas, thanks for the super chat, says, and she's in solitary, chained in court, ridiculous, for buying one box of ammunition. This is not going to bring back those 4 kids. That's right. Nothing is going to bring back those children. This is not going to bring them back. It's not going to bring the families any peace. It's not going to give them any justice. This is just vengeful. That's what this is. And I understand that you want to mete out some kind of vengeance on somebody because of this horrific thing that happened. But the bigger question here, I think the bigger thing at fault is our culture. And the fact that we don't have enough security in schools, and the anti-gun lobby has successfully kept armed guards out of our schools in many places, which is absolutely ridiculous. This is the age we live in, where children are killing other children, and the adults in charge who run the schools they're the ones with the responsibility who need to actually do something to protect those kids. And that starts with having armed security guards in the schools at all times. I think they should arm the teachers. Any teacher who is proficient in gun use needs to have a gun on them at school. My brother-in-law is a teacher in Arizona. He's not allowed to have a gun on campus. Isn't that stupid? Why not? Why
Crumbley
not?
wasn't allowed to either.
Yeah, right. Crumbley wasn't allowed to have a gun either, but it didn't stop him from bringing it in and shooting kids. But you're going to stop people like, my brother-in-law, who's knows how to use a gun and would protect his students with his life. You're going to stop him from keeping a gun on him in case this kind of shit happens. That's a stupid thing to do. That's a stupid thing. It's a ridiculous thing. Sarah says, because it wasn't locked. Do you really think that a kid intent on killing other kids is going to let that stop him? Other kids who do these shootings got guns from other places besides their parents. Now, maybe it would have been harder for him to get, but we don't know. And the gun was locked in a safe. but he knew the code. So, but again, they didn't think that he was going to use it to kill anybody. So, it is a very hard topic. I grew up in a house with guns. My father said, "Don't touch my guns." And I didn't. None of us did. He'd be like, "If you touch those guns, I will wear the hide off of you." Never touch them. And my dad never spanked us or anything, but I believed him that if I ever touched his guns, that would be the end. That would be it for me. Like, I just believed him. He scared the crap out of me. And I had no desire to touch them. My dad took me shooting one time. We were like camping somewhere and he let me shoot a 22 and shoot some cans. But I was always under the impression that I was not allowed to touch any gun unless my father handed it to me, and that was it. That's it. That's the only time you can touch a gun is if dad says, "Come on, let's shoot." And I don't know what it is with kids who don't respect their parents and don't fear their parents, maybe. I don't know. This is a very difficult topic, but I think we have a lot of brokenness and a lot of broken kids in our country. A lot of broken kids. It's not the gun's fault. And I don't know how it's the parents' fault in this case. Civilly, yeah, they have culpability, but criminally, I don't think so. And that's the line you have to understand. So Sarah, I'm not saying I don't think that they had negligence in that way, in a civil way. I think they do. And I think they'd have a much easier time getting a conviction, although I have no faith in juries anymore. Not after that $83 million defamation verdict against Donald Trump for calling somebody a nut job, someone who is very clearly a nut job. I don't know how he gets an $83 million verdict against him other than a jury who just doesn't like him. And that's not justice. And I don't think this jury likes Jennifer. And I think this jury is going to return a guilty verdict. And I mean, my question as the defense attorney would be to the jury, what would make you happy? How much more does she need to suffer? She's been in prison for 2.5 years. She's in solitary. She has no son, no husband, no nothing. What more do you want to do to her? What can we do? Should we put the death penalty on the do you want us to bring in a firing squad in front of you? Should we bring in a guillotine so you can have her head chopped off? What will make you happy? I just think this has gone way too far. Yeah, the parents failed civilly, not criminally. And this case will set a precedent. It will have the state going after now every single parent of a kid that shoots anybody in a school. That's what's going to happen. If she is found guilty, all prosecutors in every state are going to do that. And I bet they'll start writing laws that say parents can be held responsible in those cases. And I think you have a very high burden that I think the state has not met. I didn't hear anything that looked like gross negligence to me. I heard some civil negligence, but not criminal. And I just don't understand how we can be doing this. Kylie needs a holiday. Thanks for the super chat. Says sending one more so we don't get mom shamed. I don't feel like shaming anybody today. All right, let's see. Chachi's mom, thanks for the super chat, says, why can't they put metal detectors in schools? Well, we had them in the 90s. So I don't know either. I mean, I don't like the fact that schools are already like prisons, so you might as well just do the whole thing. Miles Strom, thanks for the super chat. There were more warning signs in the Columbine case than this one, in my opinion. I agree. I didn't see any warning signs until it came out after the fact that the school was withholding information from the parents. The school knew about the warning signs. They are the ones. They are the ones. Who's running off my supporters? I don't think so. Everybody's still here. What do you mean? I'm losing my audience to who? I didn't see anybody leaving.
So you're saying trolls are running your regular audience off?
What trolls? Which trolls? I don't see any trolls. There are people who don't agree, and that's okay. You guys, everybody in the chat, calm down. Everybody is allowed to have their own opinion on this. I know some of you think that this family should be held criminally responsible. Some of us don't. And it's okay. We can all still be friends and have a beer together. It's okay. Nobody needs to flounce off and get upset about it. It's okay. You're all okay. You're all okay. Everybody's okay. And if there is any nasty personal attacks that I haven't seen, try to curb that, guys. Let's not do nasty personal attacks in the chat. We save our nasty personal attacks for bad prosecutors and J-Hatch. Can we keep the nasty personal attacks to people outside the chat? That would be great. I would appreciate that. If I do, I will bring in the mom shaming bell for any nasty personal attacks in the chat on each other. You know how I feel about this. We can attack anybody you want, but don't attack each other. We're a dysfunctional little family in here, but we're going to keep it at least, I don't want to tell you what not to say, but I will say try to keep it civil between each other. Okay, I want to show you the funny meme that came from locals. Maybe we can all laugh at this and forget that we were fighting. Okay, this would be hilarious. This is hilarious. Hold on. No, that's not it. Where's my locals? Here it is. Okay, we finally found something to meme about. Things I've learned from the Crumbley trial. In the Biden economy, this is the most affordable place for an affair. Affairs in bulk. The Costco parking lot.
I want to know how they facilitated that, because I've never been to a Costco that didn't have a full parking lot when it was open.
Oh, really? That's interesting. So, how do you even find a parking space for the tryst you're about to have?
Well, yeah, because there's multiple witnesses because it's so busy. Unless you're going there when it's closed.
No, but it was in the middle of the day, right?
Yeah.
It was at noon.
So, how are you going to do that when everyone's there?
This is the question I have too. Did one of them have a van? Like Jerry Seinfeld's? They had to, how are you having an affair in the Costco parking lot without a van of some sort? Can we also talk about the swinging thing that happened? That happened while I was away from the computer. Manders, thank you so much for the 5 memberships. Welcome to the Fox Den, all 5 lucky people. I like that chat. We're okay. I'm okay. You're okay. We're all fucking okay. Okay. Michael. I'm going to put that on a t-shirt. Okay. So what came out that we didn't talk about, which I thought was pretty terrible, was since she opened the door to her other affairs, it turns out that her and her boyfriend were actually, advertising for and hooking up with other people they met. What a mess. Seriously, just what a big mess. Listen, people, don't complicate your lives like this. Don't complicate your lives with all this running around on your spouse and having thruples and stuff. It's always the ones that look like Crumbley too, by the way. It's never, you notice that the people who are into swinging don't look like Cindy Crawford, if you know what I mean. And the mental image that conjures, I can't. What did her boyfriend look like? I didn't see that testimony. What day was that?
I have no idea.
Oh, let's go find it. I think it was, hold on, let's see. What was his name? Started with an M. Jennifer Crumbley boyfriend. Let's see if I can find. Oh, there he is. Okay. Oh, good Lord. Let's watch a little bit of this. What is happening?
Oh,
All
so
right.
she's begging Jeff Bezos.
Talking about the 3 different times that you spoke to the police.
Oh no, don't do that. Hold on. I forgot to check this. Okay. Come on, YouTube. Don't do this to me.
So, Lois, we were talking about the 3 different times that you spoke to.
Nope.
You can just pass it to the private chat.
All right. I'm going to give it to you. So why is this doing this to me? I don't really understand why this is happening to me.
Correct? It's fair that from the very...
All right. Brad's going to play it instead of me because I YouTube hates me. I am starting to think that I have something going on with my energy field,
fair
Brad, that
that you-
interferes with technology.
Beginning, the first time you talked to police, you told police that you and Mrs. Crumbley had had an extramarital affair, correct? You told police from the very beginning your relationship with Mrs. Crumbley involved a sexual relationship, correct?
And that dude is
so when
quiet.
you're in here testifying,
Yeah,
it's
you can
fair to
barely
say
hear
that
him.
Law enforcement talked to you about the affair right after the shooting. You told them all about it, right? I'm sorry.
Yes. Judge, I think counsel needs to be specific. She's saying law enforcement using general terms, and she needs to be specific to asking this witness question.
Well, there's a lot of different law enforcement, so it probably would be good to be specific.
Surprisingly, he is kind of handsome.
You told him that you and Mrs. Crumbley had a sexual relationship.
Yeah. Again, identify who's speaking to.
Do you recall who was the first, which officer are you talking about?
Which one am I talking about?
Yeah, the first, you're asking him
Sure.
about the first one who interviewed him. I'm assuming you know who that is. There's lots of law enforcement.
I know, which is why I have the name, but.
Okay. Do you remember who it was initially, Mr. Marsh? Okay.
Yeah, they did have history from high school, but still.
Does that sound correct? Oh, no, I'm sorry. You talked to Brian Joseph the first time, correct?
I don't know.
Okay. Okay, does it sound right if I said you spoke to Brian, to Joseph, I'm sorry, Brian, I'm saying.
Did she really just do that?
Yeah.
10, you went to the Oakland County Sheriff's Office, the Brandon Township substation.
You spoke to Brian.
You were interviewed at approximately 15:30 hours, so that would have been what? 3:30 in the afternoon. Okay, and on that day, I'm having a difficult time telling which detective it was that did that interview. It was during that interview, though, that you gave them a copy of your Facebook Messenger thread, correct? You gave it to them on a thumb drive?
Yeah.
And you specifically did turn that drive over to Sergeant Brian. Do you recall
Does she
that?
get into, fast forward this. This is so boring. Does she get into the actual affair
if I said
or not?
it was a police
Do we get to
officer
hear
or
about the
detective
Costco parking lot?
2021.
Why is it all
Yeah,
her
that is-
talking?
is
She's got a
that true?
witness on the stand and it's nothing but her talking.
Yeah.
Good Lord, lady. I mean, I know that Peter is always so nice, but this, he's like, she's not that bad. I'm like, I wouldn't want her. I wouldn't want her defending me. Hell no. I mean, it's
And you
painful.
said that you told them right away that you had had a sexual relationship with her.
Yeah.
And the fact that you and Jennifer Crumbley had a sexual relationship is certainly something you did not want to be public, correct?
Correct.
You talked to police again.
I wouldn't
we
want
talked
people to
about
know
in
either.
February for an hour. Was that also at a substation?
The second interview?
Yes.
No, ma'am, that was at a building over here, part of the county complex.
So you met them at the county complex and you had the second interview, which was just under an hour long.
Correct.
When you had that second interview, now that was in February of 2022, you told them again, you confirmed for them again, as much as you probably didn't want to, I had a sexual relationship with Jennifer Crumbley.
Yes, we get it. I begged her. Move on,
In the
counselor.
third interview, back in December, just a couple months ago, they asked you again for more information and you told them again you had a sexual relationship with Jennifer Crumbley.
Correct.
Now, the prosecution may ask you a lot of questions.
Just in the form of the question doesn't matter, but I.
Pause this for a second, Brad. I have to address something going on in the chat. Don't spam my chat with your sob stories about running out of gas. I have seen this. Now you remember the scammers who would come up to you at the gas station and be like, I just need $10 for gas. I just ran out of gas and I need to get my daughter something and or whatever. We've got one in the chat that's been here for a couple days, John Dalton, who I just hid from the channel. So hopefully we won't see him again. But he's been coming in here to say he needs gas money. And it's like, are you serious? Do you think we're stupid? Do you think we're dumb? This is one of the craziest things to try on a live stream that I've ever seen. That takes some balls to try that kind of bullshit on a live stream online. Sir, you'd have better luck if you actually go to a gas station and try the scam the old-fashioned way. But now you've been banned from my chat. So yeah, don't do that shit. That's ridiculous.
Did I tell you my scam story?
No.
So
Dying to hear it.
This would have been 2007. I was in the military, and we were on Christmas break. I flew home from Atlanta to Michigan, and I was driving my car back. So I made the long trip down to Augusta, and I had stopped at a Walmart, and might have been Tennessee or so, and I changed into my uniform, and as I'm walking out, a guy says, "Hey man, can I get some cash?" And I didn't have anything small, so I gave him like a 20 or something. I continue walking to my car. I look back, the same guy is now walking with a lady with a full grocery cart full of groceries. And I was like, son of a bitch. I'm in uniform because he was like, "Do you know how to get to like a local shelter or anything like that?" And I had my new fancy phone at the time that I had internet, and I was like, "Well, let me see if I can pull something up," and nothing was pulling up. So
Aw.
yeah, so I was really pissed about that, and it really hardened my heart to not want to give anyone any money or
Aw.
assistance.
Well, you know, my brother-in-law, he's a pastor and he gives money to everybody. And so whenever he used to come visit us in Chicago, and we would, you can't walk down the street in Chicago without being accosted by panhandlers on every corner. And every single one we would encounter, he would hand money to. And it's after about the fifth one, I said, "Ben, you've got to stop. You've got to stop this. They're scam artists." And he goes, "Yeah, I know." I'm like, well, why are you giving them your money? He said, "Because on the off chance that one of them needs it for real, I just want to make sure I give it to him." And I'm like, oh, Ben, this is why you're a man of God and I am not. Because I'm like, no, fuck you, get away from me. I don't want, I will give, living in Chicago, you do see a lot of these homeless people, and some of them are clearly like, mentally not well and hungry and whatever. And I've given food, I'll give food to people all day long. So I will walk into a McDonald's, I'll buy you a cheeseburger meal, and I will give it to you. But that's not what most of them are after. They want money for drugs. And I don't want to support somebody's drug habit. Like I just don't want to do that. I'll give you food though all day. But I've had people turn me down for food.
Mm-hmm.
So that's how it's a scam. But whatever.
My pastor buddy in Wisconsin, he would always say, "Sure, let's come in and have a talk, and I'll buy you something." And if they say no, then obviously they're not in it for it. All right.
David Nelson, there are other reasons
Over the
Megan is not a
course
man of God.
Of the investigation, you testified earlier that your answers to certain questions have changed.
Me too, Kimmy. I love those guys. I will give those guys money.
You've added, okay. But one thing you have not changed, it's not the statements about your sexual relationship with Jennifer Crumbley. You've always said you had a sexual relationship. As police came and talked to you a second and a third time, they wanted more details about where you had sex.
Brad, can you embiggen that?
Other details about those experiences, correct? Now, when I was asking you if you felt like you were threatened in any way, that had to do with feeling threatened that your job was at issue or that your benefits could be lost,
Judge, I
correct?
can object again for the question. She needs to be specific. She's going to answer something like threats. That needs to be specific.
Okay, then I'll go to the third interview. I'm sorry.
Yeah,
Be specific. Okay, I'm going to be very specific.
So the prosecution threatened him with his job.
When you
Great.
talked to them in December,
They specifically said to you, talked to you about your job employment as a firefighter, correct?
Correct.
They specifically talked to you about the details of
All
your
right, Brad,
benefits,
I gotta go.
including your
Pause.
pension,
Yep.
correct?
I have to go. I've got to get to my appointment, but I'm going to leave this stream up. Brad has an appointment too at some point, so it might just be quiet in here for a while. But if you guys want to stay and chat, Brad, you can just put the court stream back up and let that just be there for when it comes back online, and then you guys can watch it. I'll be back whenever I'm back. I've got my massage, and then I'll be back after that. So I will change the ticker on the bottom to alert people coming in what's happening. And Brad has an appointment, but when he's finished, I'm sure he'll pop back in here if he can.
Yep.
Yeah. Yeah. Is that right?
And we'll need mods to pay attention to. Oop, I think her internet just died. Oh, Megan's gone.
Your Honor, calling people versus Jennifer Crumbley, case number 222799990 FH.
Here, McDonald, on behalf of the people.
Thank you, Marquise. We got the people.
Thank you, I'm Shannon Smith on behalf of Jennifer Crumbley.
All right. We previously drafted jury instructions, and there was briefing and comment on the jury instructions. And I think it was about 2 weeks ago that I emailed a set of final jury instructions that I believe both sides agreed to.
Yes.
But I just want to briefly go over the instructions that we're giving, find out if there's any fill-ins, and then we'll have a final set of jury instructions. I'll provide these to the jury, okay? So we're gonna give 3.1, 3.2. We're taking out 3.3.
Yes, sir.
3.5. 3.6. 3.7. 3.10, 4.1, 4.3, 4.4, 4.5. We don't need any fill-ins there, that's general,
Yes, sir.
right? Okay. 4.5, 4.7.
We have not read the stipulations to the jury. I
You
don't
guys-
know if we plan to, on the keeper record stuff, do we need to?
The things that were the subject of stipulations have been admitted.
They've already been admitted, so I don't believe it's necessary, Judge.
I didn't know if the court wanted them on the record or.
It doesn't matter to me. Normally, it's advantageous for stipulations to be read into the record, for example, in civil cases with large amounts of exhibits. But if the exhibits that were the subject of the stipulation are admitted anyway, it's probably not necessary. Can you
Yeah,
take
these are just keeper of records, chain of custody. I don't think we need to.
If there's anything that was not admitted as an exhibit, there's no stipulation that doesn't involve an unadmitted exhibit, right?
Correct. Let me
Actually, I'm
confirm.
not sure about
Okay.
that.
Okay, so anyway, 4.7, 5.2, 5.3. What about 5.8A?
I don't think that was
No.
used
Out?
at all.
Out, right?
Oh,
Yeah.
Thank you, Judge.
Okay, 5.8A is out.
5.10 needs to be amended.
Oh, okay.
Detective Wodrowski was an opinion, or was an expert, but I don't believe there were any other experts admitted, were there?
No, the two medical examiners did not testify.
Sean Bryant, Pacris and Bryant. are
Yes,
out.
sir.
We stipulated to their autopsy
Right.
reports.
So it's just Wodrowski, correct?
Yes, Judge.
All right. 5.11, 16.10. There's several of those. As to count one, 16.10 as to count two. That's involuntary manslaughter. Instruction 16.10 as to count three. 16.10 as to count four. There's a unanimity instruction that is based on an adapted from 20.30. Non-standard civil jury instructions, and the parties agree to that instruction.
Yes, sir.
Correct?
Yes.
Yes.
Okay. 16.13, involuntary manslaughter, failure to perform legal duty. As to count one, 16.13 as to count two, 16.13 as to count three, 16.13 as to count four, as to count 16.15.
Just one instruction for 1615.
Say it again?
Just one instruction for
Yeah.
1615.
I was trying to see, I think there were some things added, there was a foreseeability excerpt.
Yes,
that was
Judge.
agreed upon.
Yes, Judge.
Okay. Yep, yeah. That's non-standard, but agreed to by both sides. 16.18, gross negligence. There's an instruction about not using the shooter's name, maybe I should get rid of that one. 3.11, deliberations and verdict.
Yes.
3.13, which is possible penalty. 3.14, communication with the court. 3.15, exhibits. 3.16, written or electronically recorded instructions in the jury room. 3.20, single defendant, multiple counts, more than one act. 3.23, with regard to the verdict form, and then there's the verdict form that's standard, right?
Yes, Judge.
We have obtained a computer that would accommodate the thumb drives that's going to be in the jury room. Anything else you can think of?
I don't think so.
Your Honor, I don't have a thumb drive with mine. I just have mine. I just have a
Okay.
hard copy.
Oh, that's good. We'll send it all in. Okay.
Thanks.
Anything else? We're gonna make those minor amendments. Anything else at this time?
No, Judge.
I don't think so, Judge.
Okay, so we'll be back in about, well, we're gonna take her back down, aren't they? Okay. We're gonna take her back down and I'm gonna ask them to bring her right back up, right? It won't take long. Okay, yeah, the jury instructions are ready. I think I'm gonna give you each copy of the jury instructions just to be sure that we've done it accurately, all right? And these will be the instructions that go in with the jury as well.
Thank you, Judge.
Okay. At the moment, after closings, I'm going to eventually instruct them. I am going to have all 17 come back Monday, right? Does that make sense to you?
I think we'll get through closings and they could start deliberating.
I'm concerned about that. Are you not concerned about that?
No, Judge.
You want to approach? Well, if you can. All right, do you want me to bring the jury in now?
Sure.
Yes, please.
One moment, we're just waiting, having some.
Just take 1 second to set things up, Judge.
Ms. Williams is going to print a copy of the jury instructions for you, just to be sure. All right?
What's that?
We're going to print a set of the jury
Oh, sure.
instructions and then review those, just to be sure that they're accurate before I send them in. 5.88 comes out. 3.3 comes out. Yeah. And then the expert witness is only one box, so the other two.
Just one moment, Your Honor.
All right, for the jury.
Ladies and gentlemen, you may be seated. Ms. Smith, am I correct that you rest?
Yes, thank you.
Prosecutor, any rebuttal?
No rebuttal.
Ladies and gentlemen, the evidence in this matter has been concluded, and now that we hear closings, I want to remind you that closing arguments are just that. They are how each side sees the evidence in the case. The closings themselves are not evidence. Because the prosecutor has a burden of proof, the prosecutor also has a right to rebuttal after the defendant's closing. Right? I think you're going to hear certain elements again of the crime charge, the crimes charged, and I'm going to be giving you written jury instructions that list those, just so you know. Right? Prosecutor.
Yeah, it always seems like a good idea, but. Sorry, can you do my mic? Just like right here. So this
Go
is good.
forward pretty far.
Can you help me?
When would you like it?
Just that way.
You want it still facing this way?
I want it like almost in front of the witness box. Sorry about that. Okay, thank you. Good afternoon. We told you in jury selection it was going to be 3 weeks, and it's now been 2 weeks, so we're a little bit ahead of schedule. This is our time for our closing argument, and I'm going to spend some time going through the evidence, and I'm going to spend some time going through the elements of the crime. I want you to know that I've been watching you diligently, taking notes and listening. So what I'm not going to do is spend a lot of time repeating everything that was said from the witness stand, because I know that you all listened. And I also want you to know that I really appreciate that. And I know the court does too. I told you during jury selection that it wasn't going to be easy. And it was not easy. Listening and watching and thinking about 4 young kids being gunned down in their school is not easy. You listen to every witness, you examine the evidence, And I suspect that many of you feel the way that we do, that it's difficult. But we owe it to the victims and their families to say what really happened. And you've listened and you've done that. In our system of justice, we have different roles to play, and each role is different. There are people who think it's the prosecutor's job to convict people. I don't think that's the prosecutor's job. I think my job and our job is to present the evidence and the facts and tell you the truth. And telling the truth sometimes means showing you things none of us want to see, some of us don't agree with, some of us don't like. But I believe that that's my job. We don't pick or choose the very best things, because I believe that you should have the truth. And I believe that it's not my job, nor is it right, to sanitize what happened in that school that day. Because if we don't tell you exactly what happened, then you don't know all the facts and you don't know what the truth is. My job here, our job, that I believe we have done, is to meet our burden to prove that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter. The burden is high. I told you that during jury selection, but we embrace it. And I believe that we have met that burden. It means that you had to sit and listen to a lot of very emotional things, a lot of emotional people who sometimes aren't emotional, but were emotional for this. Because what happened on that day, every single person in that building had never experienced anything like that in their entire lives. And I hope to God they never do again. So you did see a lot of people, including law enforcement, become overwhelmed with the emotion of it all. That's not a show. That's just how that was. That's how it felt that day and every day after. So I want you to know that there was no picking and choosing the very best evidence to give you. There was no filtering things out that didn't help our case. I showed you everything. And I called witnesses to the stand to say things I knew you probably wouldn't like. But my job is to give you all the facts. But my job is also to prove beyond a reasonable doubt that Jennifer Crumbley is guilty. And I believe we've done that. The defense also has an important job: to advocate and argue for their client. And they decide how they want to do that. And of course, the judge plays an important role. Her job is to call balls and strikes when two sides disagree, to make a ruling, and then to tell you what the law is. And she's going to do that as soon as we conclude here. And then there's your job. Your job is to decide what the truth is, what really happened, what are the facts, and then take those facts and find the truth and apply the law. The judge is going to give you instructions about the law, but I want you to go over what you now know, and I want you to think about it. And we're going to go over some of the evidence. But I also want to remind you that you're allowed to use your own observations and your own insight. And if there's something that you notice from the witness stand that I didn't say, you should rely on that. We can't possibly tell you every single little thing. And sometimes, ladies and gentlemen, the most important things are the things that don't get said. The most important things are the way the victim or the witness spoke, the way they answered a question. And I encourage you to rely on your own perceptions of that. I want to start out by talking to you about the elements of the crime. Involuntary manslaughter, she is charged with. This case is based on 2 theories. You're going to have all this in their jury room, but hopefully I'm going to explain it so well you will have no questions. These are dependent on 2 specific theories. One is the gross negligence in the performance of a lawful act, and that gross negligence caused death and in doing so, the act that caused death, defendant acted in a grossly negligent manner. The second is the gross negligence in failing to perform a legal duty. One, I have to prove that she had a legal duty to the victims. Two, she knew of the facts that gave rise to the duty. Three, she willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And then four, the death of the victims was directly caused by defendant's failure to perform this duty. Causation. The judge is going to instruct you, maybe more than once, and I'm going to say it, that there may be more than one cause of death, and it's not enough that the defendant's acts made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's actions. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Meir, Hannah, and Justin. And as previously noted, there may be more than one cause of death. And defendant's acts or inactions need not be the sole cause of the harm. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting these four individuals was reasonably foreseeable. Now you look at that, all of that I have to prove. And it seems a lot. It seems like it's going to take a pretty strong case to prove that. It's going to take some pretty egregious facts, some unique, egregious, incomprehensible facts. And that's what we have here. Gross negligence means more than just careless. It means willful disregard of results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you have to find the following three things. One, that she knew of the danger to another. She knew there was a situation that required her to take ordinary care to avoid injuring others. And second, that she could have avoided injuring another by using ordinary care. Third, that she failed to use ordinary care to prevent injury, and to a reasonable person, it would have been apparent that the result was likely to be serious injury. I told you there are two theories. We're prosecuting and charging based on two theories. They're both based on a legal duty. What's a legal duty? In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child, to prevent that child from intentionally harming others, or prevent that child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. We talked about there's two alternate theories. Both of those theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven. And as long as you all agree that we've proved at least one of those theories beyond a reasonable doubt, you can find her guilty. I want to take you through the testimony. I'm not going to get into every single detail of each of these witnesses' testimony, because I know that you were listening and you were writing. You heard from Molly Darnell. Molly was a teacher in the school that day. She was in room 224. And she saw the firearm when it was raised, shoulder height, pointed directly at her. And what she noticed was there was no orange tip. You also heard her say that she locked eyes with Jennifer Crumbley's son as he was taking that stance. You heard her testify that she jumped to the right, thank God, just in time, because the shot in her shoulder that she sustained was only inches from her heart. The next witness you heard from was Christy Gibson Marshall, who's an assistant principal at Oxford High School. I don't think there's one of us that would disagree that Chrissy Gibson Marshall did the most dangerous thing she could do. And she did not follow the protocol. It's probably one of the most courageous things I've ever seen. She walked to the shooter. She saw a student on the floor. And then, when she finally came face to face with the person who had shot this student, she didn't move. She just stared at him. And he didn't shoot her. She testified that she knew him. She was his principal in middle school. And she just couldn't believe that he would do something like that because she knew him when he was in middle school. You saw the video of that day and what happened. And he just kept going. And even after he left and she had no idea where he was going, she didn't go hide anywhere. She didn't keep herself safe. She bent down to render aid and assistance to that student. And when she rolled him over, she realized it was Tatemir. We all know that she didn't and wasn't able to save Tatemir. We heard from Cammie Batt, who sold the Caltech and the Derringer to James in June of 2021. She also sold the 9mm 6-hour to James with the shooter present on November 26th, the day after Thanksgiving. She testified that James came in and pointed right at the SIG and said he's had his eye on it. She walked us through the process of purchasing a firearm. She talked about the trigger lock statement provided to James upon purchase and the cable lock provided with November 2021 on that gun purchase. Next, we heard from Special Agent Brett Brandon, who's sitting right here. You heard that when he was informed about the Oxford shooting, he left so quickly that when his partner came back, his chair was still spinning. And he raced and drove up there as fast as he possibly could because it was very much his own community. You heard he went right in and he found Lieutenant Willis and he said, do you know where the gun is and do you know where it came from and do you need help? And so he was responsible for finding out where that gun came from, which he did. He was also responsible, because he chose to be, and watched the surveillance of the video and helped to prepare search warrants. And you heard him testify that as soon as he saw that surveillance video, the one thing that stuck with him is this is not an inexperienced shooter. This is a shooter that knows that is proficient with a firearm, knows what he's doing. Taking shots, a lot of people wouldn't. And what he did was start going to gun ranges and ask people to say, because what he was thinking was, who taught that kid to shoot? He must have been to a range, and he was right. And that's how the investigation led to where Jennifer Crumbley's son learned how to handle a firearm that eventually resulted in killing 4 students in Oxford High School. Can you go back to that? Special Agent Brandon also testified that and showed the purchase and we showed you each one of those guns. He testified that there is a distinction between a Derringer, a Caltech, and then the 9mm. And what we really heard from him was that 9mm is a much more dangerous gun. It causes more damage to whatever it hits. The bullets are a larger caliber, and it's a very dangerous weapon. He showed you what comes with every gun purchase, which is the ATF pamphlet. He read to you about the warnings. There's a reason they put it in every single gun purchase. And its sole purpose is to protect kids from gun violence deaths. He talked to you about what a trigger lock is and the trigger lock statement. He showed you the Instagram post that's unforgettable. We don't have to really argue about whose gun that was. Jennifer Crumbley told us whose gun that was. She told us when she posted on social media, it was his Christmas present, and she told you in this trial. That weapon is not just that weapon. It is the defendant's son's gun. It was gifted to him. And not only was it gifted to him, she bragged about it on social media before the shooting. Special Agent Brandon also introduced all of the surveillance and the videos of the shooting range. And you got to see with your very own eyes the training and the preparation that the shooter ultimately used to kill 4 of his classmates. We all saw that. We actually saw the last day he was practicing to kill 4 of his classmates. And there was only one person with him, ladies and gentlemen, and her name is Jennifer Crumbley. And I want you to remember that video. And I want you to remember the look on his face when that target comes back in and he looks at it and he's smiling. Special Agent Brandon also introduced the worksheet. You've seen the worksheet a lot. I bet you that worksheet's burned in your memory and I wouldn't even have to show it to you. But what Special Agent Brandon testified to and showed you is that wasn't just a picture of any gun. It was a picture of his gun, which was the murder weapon. And he showed you the details, and we're going to talk about that later. And next we heard from Ed Rogrowski. We now just call him Ed because he works for the Secret Service. And he testified for an entire day. And he had a lot of information. But he also really couldn't help himself from becoming emotional. And I know that you're going to remember this, but what an extraordinary thing. That's just not seen very often. He sat right there and he took you through every single action of the shooter and every single death from his memory. And he told you that he could do that because it's burned in his brain. These are seasoned law enforcement. This isn't an act. They hate showing emotion. He probably will never forgive me. Lieutenant Willis tells me all the time how much he really hates me for that.
I would object.
It's my opening. It's my closing.
To what a witness tells her all the time. That's not evidence.
I'll move on. Nobody likes doing that. Nobody likes doing that. But it tells you something about what it was like that day. And despite what anybody will tell you, it is about the shooting. There are 4 counts of involuntary manslaughter. It's very much about the shooting because the shooter learned how to shoot and was given the murder weapon by his parents. And this parent is sitting here today on trial. Okay. You'll be able to review the evidence. It was a lot. But he talked to you about what cell phone extractions are. And because of the cell phone extractions, we have a mountain of evidence that you saw. And yes, it's a lot of data. But you know what else it is? It's telling you exactly where the defendant was, who she was talking to, what she did, what she didn't do. And you can't hide from that. She tried. There's a lot of deleted messages, which are not coincidental. I don't think any of you believe that, but I'm going to tell you why they're not coincidental. He also talked to us about and showed you the messages between Jennifer Crumbley and her son. The messages between her son and his only friend. He introduced the voicemail that Jennifer Crumbley received the night before the shooting about looking up bullets. True. Pam Fine didn't tell her to call back. That's true. And she didn't call back because she didn't ask for a call back. We all know what she did do with that information. What she did do with that information is she texted her son, searching bullets. And we all know the phrases that we'll never forget. Did you show him your gun? This is the day before the shooting. Did you show him your gun? And the shooter responds, no, my God. LOL, I'm not mad. You just have to learn not to get caught. Kira Pennant testified that she knew Jennifer Crumbley. She testified about the amount of time that Jennifer Crumbley and James Crumbley spent at the barn. She testified about all the money they spent at the barn. Why is this important, ladies and gentlemen? It's not to show you that somebody's a bad person for liking horses or spending a lot of money on horses. It isn't. And it's not to say that somebody should spend every waking hour that they're not at work at home with their teenager. That's not the purpose of this evidence. The purpose of this evidence is to show you what Jennifer Crumbley cared about the most and what she was doing and where she was when her son learned to be a killer. Kira will tell you that she referred to her son as an oopsie baby and said he was weird. She rarely saw him. And that even after the one friend was taken away abruptly with no notice, they still went to the barn even at night and left him by himself, which is absolutely normal to leave teenagers at home by themselves, unless that teenager is showing signs of mental crisis and that teenager has lost the only person in the world that he has. And then she told us that when she got the worksheet texted to her that day by Jennifer Crumbley, she was very concerned. She was alarmed. And in fact, she said, bring him to the barn. And you also saw from the text messages that Jennifer Crumbley said, he can't be alone. We know now that decision, that statement, she knew he couldn't be alone. She didn't decide to stay home with her son. That wasn't an option. She'd have to take him to the barn, where she herself testified he didn't want to go. You heard from two people who were at that meeting that day, Sean Hawkins and Nick Ejab. I'm going to tell you right now that this is not an argument that the school did everything they should have done. I'm not going to say that to you. I'm not going to tell you that I like everything they testified to. I'm not going to tell you that I think it was okay they didn't look in the backpack. I don't think it was. But this is about Jennifer Crumbley's actions. And any attempt to make it about what these two individuals did or didn't do, like it or not, who did not have any of the information that was so jarring, it's about what she knew and what she didn't say. Sean Hawkins testified that he was concerned enough that he called Jennifer Crumbley. And her first response is, can you call his dad? Eventually, he emails her both copies of the worksheet, the original worksheet and the worksheet that was scribbled on. And she eventually comes to the school. But before she comes to the school, she texts her husband, emergency, along with, I'm very concerned. And James texts back, WTF. They're concerned. For the first time, she testified ever, they're called to the school in the middle of the day and they have that worksheet. Sean Hopkins is going to tell you that calling parents in the middle of the day and asking them to get a kid help is a pretty drastic action. And that he did in fact do that. And he gave them the list of places to call. He testified that when they entered the room, Jennifer Crumbley didn't greet her son. Jennifer Crumbley didn't hug her son. Jennifer Crumbley didn't engage with her son at all in the entire 11 minutes she was there. And we know she wasn't going to be in that school very long because she'd already told her boss she'll be back by 12 or 12:30. Doesn't leave a lot of time for the meeting at the school. It's a 20-minute drive. Sean Hopkins will tell you that what he felt mostly in that room for the shooter was compassion. He didn't want him to be alone, and he felt really bad. And he also knew mom and dad decided, no, we can't take it. We have to go to work. They said that in front of their kid. He knows very well what they do. He knows his dad works for DoorDash. He knows his mom and her ability to work flexible hours. She worked at home. But they left. She did not hug him goodbye. She did not greet, touch, or even acknowledge him. And we know now from her testimony, we know why. She was mad. She was mad at him. She did not think that he should have done that, and she thought this was a discipline thing, and she was very angry. We heard from Nick Ejek. He's the dean of students. He also testified and corroborated what Sean Hopkins told you, which is that the meeting was called. They were concerned about a mental health issue. They told mom and dad he needs services. Here's a list of the services, and Jennifer Crumbley seemed irritated by it. In fact, when she walks into the room, she doesn't sit next to her son. She goes back here and stands. And that meeting ended with her saying, "Are we done here?" They're consistent about that. Nick Ejek testified he didn't think there was any risk. I don't like what he said, and I knew he was going to say it. But it's not my job to put witnesses up here and only say things that I want them to say that helps my case. It's my job to present evidence that's the truth, because you have to know the truth. Sergeant Joseph Bryan is the first law enforcement that had contact with Jennifer Crumbley and her husband right after the shooting. And you saw the interview in the substation. And you saw the demeanor of the defendant. I want you to remember something. It wasn't even an hour. It was around an hour after the shooting took place. She's on her cell phone. She's looking to see if it's on the news, she said. We also know that there were deleted messages. We don't know when she deleted them, but we know there were messages deleted after the time of the shooting, from the time that the phones were seized later that night. He asked about the gun, and you heard what she said, what they both said. It was hidden. It was hidden. She read the text message. Oh, he said he loved me. And she reads the text message. And then she said, I texted him, I love you back. It was 49 minutes later that she texted, I love you back. And it was after she already knew that he was the shooter. She doesn't say what the text after that is. She leaves that out. The text after that is, Ethan, don't do it. She doesn't say, well, we were at the school, but he was also caught searching bullets that night, the night before. She doesn't say that, and I told him, don't worry about it, just don't get caught. She doesn't say that they had just purchased the weapon and it's not secure. What do they say? The very first time they are asked about what Jennifer Crumbley's asked, where was this gun? The very first time, what did she say? It was hidden. She does not say there was any locking mechanism at all, and neither does James. It was hidden. You're at the police station. Your son's in the next room. You know the murder weapon was the weapon you just purchased for him. And when you're asked where it was, you say it was hidden. We also heard from Andy Smith, who was Jennifer's boss. He testified she could have absolutely gone home. She works from home, and there's flexibility, that they have kids that come to work, that the meeting that she wanted to get to was not in any way mandatory. And he testified about some very bizarre communications. He testified that as soon as she left, he got a text saying, my son, the bullets are gone, the gun is gone. He must be the shooter. Oh my God. Those were deleted by Jennifer Crumbley. We don't know why. I think there's a lot of circumstantial evidence to suggest why, which is those are statements you don't want on your phone. And then, not 3 hours after her son shot and killed 4 people, and he's already in custody, and it's already clear that he is probably never, ever, ever going to be out of prison for the rest of his life. She's texting, don't judge me based on what he did. I need my job. Her explanation for that, she was in planning mode. The next witness is Amanda Holland, who testified that she came back to the work that day. She had the worksheet. Andy Smith also said she before the shooting occurred, she was down, she was sad. I feel like a failure as a parent. I feel like a failure as a parent. This is before the shooting. And she also tells Amanda about this, and she tells Amanda he can't be alone. So I'm just going to take him to the barn tonight. We can get to it a little bit later. I guess what's really hard to comprehend is how before the shooting, just based on the meeting and what she knows and the drawing, she thinks she's a failure of a parent. But she sat right here and said, after all, she doesn't really think she was a failure as a parent. And that's after she knows everything that happened. Detective Adam Stoyak executed the search warrant at the defendant's home. I want to make it really clear. Jennifer Crumbley is not being charged with involuntary manslaughter because she has a dirty house. That's absurd. And you can see pictures so we can prove that she didn't have her house clean. I don't care if her house is clean or not, and I don't think you do either. Those pictures are shown to you because that is where the shooter lived and it's where she lived. And you saw his 2 bedrooms. There was barely a place for him to sleep. The testimony shows he had no person in his life after that friend left. He was not in a club. He was not in sports. He wasn't working. When I see those photos, what I think is, yeah, 2 rooms that were completely filthy, dusty, covered with clothes everywhere. But then I think, what? That is where he spent 99% of his time. It's where he ate Thanksgiving dinner, just days before the shooting. The search warrant photos were also shown to you so you could understand where these guns were stored. We have a pretty good idea that the Kel-Tec and the Derringer were in what's called the gun safe. The lock was 000, but we know that they were kept there. What do we know about the SIG, the Jennifer Crumbley's son's gun? We know that there was a box on the bed and the ammunition next to it. This is the box. This is the box. I'm sorry, this is the thing. Can you get that other copy? He's going to show you in a minute. This is the box of the telephone, which was found with this cable lock inside of it. Where she kept the other guns? No.
I'm sorry, is that the box or the key? Is that the box or the safe?
This is the box. What's the box? It was in the kitchen, in a cupboard, down
I'm sorry,
in the
but
cupboard.
the empty box was in the kitchen, right?
What exhibit
Your
number is
Honor,
that?
this is my closing argument, and I would just like to finish, please.
Sure, can you tell us what exhibit number it is?
Yes, it is 35.
Go ahead.
This was found in the kitchen. Inside is a cable lock. This was found on the end of the defendant's bed. Special Agent Brandon showed you what it's like to open this up and close it. You hear that clap? It's not an easy thing. So what this is laid out on the defendant's bed, and the bullets are right next, the box of the ammunition is right next to it, empty. The story, one of these stories that is told by Jennifer Crumbley is he must have come in there when they were sleeping, because she was in that bed all night long, and they left after her. Except that the ammunition was in the box. Taking it out and leaving the box while your parents are sleeping doesn't make a lot of sense. And it doesn't make a lot of sense that this was taken, the weapon was taken out of this case with no one hearing while they were sleeping. And you are allowed to use your own common sense. He also testified about the search warrant. He testified where this cable lock was found, and he testified where the case and the box was found. And he testified where the gun safe was found. It was not, unlike what Jennifer Crumbley alleged, stored separately from the ammunition. It was actually right next to the ammunition. In a gun safe, the other two guns with a combination 000. Sergeant Peschke arrives at the scene, doesn't know anything about the Crumbleys, doesn't know that they've already been to the substation, doesn't know that they were at the school that day. He's there and was ordered to be there to keep the house safe while they are waiting for the search warrant. And in doing so, he needs to keep the defendant out of the house. She goes in the back of the car, and you saw the video. She now tells Sergeant Peschke she actually never really looked closely at that worksheet. Now that she looks at it, it might be disturbing. We know that's not the truth. The question is, why is she lying? She says that the .45 caliber gun used at the school, and he asks if it was, and tells him no, it was a 9mm. The other is a 22, I think. She said that they had a fight the night before with her son over grades. And she says, so we told him, no gun range, no phone. Those are his trigger points. Ladies and gentlemen, that phone was never taken away from her son. We know that. We know that because he had it the night before and he had it at the school. We know that because when Jennifer Crumbley was asked about it and asked, when did you take this phone away? We know that he made that video in that shed about the school shooting with his phone at 10 o'clock. The phone was never taken away. Why is she saying that? I don't know. Then she says, my biggest fear was that he turned the gun on himself. And when he asked her, do you ever keep guns in your car? Here's what she did. Shook her head. It's not what she says here today. Next, we heard from Bob Patelis, who processed the scene. And you saw those pictures, and they were hard to see. He told you that there were 32 fired cartridge casings. He collected all that evidence, took all the photographs, and recovered the murder weapon. Lieutenant Marsvan was also at the school that day. And he testified that he picked up the phone and saw the screen and saw that the last text was, Ethan, don't do it, from Mom. He executes search warrants for all of the devices and the home and sends a team, including Officer Peshke, to secure the house before the search warrant is executed, which is what they do. He testified that when he went into the house, he finally got there and he needed their phones. And he testified that Jennifer Crumbley said, no, I don't want to give you my phone. I'm not giving you my phone. She finally relents because her husband says they're going to get it either way. And then she doesn't want to give the passcode up. She doesn't want to give the phone up. But the most important thing that Lieutenant Marsman said is when he described how he had to identify the body of Hannah in Madison that day. Dave Hendrick is retired, but he's the former sergeant in charge of the fugitive apprehension team we call FAT. And his job, his only job, when he was doing that, is to find people who have felony warrants and haven't turned up. He has a lot of ways to figure that out. But he was asked to find Jennifer and James Crumbley to make sure they turn themselves in. But one of the other primary goals he has is that they turn themselves in safely. And she was given every opportunity to do that, and she did not. I want to talk to you about something. The judge is going to instruct you that you can consider flight. It's not an element to the crime. I don't have to prove that they fled. The reason we introduce this evidence is she's going to instruct you that you can use that as a sign of consciousness of guilt. What do you do if you know you've done something wrong? You can use that to show consciousness of guilt. And we're going to get to it, but I believe we have shown that beyond a reasonable doubt. He's going to tell you that the defendant with her husband immediately began to avoid detection because they're pulling cash out. They're pulling cash out of their son's bank account. They're pulling cash out of their bank account. Where's their son during this time? He's at Children's Village being arraigned with his court-appointed lawyer, where they had the opportunity to go see him, or the opportunity to go to that arraignment, and they did not. Because they never even went, they fled their house and went to a hotel, and then they ended up at an extended stay, and that is where they ultimately left one of the Kias, backed into a parking space. He's going to tell you that he eventually did apprehend the defendant. You've heard a lot about that. And he's going to tell you that there were hundreds of law enforcement officials on the scene when she was apprehended. Luke Kirtley, I know you will not forget him, coincidentally knew a lot about cars and coincidentally pulled into that parking lot right about the time and coincidentally had just seen the wanted poster, he called it, and with a description of the cars and a photo of the defendant. And coincidentally thought, maybe that's the car. And he watched the video where he goes around and he sees the license plate and he plays it cool and slowly walks into the building and then makes the call to 911. He describes to you how within minutes, police officers arrived and then swarms of law enforcement arrived, SWAT, the marshals, ATF, the sheriff's department, Detroit PD, all sorts of law enforcement show up immediately. He also testified that the unit where Jennifer Crumbley was actually found was very close to his, and it faced the parking lot, and the whole wall was windows, and it was on the first floor. And he's going to tell you that the whole parking lot was lit up with law enforcement, lights, sirens, all kinds of things. Next, we heard from Corporal David Shaw, and he testified that once he got there, they took a 35-pound ram to breach the door, which was right outside the unit where the defendant was found. We heard from Brian Deloche. Also, didn't love a lot of things he has to say, but you deserve to know the truth. And the truth is, like it or not, this is who Jennifer Crumbley spent her time with. And she told him that morning, the gun's in my car, and I'm afraid my son's going to do something stupid. Before the shooting, the same day. You've also learned that although their Facebook thread in general was always deleted, after the shooting, it remained, except she deleted, not unsent. Rely on your own memory about what that testimony was. Those were not unsent messages, they were deleted. And you heard Ed Rogrowski tell you that. But these were the two that were deleted. On the run again, and we're fucked. William Freer testified what was found in the building and the art studio where Jennifer Crumbley was found. You saw the photographs. You learned that there was a little over $6,000 in cash. You learned where the phones were found, and the cash, and the purse, in the plastic tub, in another plastic tub with a lid on it, feet away from where the mattress was, and there are other things where you learned all those phones were off. He also testified what else was found. Booze, orange juice, ice, and avocado, bananas, socks, blankets. And that is the room where Jennifer Crumbley was ultimately apprehended. You heard from Lieutenant Lewis, who was the officer in charge. He told you what it was like in the school that day. He described the autopsy protocols that were done and how each of those kids died and where they were shot. He told you that both Justin Schilling and Madison Baldwin were shot in a contact wound, which means the gun was either very close or actually touching their head. He showed you the video of the shooting. And again, this is not to incite emotion. The video of the shooting shows Jennifer Crumbley's son taking a stance he clearly knew how to take and was trained to take. And you watched his demeanor and the calculated, cold way he proceeded through those hallways looking for people to shoot. You saw the surveillance of how he ultimately surrendered. Walked out after executing Justin Schilling, laid the gun on a wastepaper basket, made it safe, took the magazine out, and surrendered. He showed you and introduced the bank records that show you what they were doing after charges were either very soon coming and after they were announced. And he showed you an in-car video of Jennifer Crumbley and her husband, who just a few hours after the shooting embraced, kissed, whatever happens, I love you. Don't say anything to the police. One of the elements we have to prove is what a person using ordinary care would have known about whether or not there was a situation that they needed to exercise ordinary care. So the defendant's knowledge about her son matters, but it's two different stories. It's what she knew before the shooting, and it's what she said she knew after. Before the shooting, she tells Kira, my son's weird. She always refers to him as an oopsie baby. She tells Amanda Holland he's lonely. He's hearing things around the house sometimes. She says, I'm a failure as a parent. The message to her son's friend's mother, he's kind of depressed in April. She texts that. And then the messages from her son. the messages in March about he's seeing things. Things are flying off the table. Now she wants to tell you that was just a joke, but I think you really need to consider whether a 15-year-old boy is going to text, could you at least answer me or reply to my text, as a joke. And we know there were no replies. There were missed calls. He called her. There were no replies. And she told us why. He was just messing around. But after the shooting, in the in-car, we hear her say, he's never been in trouble. He's never done anything. He's never done anything wrong. He's a good kid. Also in car, I never even thought like he would have any mental issues. Like he never exerted any type of anger. He's never exerted anything. He's just like one of those mellow, laid back kids. In the substation, he's never done anything. He's never done anything bad. After the shooting to Brian Lowe, she's never done anything wrong. Jennifer Crumbley has said a lot of things about that drawing and that meeting at the school. She sent the drawing to James, and Kira and Andrew, as I said before, with the call now, emergency. She told Kira he couldn't be left alone. She tells Andy she needs to get him counseling, and she tells Amanda that the drawing was really scary. She agrees. After, this is what she says in the substation. Nobody didn't seem worried about it, and he said that my son's more than welcome to stay at the school, or he could go home. And I really wish we had taken him home. In the in-car, she said, I didn't even look at that closely. Now that I do, when I was at the substation, I looked at it closely, which we know is not true. I looked at them closely, and they're a little disturbing. Well, they're very disturbing because look what he just fucking did. And then to Milo, she says, the school was very nonchalant, but the paper they showed me had all of the things scratched out. That's just not true. It's just not true. And you don't have to believe me because we have evidence it's not true. And you heard it. The statements about the gun are also numerous. She said, we've heard her testify the gun was in her car. We know that she's acknowledged that she drove to the gun range. There was no lock on the gun when she drove there. She returned with the gun. There was no lock on it, but she said James locked the gun when he got home. She didn't see him do it. She testifies at trial. James is responsible for the gun. In the substation, though, when asked where the gun was, hidden. In the in-car interview, James flew home and he's like, I had the gun hidden and I told him where I hid the bullets. He asked whether she kept the gun in her car. She shakes her head no. And she tells Milosh, after, the next day, we had the screen lock on it that came with in the case. Everything was secured, not loaded, bullets stored separately. Oh my God, oh my God, oh my God. That is not what she says in the substation. Jennifer Crumbley begins distancing herself from her own responsibility about the gun. You heard her testify that they wanted to get the gun. It was my son and my husband. My son did a lot of research on the gun. I guess when I was shopping. She doesn't say she didn't know. She doesn't say that she didn't approve. She says it really interfered with going to get Christmas trees. That was what she was upset about. And she said, it's James's responsibility. However, as I've shown over and over, at the substation and in the car, it's we. It's we take him to the range. It's our hobby. We go to the gun range. That's what we do. We just got him this gun. Sitting here today, it's all James' fault. It's not ours. And then, of course, the statement that we don't really have to question whose weapon it was. Jennifer Crumbley posts, Ethan and James Crumbley both got handguns this week, testing them out at the range. That's in June. The evidence really shows that the shooter owned 2 guns. But for sure, she acknowledges Mom and Sunday testing out his new Christmas present. You heard evidence that was presented to you about the journal that was found in the bathroom by the shooter's backpack, right before the bathroom that he exited and started shooting. I have zero help from my mental problems, and it's causing me to shoot up the fucking school. Next slide. First off, I got my gun. It's an SP-2022 Sig Sauer 9mm. The shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this. So yeah, I'm going to prison for the rest of my life, and many people have about 1 day to live. One of the things I want you to ask yourself when you go back in that room is why, after hearing that there's an active shooter situation and knowing that your son is involved, you are taking the time to delete text messages. And look at the messages that were deleted. We're on the run again. Helicopters, not sure where to. I'll message you, and we're fucked. Deletes, the gun is gone and so are the bullets. Oh my God, Andy, he's going to kill himself. He must be the shooter. Ethan did it. Those were deleted from her phone. She deletes all of the things she says about the drawing to Kira, including making sure that she still was going to get her lesson that night. This is the timeline from when in March, which you've heard a lot of testimony starting in about March, was where we first have evidence that he was struggling, he was hallucinating, he was seeing things, and he wanted her to text back and she didn't. We know that he had some incident, and he said that the mental breakdown in April. You saw text messages between James and Jennifer saying, did he say anything about last night? He woke up in our bed, he didn't know where he was. We don't know what that was about, but we certainly know that that is not evidence of somebody who is completely fine and stable. In fact, lots of messages from Jennifer Crumbley saying, I'm worried he's going to do something stupid. In April, she texts her friend that she thinks he's depressed. The Caltech and the Derringer was purchased in June. They go to the shooting range in June. They go to the shooting range in August. They go to the shooting range in September. And then in November, they buy the Sig Sauer. And we see the shooting range that Jennifer Crumbley went to with her son, testing out his new Christmas present. Here's what we learned Jennifer Crumbley did after the shooting. As soon as they took her phone, they bought burner phones in the pier at 8 o'clock the night of the shooting. They checked into a Holiday Inn Express that night in the pier. They then left and went to an extended stay in Auburn Hills, which Lieutenant Willis testified was almost across the street from the police department. Upon learning that charges were possibly coming, and the same day charges were announced, they leave that hotel and drive to Detroit. They withdrew $2,000 from a Flagstar Bank on December 2nd. They drive to Owasso, an hour away, she says, because we just didn't want anyone to recognize us, to buy replacement phones. She texts that she's on the run again. Helicopters are not sure where, I'll message you to, at 7:31 a.m. on December 2nd. She texts on December 2nd, we're fucked, at 2 o'clock. On December 3rd at 4:59 a.m., she texts, I'd rather die than go to jail. Then she withdraws $4,000 from another Flagstar on December 3rd. She checks out of the extended stay on the 3rd and drives down and arrives at Bellevue at 10:58 on December 3rd. You heard what happened. You heard her testimony. The facts do not support the story that Jennifer Crumbley told you. They just don't. There is no possible way, and Luke told you that, and so did Corporal Shaw, that you could be in that building with that many law enforcement and not know that somebody was there. And we don't even have to use that today's testimony, ladies and gentlemen, because she texted herself, I think we're caught, we're laying low. She texts that, we find out, and this is evidence we got this morning. She texts that after she's already said she took 4 Xanax and went to sleep. Now you saw that video. You saw that video. All those people for over 2 hours, they're sleeping, and even when they come into the room, they still don't even act like they get up. It's just not true. And we know it's not true because they'd already taken steps. She had hidden the phones, powered them down, separate from all the other things they had with the cash. Jennifer probably wants you to believe that if only the school had done something different, we wouldn't be here. If only the school. Well, let's talk about what she knew that no school employee knew. She knew about the text messages in March that he was about a demon, throwing bowls, clothes flying off the shelf. She knew about the March 18th incident of waking up in his parents' bedroom and like he had way too much to drink and asking why he was in their room. She knew he had previously asked for help and to go to the doctor, and she laughed at him. She knew there were multiple guns in the home. She knew her son had been gifted a gun just a few days before the shooting. She had posted it on Instagram. But apparently, it's absolutely fine for all your Instagram friends to know that you got him a Christmas present with a 9mm handgun, but it's not okay or relevant to the people sitting in that room with that drum. She knew that that gun looked identical to the one in the drawing. She knew that the gun was accessible to him. She knew it wasn't stored properly. She knew that he was proficient with the gun. She knew he had access to ammunition. And she knew that her son was upset the night before. Now, that says he was locked out. She told Amanda Holland he got locked out. She doesn't acknowledge that. She does acknowledge that he did leave the house that night because he was upset. And we all know what he did. We all know what he did. He went to that shed and recorded that video.
I object. That video did not come into evidence.
Okay, it isn't in evidence.
Okay.
You're right.
That's true. Let's go back to the elements. Ordinary care. What ordinary care, the smallest, tragically smallest thing she could have done to prevent this? She could have stopped at home on the way back from the meeting. She goes right by her home to see where the gun was. She could have stopped on the way back to work. She could have searched the backpack. She could have asked her son where the gun was. She could have blocked the ammunition. She could have blocked the gun. She could have taken him home. She could have taken him to work. He could have gone with dad. He was door dashing. She could have told the school that they just gifted him a gun. She could have embraced her son. She could have said, can we talk to him for a minute alone? She could have looked at him and said, I care about you, I love you. She could have at least acknowledged he was in the room. She could have told the school about her son being in crisis previously and asking for help. Ordinary care would have included all of those things. And the tragic part about it is none of it was hard. None of it. The smallest thing, just the smallest thing, could have saved Hannah and Tate and Justin and Madison. The smallest of things. I have to prove that there's reasonable foreseeability. And that worksheet right there that Jennifer Crumbley saw just hours before the shooting is reasonable foreseeability. And we're going to show you in the next slide. That's the picture of the gun. It's not just any gun, ladies and gentlemen. It's the gun that they just gave him. Blood everywhere. That's what he wrote with ammunition. I didn't show you the picture with the blood because I don't think you need to see it again. But we know what happened in that school and in that hallway. Here's a picture with 2 bullet holes and blood coming out of the figure's head. And look at that. That is where those shots went. Those are from the shooter's gun. The thoughts won't stop. Help me. These are all of the things that were texted to Jennifer Crumbley. This was in March. But he's writing it on a piece of paper and he's showing it to her. That is foreseeability. He's telling in that drawing, this is the gun that was purchased for me. Help me. Blood everywhere. The world is dead. I know you won't ever forget the video, but if you look at the defendant's son and see that there was no emotion, none. He was only concerned in a very calm manner for finding as many people as he could to kill, and he did. My life is useless. These statements from the defendant's son are just heartbreaking. I actually asked my dad to take me to the doctor yesterday, but he said, just give me some pills and told me to suck it up. Like, it's at the point that I'm asking to go to the doctor. My mom laughed when I told her, but I am having bad insomnia right now. I need help. I was thinking I could call 911 so I could go to the hospital, but then my parents would be really pissed. Like, I'm mentally and physically dying. Let's talk about the cable lock. Jennifer Crumbley says that the weapon was used, but it was locked in a cable lock that came with the case. This cable lock that came is the cable lock that came in that case with the SIG. It's never been opened and it's never been used. This is the last picture that we have of that gun until we see it murder 4 kids on November 30th. And the person holding it is Jennifer Crumbley. She's the last person that we see with that gun. She's the person that said it was in her car. Then she said it was in her house. It was her husband's responsibility. It wasn't hers. That's what she told you. She knew he was distraught the night before. He texted her, I love you. She told you that's never happened before. She did think it was abnormal or odd. She knew he was looking up bullets in the school. She knew he was watching violent videos. She knew he was proficient with guns. She knew he was previously in crisis. She knew his only friend that he talked to was just gone. She knew all those things. And then her own statements, ladies and gentlemen, when she took the stand. She testified that when she's looking back she still wouldn't do one thing different. Not one. Not any of those tragically small things. Even now, she told you she wouldn't do anything different. And then she also told you that we took his gun away. You heard her say it. And then she said she doesn't think of herself a victim, but she has lost everything. You're going to hear the instructions from the judge, and you're going to take the facts and the witnesses and the evidence and use what you promised to use, which is impartial, honest assessment, and find what you believe the facts are in this case. The flight, evidence of the flight and what they did after is not an element I have to prove. But what does it show? It shows the minute this shooting became public and ended up in the paper and the media, Jennifer Crumbley started telling a story, and then she ran. And she didn't run just because she was selfish, ladies and gentlemen. She ran and she started deleting text messages, and she started telling a different story because she knew she had done something wrong. That's the only reason you start deleting text messages. It's the only reason that you start saying something that isn't true. It just isn't true. Jennifer Crumbley drove to Detroit with a bunch of cash and 6 cell phones powered off. You can consider that as consciousness of guilt. Everything she did from the time she found out that there was an active shooter and had a 10-minute call with her husband. They both say they went right. He called 911 right away. He did not. He talked to his wife for 10 minutes, over 10 minutes on the phone before he called 911. But the facts changed because it was an immediate attempt to misrepresent what actually happened. Why is a mother whose son just killed 4 people thinking about deleting her text messages? Why is she saying things that are not true about her son? Why does she care about her job? Why does she care about her horse lesson? Why does she care about any of these things? Because she knew she did something wrong. And she's deleting all of those things because she wants you to believe that she's somebody she's not. And you know what she's not? She is not somebody that used ordinary care to prevent what was foreseeable, reasonably foreseeable, that could have happened. Injury or death. And it did. It did. Those words on that paper helped me. She walked out of that school within 11 minutes, didn't so much even address her son. She did not give him the help that he wanted. And you can argue about the months before and the weeks before, but if you just even look at what happened that day, she walked out of that school and she knew something bad might happen. What does she do when she gets back to work? She all of a sudden texts her son, "Are you okay? You know you can talk to us." These are the actions of somebody who was worried. She was worried and she was concerned and she was panicked until after. And then it's a different story. Why? Because she knew she had done something wrong. She walked out of that school when just the smallest of things could have saved, could have helped Hannah and Tate and Madison and Justin. Just the smallest of things. And not only did she not do it, she doesn't even regret it. we have proven beyond a reasonable doubt that she is guilty of 4 counts of involuntary manslaughter. It's a rare case. It takes some really egregious facts. It takes the unthinkable. And she has done the unthinkable. And because of that, 4 kids have died. So I'm asking you to go back when you hear the law, review the evidence, and find her guilty, because we have proven our verdict. Thank you.
Thank you. Your Honor, I am ready to go, and I will, but I'm going to need to use the bathroom halfway through if I start now. Can I have like a 3-minute bathroom break literally?
Do you guys want a break? Okay. So we're going to take about a 5-minute break, and then we'll do the cuts. Council closing. Okay.
All rise for the jury.
You may be seated. I don't want to pressure anyone to speed up their closing, but both sides have asked me to let the jury deliberate today. I'm going to talk to the deputies. I'm not positive that's possible. I'm not positive it's possible.
Okay, I'm running to the bathroom. Thank you.
You have to take it out? Okay, you're gonna take it out.
You can remain seated. Everyone can remain seated. Honor, calling People versus Jennifer Crumbley, case number 222799990 F8.
All right, one thing I wanted to tell you, I've been using up all my brownie points with the captain who has told me that we can stay later than we need to, if that's what you want to do. I'm concerned about sequestration and all that. When we pick 5 alternates, I'm going to put 5 alternates in another jury room, and they're going to remain sequestered in the same way that the 12 are. So 5 are going to sit in another jury room. If we come back Monday, I'm still bringing the 5 sequestered jurors back here. All right?
I think that's smart.
Yeah, oh, well. Okay.
I know it's awful for them, but if one of them goes down.
Okay, yeah, no, I'm concerned about that, so that's what we're gonna do, right? I just wanna let you know, because when we go out to the jury room before I pick the 5, I'm gonna have them bring their personal things out here, because then they'll be separated, right? Okay. All right, so I'm gonna bring that.
Thank you.
All rise for the jury.
All right, you need to see it. You're not going to take your defense, please.
Yes, thank you. As the prosecutor finished, she said, "This is shocking, unthinkable." I believe there were other words used throughout trial. Unbelievable. Obviously, unbelievable, unthinkable, unfathomable. And the reason that's the case is because it was unforeseeable. No one expected this. No one could have expected this, including Mrs. Crumbley. Now, the first thing I want to do very quickly is talk to you about the burden of proof. In the state of Michigan, there are different burden of proofs depending on what kind of a case it is. When people sue for money and say, "I've been injured," or "I was failed by the school," even, there will be civil lawsuits, and the burden of proof is a preponderance of evidence. That means it's about a 50-50 standard. And if you have 50% of the evidence, that's the burden of proof for civil. When the state thinks it's important to take away a person's children, the burden goes up, and the burden has to prove more evidence, and that specifically is clear and convincing evidence that it's correct for the state to be taking away a person's children. Now, the highest burden in this country is in a criminal case, and that is beyond a reasonable doubt. And the reason I'm telling you about the differences in the burdens is because in a criminal case, if you have just one reasonable doubt about the case, you must vote not guilty. And so this is my poster just showing beyond a reasonable doubt is guilty, but there's many, many other options. If you think it's likely, probable, possible, not likely, those are all not guilties. You have to be sure beyond a reasonable doubt. And later, as I go through my closing, I am going to tell you the reasonable doubts that the defense believes exist in this case for you to look at.
The other thing I have to ask you to keep in mind is that in the jury instructions, and I think you've been told this throughout trial, the defense does not have to prove or do anything. Like Judge Matthews said, we could sit at the table and play chess the whole time, call no witnesses, cross-examine no witnesses, provide no evidence, because we have no burden to prove a thing. However, in this case, you obviously saw the defense present Mrs. Crumbley, who took the stand, so that she could give you some context beyond parts of the evidence that were confusing when the prosecutor was introducing in bits and pieces. And the problem in this case is that we can all agree everything can be seen different in two ways. First of all, when you look back in hindsight with 20/20 vision, when you look back in hindsight, it is easy to say, this could have been different, that could have been different, this would have changed. And the other circumstance, the second one that makes a huge difference, is when you get full context around the evidence that is being used. And in this case, the prosecutor has cherry-picked little bits of evidence out of mountains of evidence to put in front of you with no context to explain what they're doing. And when you get cherry-picked bits of evidence, it's easy to reach wrong conclusions. Now, during jury selection, it felt like the prosecutor was asking you questions and giving more of a campaign speech than a jury selection proceeding. And I would suggest to you that at the end of the day, the only judge, although Ms. McDonald mentioned she's been a judge and was a judge several times during her jury selection, the only judge in this courtroom that matters is Judge Matthews. And the only other people whose judgment matters are the 12 of you who will collectively decide this case. The rest of us don't matter. My opinion doesn't matter. Ms. McDonald's doesn't matter. The opinions of everyone in this audience doesn't matter. The media and all of the people who think they know everything behind keyboards at home commenting about what they think the evidence in this case has shown. So during this case, it's obvious real life is messy and complicated. And during this trial, I will openly admit that I'm a lawyer who messes up. I get thrown off when I'm surprised by something. I feel like I get overwhelmed when information is coming at me quickly. I say I'm sorry a lot. Evidently, there's a TikTok channel of me saying I'm sorry through this whole trial. And all I'm saying is that I'm human. I am a human being, and so is Mrs. Crumbley. And that's what this case is about. She's not a perfect person or a perfect parent. I'm certainly not a perfect person or a perfect parent. And I'm certainly, beyond a reasonable doubt, bad with technology, which is why you're not going to see me touch that laptop. So during this trial, I have stood before you and shown you all my flaws, and I embrace them, and they are a part of what makes me human. And so has Jennifer Crumbley. She got on the stand and talked about every nook and cranny of her life, things no one else in the world knew, in her family, among her friends. And she wanted you to see the whole truth, the entire truth, and nothing but the truth on everything, where she had to show you that she has made immoral decisions to have an affair, that she has made decisions you might not make to have another person involved in the affair. Now, we didn't get too far into the details, but it was enough for you to know that Mrs. Crumbley got up there and literally stripped off her armor, let the prosecution cross-examine her, and show you what happened in her messy life. And I say that with all kindness because I'm a mess too. I saw a meme about a week ago that said, I'm trying to be a mom, trying to get exercised, stay hydrated, get enough sleep, text everyone back, and not lose my shit. And I've got to be honest, as a mom, a working mom, on most days, I'm lucky if I'm fit for human contact. I'm lucky if I've taken a true shower and didn't just grab a handful of wipes and scrub off the best I can on my way running out the door, putting on my makeup as I drive to court in my car. Because my life is not perfect and no one's is. And during this trial, you may have concluded that you don't like me, that you hate me. That's fine. I am just asking that your opinions about me as a person, and if you're one of the people who plans to make a TikTok about me, that you won't hold those opinions against Jennifer Crumbley and will judge Jennifer Crumbley's case based on the evidence about her and her family. And if you hate her or don't like her or agree with things she's done, that's okay too. You don't have to like her. You are not expected to go hang out with her when this is all over. After trial, you don't have to decide if you want to go to her house. You don't have to have Thanksgiving with her. But when you're looking at the evidence in this case, it's important to set aside your opinions of her or take your opinions of me and supplant them on Mrs. Crumbley. Now, when I took on this case pretty early on, I realized I am Jennifer Crumbley and I could be here accused and sitting in her spot very easily. Now, in my house, we don't have guns. I don't have guns, but I do have children. And actually, I have an oopsie baby, my fourth one. I did not want 4 in 4 years, but that's what I was blessed with. I say I'm abundantly blessed. And I have kids that seem to have no issues. And at the end of the day, they're good kids. They go to school. We have no discipline problems. We have arguments here and there, just like every family does. I have a son that wants to hang out with me very rarely, but I have no belief that any of my 4 children would ever harm anyone else. And while I don't have a gun, I have a large butcher block on my counter with big knives that I use when I cook, and I enjoy cooking. And at the end of the day, my kids could just as easily grab a knife without me knowing it and without me having it on my radar and walk out the door of my house and go play with their kids, the other kids on my block. Granted, they live farther down my block because I'm in the middle of nowhere. And my son could kill somebody with my butcher block knife that I would have never expected to happen. And if you saw the text messages that my husband and I exchanged on a daily basis throughout this past year and even years before, it would be so easy for me to be in her seat. With my kids, I don't monitor assignments. I don't look at their phones. I have no reason to. My son plays a lot of video games. My son's online talking to a bunch of people as he's playing a lot of video games. Even though he has a cell phone, I don't go through it and look at his messages every day. And as he gets older, I do know he's interested in girls. If he starts receiving nude pictures of a girl on the cell phone I own but let him use and gave him for his birthday when he turned 11, should I be held accountable for receiving child pornography if a girl sexts him over some inappropriate pictures? If my son decides
he's going to send some pictures back and takes a new picture of his bits and pieces, that's a 20-year felony. Am I then responsible because he sent a picture of his penis over to some girl? So not only taking the picture, a 20-year felony, but then we've got a 7-year felony for sending it over. Can every parent really be responsible for everything their children do? Especially when it's not foreseeable. And this clearly was not foreseeable to Mrs. Crumbley, because there's no one in the world, including Mrs. Crumbley, who would have let a school shooting happen and let what happened on November 30th take place. Not only ruining the lives of so many families and victims and taking the lives of 4 young people, but also ruining her own son's life and ripping his life right from her as well. She would be the first person on the planet who would have never let that happen in a million years. So this case is a very dangerous one for parents out there. It just is. And it is one of the first of its kind. Luckily, however, this is a case where the prosecution cannot meet its burden of proof. And thankfully, it's a case where truly Mrs. Crumbley does have a defense. And this isn't just one of those stretched cases where a parent is liable for what their child has done. Now, the judge is going to tell you that you have to, if you find reasonable doubt in this case, you must find the defendant not guilty. And the law says you must have a reasonable doubt, not 3 reasonable doubts, not 5 reasonable doubts, not 10. If you have a single reasonable doubt, you must vote not guilty for Mrs. Crumbley. And when it comes to reasonable doubt, each of you can have a separate reason to have doubt in this case. You don't have to agree on what the doubt is. And for that reason, what I am going to do is show you all of the doubts that the defense believes exist in this matter. Some of them may speak to one juror, some of them may speak to another, but at the end of the day, if you have just one, your vote in this case must be not guilty. So the first place the defense finds reasonable doubt is in the fact that the prosecution is so desperate to prosecute this case that they admitted a mountain of evidence that, quite frankly, was unnecessary. Now, they say to you they needed to show you, they needed to prove the manner of death. We stipulated that 4 people died. We stipulated that it was the most horrific set of facts you could ever imagine. We stipulated that what happened to Molly Darnell and Christy Gibson Marshall was horrible. But this prosecution, putting that evidence on, was designed to inflame you and make you emotional, strike your sympathy, and get you to hate Mrs. Crumbley, which, by the way, has been very effective for most of the media, most of the public, and for anyone who has seen information put out by this prosecutor in this case. A second reasonable doubt comes from the fact that we know, and the evidence in this case showed, context is key. And that was clear when Detective Wygrowski took the stand and said, you get better decisions when you have more evidence, and testified that in a former hearing, he messed up because he didn't have the video from before the one he saw. So he believed the parents arrived at the school together, and subsequently, when given more context, showing more video from further beforehand, he could see they actually arrived in different cars, met, and walked in the building together. And at the end of the day, the more context you have, the more accurate you can be.
When Brian Maloche testified, another example came about where the prosecution had him testify that Mrs. Crumbley said to delete his messages, clear your cache. And I'm so thankful that the rest of the world sent me emails that I don't know how to pronounce cache, because now I do. And when Brian ended up seeing the messages before clear your cache and after clear your cache, he realized, oh, she wasn't asking me to delete messages. She wanted me to refresh my web browser to see if the Facebook had actually deactivated. And so that was proof again that when you have more context, you're more accurate. And the problem the prosecutor has in this case is they have very little context for the very little evidence they've submitted. There's also no context around some of this little bits and pieces of useless evidence, like Jennifer Crumbley saying that her son was an oopsie baby. I call my son that, so what? Does that mean I hate my son? Does that mean I would be okay if he went and killed a bunch of people and or if he committed suicide? No. Calling your child an oopsie baby was designed to try to make her look bad with no context. Having Amanda Holland come in, a coworker who's not a friend to Jennifer Crumbley and has been interviewed by law enforcement to tell you her advice on she should go have a mother-son day with her teenager, so irrelevant when she's faced with raising toddlers every day. When I heard her advice, I thought, yeah, right. I have 3 teenagers. I almost have a 4th. And personally, not only would they rather do anything else than spend a day with me, I'd rather do anything else. And we do spend time together, but that's not their first priority when they get to pick what they're going to be doing. It does not mean she loved her son any less if she ever told a witness, my son is weird. And part of what made me realize I could be in Mrs. Crumbley's shoes is I've sent texts to my husband saying, our daughter is a psycho today. On the way to school last week, she's crying. She doesn't have people to sit with at lunch. I texted him, she's a nutcase. I don't know what to do. I don't know how to handle this. I don't have time for this. My other daughter is complaining about her lights flickering in her room. I texted my husband, this sounds like a case. The start of a case. My husband works for my office. He's actually my office manager, so he knows about the case. He went in her room and figured out in 5 minutes, it's because when she flips her blow dryer on, one of our plugs makes the lights flicker. So this ghost that you would read about in my text messages, which by the way, I did not respond to, despite the fact that it's on our 6-person group chat, would be taken out of context and make me look like I don't really care that my daughter is crazy. I also got text one day, we have no food in our house. I am absolutely starving. You are the worst mother ever. And you know what I did? I ignored it. She was mad we didn't have the right kind of chicken ramen. When we have 85, I like the number 85, when we have 4 other flavors of ramen, and there's about 100 other things she can eat, and I knew she's not going to starve to death, but taken out of context, it makes me look like a neglectful mother. But if you know all the circumstances, and you know the relationship I have with my daughter, I knew it was an overdramatic, stupid point. So when you see messages from Mrs. Crumbley's son saying, will you at least call back? Those are so out of context. And when I'm driving home from court every day, I'm getting messages, will you at least call back? And I don't, because I know what they want is for me to run through the McDonald's drive-thru and bring everyone a Coke. I do stop and get myself a Coke, but I am not getting a round of drinks every day for everyone. And I've realized it's easier to not answer the phone. So you can find reasonable doubt from the context that the defense did actually provide. And when Mrs. Crumbley got on the stand and explained to you her understanding of ghosts and dishes flying and laundry flying. That is evidence. And that is something that can create reasonable doubt to hear what was really going on. Even if you believe the prosecution's dates about what was going on, it's not strong evidence. It's very misleading. And I'm going to go through what it does show. There are 3 sets of dates involving Mrs. Crumbley, all from March of 2021. The first time is March 8th and 9th. They introduced exhibits, including text messages on the 8th, where Mrs. Crumbley starts off asking, is he home yet? Is he home yet? I don't want him to do anything stupid. I'm sure you all remember those. Then they introduced evidence on March 9th that she went to the barn that day with her husband on the 9th. Then they introduced evidence, and I will give them credit. They put together quite a case, although it's really not important, that there was a picture of the horse taken at the barn that day, that the data supports there was a picture of the horse taken at the barn that day, and that there was GPS tracking information supporting that she was at the barn that day. Okay, fine. So on March 8th and 9th, there's concern that the shooter, Mrs. Crumbley's son, is making weird comments. And on the 9th, she goes to the barn and she takes some horse pictures. That's all that shows. Pretty minimal. Next, they went to March 16th through 19th, which was broken up into a million exhibits that, quite frankly, were out of order, threw me off my game, helped create these beautiful TikToks. And I'm going to tell you what they show. Now, these ended up all being admitted as exhibits, but I'm going to go in order of what they show. There was a text thread in Exhibit 85, which if you want to look at it, you can, where Jennifer Crumbley said, I'm going to get drunk and ride my horse. This was on March 17th, St. Patrick's Day. A lot of people have a cocktail on St. Patrick's Day. That does not make her a mother that would be negligent or grossly negligent to her child. There's text messages from the day before where Mrs. Crumbley's son is saying some things about, now the house is haunted. Some weird shit just happened, now I'm scared. I got some videos, a picture of a demon. It's throwing bowls. I'm not joking, it fucked up the kitchen. I'm going outside for a while. Can you at least text back? On that day, Mrs. Crumbley didn't text back, but their own exhibit, okay, which is Exhibit 83, so the numbers do bounce around, so we go from 85 to 86 to 83, show that within an hour of the shooter making these ghost comments, she did call him. Specifically, she called him back at 7:24, and they had a 19-second phone call. If it was 19 seconds, it most likely was, I'm on my way home, we'll talk when I get home. So then the state, in order to make it seem like they've really, really got some proof here, they admitted exhibits 87, which show on the 17th on St. Patrick's Day, James was on a horse. They showed People's Exhibit 88, confirming the metadata that James was on a horse. They showed a picture, 89, of Jennifer on a horse that day. Metadata to prove she's on the horse that day. Another picture, number 91, of James on the horse, a different picture. The metadata to prove James is on the horse. A picture of Jennifer with her horse in Exhibit 93. And again, the metadata to support the picture was taken out at the barn and sent, and that these people talked about these horses. Okay, so fine. That's on the 17th of March. You're going to have access to all this evidence if you want to see it. Then they introduced exhibit number 86, which is where Their son says the house is haunted. This is on the 17th. This is the day where he says, can you text back? This is the day where I already showed you the exhibit. She called him. She didn't text back, but she called him. And then they show a couple texts from a few days later on the 19th, where it's obvious from the messages, the Crumbleys had had an argument with their son the night before. He was upset to have his phone and things taken away, that Jennifer Crumbley gave him a melatonin to go to sleep. She should have only given him a half. It's in the messages, but she gave him the whole thing. And it knocked him out and he slept in their bed that night. And when he woke up the next morning, James described him in the text messages as he woke up looking like he had way too much to drink last night, complaining about a headache. Jennifer says, well, he was really worked up and out of control, so I can see why, talking about his behavior during the fight. All I know, Jennifer says, he needs to eat, go to work hard, not complain, and he can get his stuff back. She testified that getting his stuff taken away is his trigger. It's what makes him go get upset. She says, you respond and I didn't get it. James says, Jesus, yes. He said, let me ask you a question. Why am I in your room? That's when they talk about the melatonin. She says, oh my God. James says, I really thought you were giving him a Xanax last night. Jennifer says, does he seem better? No, melatonin. James says, I know. So obviously he's joking. Jennifer writes, but he hasn't had one before, so I should have only given him half. James writes, well, he's doing his school, says his head's hurt, so he took Tylenol. Jennifer asks, is he okay to work? James says, yeah. Does he remember what he did? James finally says, dude, I'm working. I'm on a demo right now. I haven't talked to him. He's doing school. And that's really the extent of the conversation. So fine. So one day they get in an argument. And I'll tell you what, those kind of arguments in a heartbeat could have me sitting in her chair. The final date that the state claims Mrs. Crumbley had knowledge about back from March of 2021 are exhibits 96 through 100. And 96 starts off with their son saying, I'm picking up the room. I cleaned until the clothes started flying off the wall. This stuff only happens when I'm home alone. I pick the clothes back up though. And that's the important part of those texts on the 20th. We know on that date, because the people proved it, no pun intended, but they beat a dead horse, that at 97, it's a picture of Jennifer at the barn. We've got the metadata showing Jennifer was at the barn. We've got another picture on 99 showing Jennifer was at the barn. And exhibit 100, Jennifer was at the barn. Big deal. Jennifer's at the barn. Their son is saying goofy stuff. Jennifer gave you the context. They had an Ouija board for a couple months after Christmas of 2020. He and his friend are playing with the Ouija board. They ultimately lost interest. They stopped doing it. Jennifer admitted to you one day to mess with them. She turned the power off in the house, turned the circuit off to mess with them. She mentioned a time where James pretended he was getting electrocuted. She didn't know what to do. She's screaming, trying to kick him, see if he's electrocuted. Ethan is laughing, taking a video of the whole thing. This family played together. They had fun. They did what families do. The prosecution just had zero context because they had tunnel vision that she was doing something wrong and was grossly negligent, and they were hell-bent on convincing you that was the case. So the other thing that you can find as a reasonable doubt in the case is the lack of evidence in the case as a whole. The prosecution has made very serious claims. And when you really look at it, they have very little evidence. So what they've shown to you, and I have it in these folders, are these dates in March 2021, which, by the way, are 10 months before the shooting even took place. They're before it would have, it's unreasonable to expect that things that happened in March of 2021 are an indicator that 10 months later their son's going to do something. It would be very different if every week there's something going on up until the shooting, but there's not. Because if there was, the prosecution would have brought that in and showed you every horrible thing that was happening to show you their son was being ignored, and they don't have the evidence. So what they did provide and what was admitted, this is exhibit, I believe, 423. These are all the Facebook messages between James and Jennifer. So when you look at those Facebook messages and consider, and this includes the photographs and the GPS stuff, that they're using this much compared to this much over the period between January 2021 and the shooting. This is a very little bits in time compared to the grand scheme of things. And while the officer testified and played games with me that he's not sure this is the best evidence against mother, you better believe if they had better evidence, they'd be up here showing stronger and better evidence. This is it, ladies and gentlemen. It's obvious from the evidence in trial, and you may find it to be a reasonable doubt, that the Crumbley son was a skilled manipulator, and they didn't realize it. He's not sick. He doesn't have a mental illness. He's had no history of hallucinations. He has never shown his parents signs of mental illness. He certainly never showed signs of mental illness wanting to get a gun. No parent would purchase a weapon if they believed their child had mental illnesses. And these are people that had 2 other guns in the house for months where nothing ever happened with those guns. They had no reason to believe that somehow this third gun was the thing that was going to make the difference. The texts that the prosecution admitted as Exhibit 101 were texts between the shooter and his friend that we have not named. The extent of these text messages saying goofy things like, I told my dad to take me to the doctor, he gave me pills to suck it up, it's at the point I'm asking to go to the doctor, I'm having insomnia and paranoia, I'm calling 911, I thought about calling 911, but my parents will be pissed. I don't disagree with the prosecution that these are alarming messages, but clearly the shooter's friend isn't that alarmed because he's not texting back. The shooter's friend knows there must be more going on because he doesn't tell Mrs. Crumbley, who is like, and he's like a second child to her. And we have no other context about these messages. And if anything, the evidence does not show that Mrs. Crumbley ever saw these messages. Now, when she sees them now, she thinks that's crazy. She'd like to know more context. But you also have to know, and another reasonable doubt you may find in this case is created when you compare these text messages that were sent that have alarming things between Ethan and his friend to all of the messages between them, which are over 20,000. And what you would have to believe, and what I would believe, is that if the state had stronger evidence, they would have paraded it up and we would have been seeing a lot more of these. But instead, they were admitted, and you haven't heard the friend testify. You haven't heard any context about these. And all you can see, and really all the evidence shows, is that there's no reason to believe Mrs. Crumbley ever saw that. I don't want to have another Leaning Tower of Pisa situation. So move this down.
I'm watching.
I've taken your advice. Now, the other evidence the state has shown are little bits and pieces from the shooter's journal that are quite alarming and disturbing. But again, Mrs. Crumbley says the information in there about my parents won't listen to me for help is not true. And there is no evidence to show she ever saw that 22-page handwritten document. She never saw the little bits of evidence that the prosecution admitted. To evaluate this case, you have to look at it from the perspective of what she knew. So the journal information and the small amount of text compared to all the text with his friend are things she didn't know about. There's also 2 times where the state says that they have proof that Mrs. Crumbley's son was showing signs of depression or being sad or lonely. All right, those come from April 29th, 2001. This is when Jennifer Crumbley emails the friend, his mother, and all she says is that her son has been acting kind of depressed. She doesn't know what's going on. She's trying to find out what's going on, but he won't really tell her much. She's trying to find out if there's an issue between the 2 boys she should be aware of. She's trying to get down to the bottom of it. If anything, she's doing what a good mom does to try to figure it out. But the worst of what she says is that he's stressed by school. I don't want to get this wrong. He's been acting kind of depressed. And she's happy to hear it's not an issue between them. Then they go on to make plans for their son. This was admitted as Exhibit 104. If you put my text up there and showed every time I told my mom that one of my kids was acting depressed or weird, I guess my favorite word is moody these days, it would look like my kids were complete lunatics. I'm actually shocked Jennifer Crumbley doesn't have more texts about her son acting like a typical teenager. And Jennifer Crumbley testified that although she said that, she didn't think it was anything she needed to run to a doctor about or anything she needed to do anything more with. And this moment passed, because if it didn't, the prosecution would have brought in all the texts that went beyond this, and there'd be more evidence. They also run in text with the same parent of the friend from Exhibit 105, the friend's mother, when Jennifer Crumbley reaches out to her saying she had no clue what they were going through with their son, and she felt really bad about it, and asked how they're all doing and that they're thinking about them, that family, a lot. And ultimately, the worst that Jennifer Crumbley says about her son is, I know my son misses him. And if you need anything at all, don't hesitate to ask. That's it. It doesn't go on with wild depressions or hallucinations or mental health issues. That's it. That's it. I'm actually shocked there's not more instances of depression or moodiness or my kid is acting weird. The fact that there's this little evidence is shocking to me. However, it's a lack of evidence on the state's part. There's also a lack of evidence in Mrs. Crumbley saying he's depressed to really anyone else. Even after the shooting, when she's talking to her friend Kira, to other people, to Brian, all she keeps saying over and over is, I wish there had been signs. I wish there had been something. He's a normal kid. There's a complete lack of evidence of mental health concerns specifically. if you want to really spend some time digging into this, you can read all the messages between James and Jennifer Crumbley, all of them, and you will find that there are not texts that go on and on that their son was exhibiting anything close to a mental health concern. And again, my text would read worse because I say things like, I think my daughter's psychotic. When Mrs. Crumbley did have to evaluate what's going on with her son, and there was something alarming happening, she relied on people who spend day in and day out with kids, people she considers to have more expertise in kids than she does, including Pam Fine, who left her a very nonchalant voicemail that you've heard, that was exhibit 115 if you want to hear it again, saying Ethan was looking up bullets in school today. It's not illegal. It's not wrong. He's not in any trouble. It's just like how teachers can't look up hops for beer. You don't need to call me back. She was relying on the representations by the school counselor, Sean Hopkins, who took the stand and has had a lot of training, hundreds of hours of training, and made it very clear this was just an issue where he needed some kind of therapy and didn't think it was necessary to suggest to the Crumbleys, go to common ground today, or serious enough that he called 911. And she relied on the assistant dean, who also has an abundance of experience Mrs. Crumbley doesn't have. And quite frankly, my kids didn't come with a handbook, and my guess is her son didn't either. And the assistant dean said the same thing in the meeting with Mr. Hopkins, that Ethan Crumbley that the son could remain in school that day, that he would probably be better off, according to Mr. Hopkins, around peers versus being alone, and that as long as they got him an appointment within 48 hours for some kind of counseling or therapist, that was sufficient. So it's absolutely not credible when a witness from the school, like Mr. Hopkins or Mr. Ejak, gets up on the stand and says, even if a kid is very sick, we cannot force them to go home. That is not true. And as parents with common sense, you should know that's not true. Because when my kids are puking, my kid's school will not let them be there. And when they have a temperature, not only can they not be there, but my children's school is always nice enough to remind me they can't be there for the next 24 hours, which means they can't be there the next day either. So reasonable doubt can be found in the fact that trained professionals told Mrs. Crumbley her son was not a risk, and Mrs. Crumbley relied upon it. This school also failed to even really look at the situation and tell her about things from the year before. They made it very clear that he was not in any kind of discipline issue, which is shocking to me and was shocking to Mrs. Crumbley, considering he's off topic looking at bullets in school. He's looking at a video in school of some kind of violent pictures, and then he draws a gun on his math paper instead of doing the math paper. So when school officials say, okay, this is really not a big deal, all we want is a counselor within 48 hours, Mrs. Crumbley took that as a very strong sign that things were fine. And reasonable doubt can come from the fact that those three people at the school, Fine, Ejak, and Hopkins, are mandatory reporters by CPS who would have reported if they thought Mrs. Crumbley or Mr. Crumbley were neglecting their son. Mrs. Crumbley even commented to others about the nonchalance that was at that meeting, that it was only 12 minutes long, which surprised her, that she was disappointed they didn't take it more seriously. that she was surprised there was no disciplinary action, and she left the school actually feeling better that maybe she had overreacted when she flew over to the school. Now, the people who are trained in these areas, they didn't just say, we're not trained in these areas. They gave specific examples. They said that kids who are really a threat, they would show nervous behavior. They would show anxiety about somebody else handling their belongings. In this case, the shooter was cool as a cucumber as Mr. Ejak went down, got his backpack with the gun in it, and brought it to him. And Mr. Hopkins and Ejak said they hoped they could get him into counseling today, but ultimately said he can stay at school and we'll give you 48 hours to get it situated. All right, so the prosecution keeps harping on the fact that Mrs. Crumbley knew they had bought a gun and that the people at the school didn't. This is Oxford Community Schools. These professionals testified about how common guns are at the school, so common in this kind of unique way, although I live out there, that students are known to go to the gun ranges often, that girls on homecoming wearing their short little party dresses they wear to the dance take photos before the dance holding their guns, that kids go hunting on Late Start Wednesday before they go to school, and the school has to give reminders to parents for people to leave their guns at home. So this school that obviously has a strong gun culture going on, that sees a student looking at bullets, looking at a video game type thing with violence, and seeing a gun drawn on a paper, that these school officials, knowing that community, that they didn't ask if he had a gun when they carried the backpack down and did make a comment about how heavy it was, although the comment evidently was made to a different teacher, and I misunderstood and thought it had been made to the shooter. So yeah, Mr. and Mrs. Crumbley, they didn't mention the gun, but they did mention that they had been at the shooting range with their son. And this is a community that is so into guns. I can't even believe that these girls, I always look at those pictures on Facebook and think, oh my God, how short are those dresses? And these are girls showing their dresses with their guns in their hand. They know this is a gun community. Reasonable doubt can be found from the fact that the biggest concern at the time was suicide and not homicide. The worst case scenario that was presented would lead a reasonable person to believe there was a possibility of suicide, not homicide. The prosecution seemed to also carry on about the amount of money and time that Mrs. Crumbley spent on horses. Just because she spends money and time on horses doesn't mean she doesn't love her son. And the fact that they have to stretch so much can create reasonable doubt. And if you actually look at the exhibits the defense submitted, you'll see that Mrs. Crumbley said she has to get a second job to pay for the braces, which are very expensive to put on her child's teeth. She paid for her son to be a part of a bowling team. She paid for him to do other sports. She cared about her son. Just because she cared about horses and bought medication from them and had a horse hobby, that's not any different than a dad who likes golf and buys new golf clubs and has a membership to a country club and spends time there and spends money at the bar there on days they go golfing. It's not any different. To try to suggest that it shows the priorities were on horses and not their son is just garbage. This is a son who had everything he needed and all kinds of opportunities in life. A son they take camping and on vacation to Cedar Point. Not only do they take him, they take a friend with them. These are parents that clearly love their child. They're sitting there playing board games with him, spending time doing that. That's all in the Facebook pictures that were admitted. Those are submitted to you as exhibits, and you can take a look at them if you want to. Brian's testimony in this case absolutely creates reasonable doubt. When Brian Meloche testified, there's no question he was inconsistent. And I would submit to you that there was no reason law enforcement needed to interview him for 2 hours, 1 hour, and then 3 hours. But over time, the police certainly caught on to the fact that the more you ask Brian the same question over and over, and he realizes he's not giving the answer you like, he changes it. And while the prosecution tries to make it sound like, well, he didn't want his affair outed, from the very beginning, he told them he was having the affair with Mrs. Crumbley. That was not something that ever changed. It wasn't until the third interview when they started talking about his pension, talking about his job, that he felt pressure. He agreed with the word pressure, and he agreed with the word veiled threats, although he did take it back later, that the police wanted him to say something bad about Mrs. Crumbley. And I would submit to you that they probably did that to all of the witnesses in the case. But Brian Meloche was the one who admitted to it. And when Mr. Keast got back up there and asked him more questions, Brian got right back in line like he was supposed to and told them exactly what he knew they wanted to hear. Brian is a terrible witness. He said he had memory problems. And quite frankly, when he's testifying that he knows that the gun was in the car that day of the shooting, we all know no one thinks that's true. Mrs. Crumbley testified and explained the day the gun was in the car. Brian's just wrong. And when Brian testified that Brady was gone and he believed Brady died or committed suicide, I would submit to the jury that Brian is just an idiot and has no clue. And that the truth is, he didn't know the details about where the shooter's friend went. He just knew he went away. Wherever he got that suicide idea from, who knows? The prosecution didn't show any texts or anything to support that. But it's clear that Brian Meloche has been put on a mission, which is you're coming into court, you've got some things hanging over your head, and we want you to take a position against Mrs. Crumbley. And I would submit to you that if you read the 77-page exhibit that I got yesterday and went through in painstaking detail with you, you can see that Brian Meloche did not think of Mrs. Crumbley that way when he knew her and when he dealt with her. And he testified the only places he got new information about her that made him think differently about his answers were from law enforcement and were from the media. The media that we have talked about in this case repeatedly as being inaccurate. Brian admitted that when the prosecution asked him, and we've already talked about this, to delete his messages, when I went through the part about clear the cache, Jennifer telling him clear the cache, showed him the stuff before and after, he realized it was just to refresh the page to see if Facebook had deactivated. So giving him little bits of information is particularly dangerous because he's not the sharpest. And that's what the prosecution did. They used him to their advantage to try to make it sound like they have this case and all these horrible statements against Mrs. Crumbley. And by the way, when they presented evidence that Mrs. Crumbley is deleting texts and keep making it sound like she selects different texts here and there, it actually sounds like Mrs. Crumbley deletes all her texts, as she testified, that when people start flooding her with text, she deletes entire threads at a time. Who knows what she's deleting? We saw her on her phone flipping through them super fast. And the texts ultimately that she deleted, the prosecution did point out two of them in their closing. They pointed out the texts about "we're fucked" and "we're on the run again," but they didn't mention that she deleted 2 texts that are actually very exculpatory and helpful to her. Why would she delete some of the most helpful and exculpatory things she said? Those 2 texts are on page 42 and 44 if you want to see them in the 77-page exhibit. And those 2 texts confirm, she calls it the string lock was on the gun. She means the cable lock, but she doesn't know enough about guns to say cable lock. The string lock was on the gun. And the other deleted text that the prosecution didn't mention was when she said that the weapon had been locked, the ammunition had been stored separately, and that everything was not loaded. There's no reason she would delete 2 messages that are that helpful to her. She's just a person who deletes all of her messages, as she testified to. You can find reasonable doubt that Mrs. Crumbley's state of mind is very obvious in statements she made after the shooting. Right away, she's talking about how she had no signs to believe anything would happen. At the substation interview, it's on recording, we watched it. She tells the interviewer, "I had no signs, there were no signs." Then when they have her in the car, the squad car, and she's in the back, she says to them again, "I had no signs." In her text message with Kira, which was admitted, she says there were no signs. Kira says there probably were, you just missed them. With Brian Maloche, Mrs. Crumbley says again, there were no signs. I would submit to you, this is not some master plan where Mrs. Crumbley decides she's going to suddenly say there's no signs. First of all, there's no evidence of signs Mrs. Crumbley knew about. And second, all of her immediate fast statements in a time of stress, went right after she's had guns held to her face, walking out the front door of her house, she's saying there were no signs. You might find, and I know the prosecution takes issue with this one, but Mrs. Crumbley was actually, in fact, a hypervigilant mother. She's the kind of mother who is going to the friend's mom to chase down why he's having a moody and kind of depressed day. She's on Power Schools on the app multiple times a day, checking for missing assignments. She's emailing teachers about grades. Christy Gibson Marshall, the assistant principal, who did do one of the bravest things I've ever seen, she testified she saw the shooter's face and couldn't believe it was him. And the reason she couldn't believe it was him is because it was so unforeseeable. Mrs. Crumbley's hypervigilance also comes when you look at how she takes him for medical appointments. They're at the urgent care because some little mole on his back changed colors when she's applying sunscreen. I think of myself as a hypervigilant mother, and I've never noticed any moles on my kid's back, and I must need to go home and look. Because when I look at the actions of Mrs. Crumbley, she actually pays far more attention to that kind of thing and other things than I do. I could easily be sitting in her chair. When her son's experiencing headaches and medical issues, she's at the doctor or doing virtual visits. There's no reason to believe that's not true. With the headaches, they go through a whole process. She gets a whole x-ray done of his head. She takes him to the eye doctor to see if that's causing the issue. Ultimately, she pays and puts braces on his teeth. Then he's a bad brusher, so she's going to the extent of getting the braces off his teeth so he can get the cavities fixed, 13 cavities. I would go crazy on my kid. And she's just doing each thing she needs to do as a hypervigilant mother. And yes, a hypervigilant mother can have a drink once in a while. I'm a hypervigilant mother, and I not only have a drink once in a while, but sometimes I've been known to have 2 or 3 or maybe a bottle. Reasonable doubt can be found from the fact that Jennifer Crumbley did her best as a mother. While going to the shooting range is not her thing, she's trying to find a way to bond with her son, who has just had his best friend move away. She took him camping, took him on trips, brought the second son along, like I've already talked about. She let him have pets. He has the cutest little kitten you've ever seen in these Facebook pictures. Board game nights with him. She's not neglecting him in any way. And if anything, she's going to the gun range for him, not because she enjoys it. You can tell how much she loves it when she gets up there, shoots a couple shots, and then just stands there letting him enjoy the activity he likes. And I do the same thing for my kid. He likes to go to skate parks. I would rather do anything but go to the skate park. But I sit there and watch and say, oh, that was amazing. And all I hear is, Mom, watch this. Mom, watch this. Mom, watch this. And I would rather do anything else. But Mrs. Crumbley on that day is trying her best to bond with her child and have a relationship. Showing the pictures of the messy house was just not necessary. And the prosecution explained to you they weren't trying to prove she had a messy house, but much of it was just so unnecessary that I would suggest they are trying to make her look bad. They do kind of make her look a little bit like a hoarder. But if you saw pictures of my house right now, like a snapshot in time, you'd be just as horrified. I've been so busy getting ready for this trial, ready for all the fun we've had in the court and through these last few weeks. I still have my Christmas trees up. I was complaining to my husband the other day, oh my God, we still have our Christmas trees up. This is embarrassing. And he said, hey, Shannon, we still have ceramic pumpkins up. And I realized, oh yeah, all of our fall decorations are out too. And right now I have piles of laundry all over. My kids over Christmas break put together stacks of stuff I need to take to the Salvation Army. I have donations of my own that need to go. My house right now, if they did a search warrant today, would look just as bad as Mrs. Crumbley's, and it says nothing about me parenting my child. If anything, when I come home from work, I make a deliberate decision. All right, listen, I can run around this house for 3 hours and try to get as much as I can done, or I can sit on my couch and watch old episodes of the Kardashians with my daughter. And I believe my time is better spent hanging out with her, watching trashy TV, than cleaning up my house because I get a chance to spend time with her. And Mrs. Crumbley was the same kind of mom. She was waiting until the holidays to have more time. She said she was going to clean her son's room. I would be screaming that I would make my son clean his room, but regardless, the project coming up was going to be to get those rooms in order. But at that point in the year when the holidays are coming up and you're getting ready for all of it and going through Thanksgiving, it does get to a point where you do have boxes piling up and you're just trying to get through those last days of school to get to Christmas break. There's reasonable doubt when you look at what Mrs. Crumbley thought after the meeting with Mr. Hopkins and Mr. Ejak. The state of mind she was in and her thoughts and what she was thinking come in through her statements. She thought everything was way less of a big deal when she left that meeting. She thought leaving him in school with his friends was the better decision based on Hopkins saying peer support is a good thing. She thought making him an appointment was sufficient within 48 hours was sufficient. That doesn't even mean the appointment was going to be within 48 hours. Reasonable doubt can be seen in the video when Mrs. Crumbley first sees her son at the substation. Her reaction to seeing him in this complete state of disbelief as to what's going on is to look at him and say, why? Why? She doesn't look at him and say, I knew you were going to do this. She doesn't look at him and say, see, I knew we shouldn't have bought that gun. She says, why? Why? And when he says, take care of Dexter, She cannot believe that's her son and goes back into the other room with her husband and says, what the fuck? He didn't even care. And while the prosecution asked questions about, well, she's not sobbing, and we hear sobbing, and that's clearly James. James is sobbing. When you look at the video, if you decide you need to see it, Mrs. Crumbley is dabbing her eyes and wiping her eyes. And fine, she's not the crier some other people are. Reasonable doubts can come from the statements in the heat of the moment at the substation when Jennifer Crumbley is in a state of shock trying to answer their questions. She says, he's never done anything bad. This is after she already has somebody saying you really should have a lawyer there. She's still just talking about what the truth is. He's never done anything bad. One of the parents says he's a perfect kid. Jennifer Crumbley tells them the most of an issue he ever has is anxiety over tests. Jennifer Crumbley tells them everything was fine this morning. In the statements Jennifer Crumbley made when she was in the car and doesn't even know yet if there has been fatalities, she says he's never done anything. She acknowledges he ruined lives today. She says, it's the first time I've ever seen him do anything. She says, he's a good kid. He's never angry. He's mellow. He's not what he looks like. He's not a monster. And she's not a monster either. She explains to them in detail when they ask, he's never had mental issues. In those moments, she can't even think straight about life around her. She's worrying about a horse and her job and all kinds of random stuff. And ladies and gentlemen, when emergencies happen, life doesn't just stop. So the fact that she's able to function and think, I still need a job, I need some money, I need a phone that works, that doesn't mean she thought her son would terrorize and kill people and shoot people at a school. Her reaction when she finds out there are fatalities was genuine and honest, and she broke down crying, although she does continue to keep answering their questions. She explains why she feels like fatalities are different. She explained that on the stand. If he had shot people and injured them, it was something they could at least deal with. But a fatality is a fatality and can never be changed. The prosecution's attempt to misconstrue Jennifer's entire demeanor is a reasonable doubt in this case to show they don't have a strong case. They keep saying she's not sad. Jennifer explained she went into what can I do mode. She did show sadness if you read the texts between her and Mr. Maloche. She showed sadness in the way that she shows sadness. And for these officers to get up on the stand and say she didn't behave like the mother of a school shooter should behave is nonsense. None of them have ever dealt with the mother of a child a teenager who has just killed people and shot many others. There isn't a right way in any handbook to say how you should or should not behave. Trying to make her look selfish and callous goes right with that same thing. How she reacts is how she reacts. You see it on the screen. It's really hard to pass judgment, although these police officers did, on how a person should react when for the first time in their lives they walk out of their house and are surrounded with guns in their face. Or how a person would react to be woken up in the middle of the night on a mattress with police around them and above them with guns in her face. So not only has anyone not been in the shoes of a school shooter and dealing with the kind of emotions that would come with that, they also don't know, and there isn't a standard reaction for how you behave when you're surrounded with guns in your face? Jennifer's own statement provides reasonable doubt that she didn't think he would hurt other people. She typed to him, "Ethan, don't do it." She didn't say, "Don't shoot people." She didn't say, "Don't hurt anyone." She thought the only thing on her radar that could be possible at that point, knowing there's an open shooter and he has a weapon, was that he would kill himself. Reasonable doubt can be found in Jennifer's testimony. Jennifer's testimony is evidence. And at the end of the day, whether you believe, like, hate, however you feel about her testimony, the defense didn't have to prove anything. You still have to evaluate the prosecution's case for what it was. However, Jennifer Crumbley did take the stand, and that was not easy for her, to give you additional context about what was going on in the shreds of evidence the prosecution cherry-picked and put before you. The only person who's actually been consistent in this case, and you can find reasonable doubt from this, is Jennifer. She's consistent in what she says to police, what she says to her husband about things, and what she says to other witnesses who testified. You can find reasonable doubt in the fact that the police officers are very, very biased in this case. There is no doubt this is one of the most awful situations any one of them have ever been involved in. But it's also very clear they have a narrative that Jennifer Crumbley is responsible. And when they came in here and took that witness stand, they were going to mess with me on questions that were so stupid. Like this ATF agent telling me he doesn't know if teenagers could lie. Everyone in the room knows a teenager could lie. That was a low ball. Just answer the question. When you have an ATF agent that can't even get on the stand and answer a question that's common sense, that should speak volumes. That there's a narrative they've been directed to get out, and they have an agenda. And that agenda, ladies and gentlemen, is not positive for Jennifer Crumbley. Making this big deal about money and cash that Mrs. Crumbley took out is another reasonable doubt in this case. Mrs. Crumbley explained her dad had accounts frozen. She didn't want her accounts to be frozen. Her dad put money in that day so she could take it out. Getting money out of the account that had her son's name on it wasn't done in any way to steal money from her son or show she doesn't care about him. She's the one that contributes every week from her paycheck into that account. And at the end of the day, she wants cash because everyone in the world absolutely hates her. She can't walk in places and hand them a credit card. Hey, Jennifer Crumbley's on that credit card. The only option she had was cash. She can't go in and start showing identification and things to get hotel rooms, and the more cash she can use, the better. The less she has to risk that people are going to figure out who she is. And remember, the world was essentially showing its colors against her as she was receiving threatening messages in the days that followed that shooting on Facebook from other people, in her emails, in her Instagram, everywhere. They're so threatening, her employer is making her shut down accounts. Her friends, people that have been her people for years, don't want anything to do with her and don't want to be by her because she's that dangerous at that point in time. So for her to want to have cash makes absolute perfect sense. That's not a sign she's trying to flee. And also, if you're trying to flee, you don't go around local Oakland County and areas surrounding it and carry around a syringe of horse medicine. If you're going to flee, you abort mission on the horses. At that point, you're fleeing. It's very obvious Jennifer Crumbley, her intent was not to flee. Her intent is to stay safe. Her intent is to avoid threats. Her intent is to get this horse medicine to this horse. which obviously can't happen if she flees. It's clear when she's at the art studio that she's not hidden very well. She's outside smoking. Her husband's outside smoking. We saw the evidence of the cigarette butts in the snow. There's commercial buildings around and businesses within that studio. She's walking around taking a tour of the studio with her friend who owns it. And there's cameras all over the building. Obviously, she's not trying to hide if she's going into a building where you can see security cameras right on the outside that would document everything that's happening that we ultimately got to see in this trial. It's clear she's trying to stay the night in Detroit on November 3rd and didn't know where to go. It's clear from the video she's dead asleep at 1 o'clock in the morning when they're ultimately found and woken up to guns in their face. She testified she took 4 Xanax and so did her husband. We also saw evidence there was a liquor bottle in the garbage and presumably she had a drink. After 4 days of no sleep and not really eating, one can only imagine how hard 4 Xanax and a cocktail might hit you. So they make this big deal that there's text messages after 11 o'clock saying we might have been found. Well, earlier in those text messages that were admitted by the prosecution is Exhibit 430. The first text says, Marielle, this is Jennifer's phone. And Marielle was the other attorney at the time. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. Next message. The other phone broke. And then there's a message to the Crumbleys, when you can, we'd like for you to call us. That's at 6:19. Then at 6:21.
I'm back.
Shannon's calling you both shortly.
Oh man.
Then at 7:02, I text, Marielle and I are going to come get you in the morning. We do not think it will help to make a statement that you're coming in or that it will be tomorrow morning. All we can say, as we've told everyone, is that you're coming back, and as of tomorrow, you'll be back. My next message says, we can show them that everything we've said was going to happen did happen. Because the Crumbleys weren't running. They just wanted to turn themselves into a court. And law enforcement got on the stand and told you that's something people commonly do. It just didn't happen in this case. At 7:03, the Crumbleys right back, and we don't know if it's Jennifer or James because they're sharing his phone. Okay. Text to the lawyers that say Marielle Shannon lawyers. Who knows why they sent that? I text, I am going to drive home from my office right now. I'll give you a call in about 45 minutes so I can get all of the bond factor information written down for you, for Marielle and me. I'm asking for bond information so we can go to the court in the
Your Honor,
morning.
I'm gonna object. There's a prior ruling. She cannot be a witness. That was already dealt with.
Sorry, I thought I was arguing off the evidence they admitted.
Well, you can argue off the evidence.
Okay. So they say at 7:37, okay, we'll be waiting. I'm gonna call in 1 minute, okay. Then at 11:14 on the phone that both of them have been using, a text is sent to the lawyers. Think we might have been found, don't know, just a heads up, please check. It's not for a couple hours that they're actually found, but Mrs. Crumbley testified she didn't send that text and she was already asleep. Now, after those text messages, there's 2 more pages that are included in that exhibit. So if you do end up taking a closer look at 4:30, which is totally fine, just be aware that there's another thread that starts that's a repeat, and I don't know why that is. I just want to let you know that, and I'm not sure why that exhibit is like that. That was a new one we got, obviously, all today. In the days after Mrs. Crumbley and Mr. Crumbley are planning to turn themselves in, we know they're planning to turn themselves in because Exhibit A was admitted, which showed they were trying to find a hotel in Auburn Hills on Priceline for December 4th and 5th, in case they needed it for the weekend. There's no doubts, and I don't need to go on and on about this, they were getting threats. That was so clear at trial. They were afraid to go turn themselves into a police station. A police station where if they went, there would likely be other inmates or bad people there, and their faces would be up on a TV because it was all over the state at that point. They were terrified. They wanted to go in through a lawyer. Reasonable doubt can be inferred from the fact that they set an alarm clock, which was admitted by the prosecution, showing that on Saturday they were getting up at 6:30 or 6:45, completely consistent with their plan to go to Novi for an 8:30 hearing. This is also not James's trial. I am not standing here suggesting that James is guilty of involuntary manslaughter in any way, but it is important to point out that James was the parent responsible for all of the storage of the guns. Jennifer Crumbley barely knew a thing about them. She didn't object to them being in the house. She didn't object to buying the gun that James and Ethan were interested in. She didn't object to calling it Ethan's Christmas gift. She was not responsible at all for the storage of the weapon. It is misleading to suggest by the prosecution that that 6-hour case was open on the bed and that it sat open like that all day with the ammunition box next to it. It's very clear that when James and Jennifer Crumbley were on the phone during that 7-minute phone call, Mr. Crumbley was looking for the gun, found the gun was missing, asked Jennifer Crumbley, where's the ammunition, pulled it out, and set it on the bed. It's not like that gun box, that case, was just sitting out there open at all times. When law enforcement did get there, find it on the bed, even they moved it around to the kitchen counter and other places. While this is not James's case, it is fair that Jennifer Crumbley would expect that he would have more flexibility in going to handle an issue at the school. That is not unreasonable and does not make her a bad mom. He's out in the Oxford, Lake Orion, Rochester area door dashing. She's the one with the professional career supporting the family and paying all their bills and trying to keep her job, which they may need to add the family on for insurance in this open enrollment period. She shouldn't be diminished as a mother because she was going to let father go to the school and handle whatever issue there was. Now, ultimately, they went together, but he's a DoorDash driver. She's trying to pay the bills. She's the breadwinner. At that time, he's in between jobs. She shouldn't be dinged for that. It's misleading for the prosecution to suggest there's been evidence in this case. She keeps guns in the car. She didn't say she keeps guns in the car. When she was interviewed, and if you really want to watch the interview, you can. Jennifer told law enforcement there was one time that gun was in the back of her car. That one time was when James put it in the back of the car, and she drove the car to the range. Her son and her had a experience at the range, and she drove the car back home, left the car locked with the gun in it, so that when her husband got home, he could put it away. It is not true that she was driving around keeping guns in the car. That is not what she said to police. As far as Mrs. Crumbley knew, there was a cable lock on the gun at all times. She called it a string lock. She testified that the key was kept in a separate place in one of the many beer steins they had. She testified that she did know where the ammunition was. She hid it in her drawer of jeans. And she testified that things were locked and hidden separately, and that Mr. Crumbley was responsible for hiding the weapon. If you are upset with how the weapon was hidden, that's not your issue to decide. That's a future jury that will look at the case of James Crumbley. You're here to look at the case of Jennifer Crumbley and consider what she knew. She is not the person responsible for storing this weapon. I'm not trying to suggest she didn't know it was in the house, but she is not the person putting the cable lock on and off or doing anything with the gun. We saw her gun abilities when she went to the range and had to have her son show her everything about it. It's a gross overstatement to keep saying that the gun was his gift. It's very clear it was something bought for him to use at the shooting range, something that may one day ultimately be truly just his. But it's just like any of us giving our kids a laptop to use, a cell phone to use, a car to use, a jet ski. I have a friend that has kids, they have snowmobiles. Nothing different. It doesn't really mean the kids just have free access to all of that stuff. It comes with conditions, rules, and parameters. Unfortunately, this is a case where the prosecution made a charging decision way too fast. It was motivated by obvious reasons for political gain and media attention. And we know that because on 11/1, when the shooter was arraigned, the shooter was on Zoom, and so were the parents, and the media was aware. And when Mr. and Mrs. Crumbley were charged, and there was a swear to at the court, the media was all there, but guess who wasn't? Mr. or Mrs. Crumbley. Mrs. Crumbley testified she didn't even know there was going to be an arraignment, but the media knew. And then the prosecution came out with a big press conference, announcing it. I would submit that the plan was never to let the Crumbleys turn themselves in, but to turn them into a big charade of looking like they're trying to flee when they absolutely weren't. The prosecution and law enforcement have approached this case with tunnel vision from day one. Brian Maloche called it a witch hunt. I would submit to you it was. And once they charged these parents and the ATF, Sheriff's Department, Border Patrol, Secret Service, all U.S. Marshals, not Secret Service, when all these agencies have gathered around and hundreds of people are looking for the Crumbleys, it's really hard to say, we made a charging decision a little too fast. And in this case, you heard evidence that much of the evidence in the case didn't roll in until after the parents were charged, arrested, and in jail. To try to suggest having multiple phones as a sign of fleeing is just garbage. I think everyone here clearly understands why they bought burner phones and why they went and bought replacement phones with their phone numbers so they could use two-factor authentication to get into their accounts. Jennifer Crumbley is seen in the police interview at the substation handing her phone to law enforcement when they're asking questions. When the police tell her they want to take her phone for a search warrant, she doesn't want to hand it over right away, but it's not because she's trying to hide things. It's because it's her only line of communication. She doesn't really understand how a search warrant works until her husband explains it. All of her contacts are in the phone. She doesn't carry around a little diary of all the numbers, although police do let her get the numbers out. And it's the only way people can get a hold of her, and she's been in touch with them nonstop, as we can see when she's in the police vehicles. And again, although she's on her phone, and there is a substantial amount of time where she's looking things up, communicating with people, trying to get things done, that doesn't mean she believed her son was a school shooter and had no emotions over what was happening. The prosecution has painted her out to be a person who lacks remorse, and I would submit to you that she would change everything if she could. And when she looks back and says there's not a thing that she feels she could have changed that would have changed something, you have to keep in mind that the suggestions by the prosecution are just ridiculous. giving him a hug that day in the counseling office was going to stop a mass shooting. That's just ridiculous. There is nothing to prove
That is ridiculous.
that anything could have stopped a mass shooting when you're dealing with someone who is so manipulative and is a criminal and was a shooter in cold blood and pled guilty and took responsibility as an adult for his crimes. Finally, my last reasonable doubt card is blank, because I've tried my hardest to come up with all the reasonable doubts the defense sees in this case. And like I said, each of you need only one to vote Mrs. Crumbley not guilty. But a lot of times jurors think of a reasonable doubt I miss because there's so much evidence. And we've already established, and I've admitted I'm not a perfect person and not a perfect lawyer. So I put a blank card before you so that if you have a doubt I've missed, you know you're not limited to what I've suggested or the defense has suggested. You're welcome to come up with your own doubts on your own. And if you decide you want to dive in and read the truth between Mr. and Mrs. Crumbley and everything they talk about, you're totally more than welcome to. Those exhibits are all going back with you. And what I'll tell you is that you're going to find a lot of instances where Mrs. Crumbley is anxious, asking where her son is, where her husband is. You're going to see a lot of horse talk. You're going to see arguments between a married couple. When I read them, they read just like my husband and myself, yelling and swearing at each other at times. And then the next message says, hey, what do you want for dinner? And then we just move on, and that's just how life is. You'll see messages in here that will certainly make you blush when you read what Mr. and Mrs. Crumbley intend to do in bed that night. You will read a variety of messages that show real life and real life between two married people that have a child. And it should make no difference that they may use their horse's name more often than their son's. And I'd also submit that every time you see them talk about when is he going to be home and what are we going to eat for dinner, even if they don't use the words spelled E-T-H-A-N, that's who they're talking about, because there are only 3 of them in that house. At this point in the trial, I am asking that you find Jennifer Crumbley not guilty, not just for Jennifer Crumbley, but for every mother who's out there doing the best they can, who could easily be in her shoes, for every parent doing the best they can, who could easily be in their shoes, for every parent that has snippets of text messages that could be read and make them look like horrible monsters, for every parent that has fights with their kid on text message that also would make them look like terrible parents. For every parent that's ever had a hobby and has not spent 24/7 with their child. That should not be held against parents. For any parent that's ever had an affair or spent time communicating on an affair, that says nothing about how much you care about your child or your expectation of whether or not they would commit a school shooting. Most people who have affairs would still not expect their child would do this. I do wish more than anything, this case could bring justice to the victims of the shooting, the victims of the terrorism that took place that day.
This is a good
And the
point.
victims of their families. I wish more than anything, it really could be a result that would be a Band-Aid to make everyone feel better, but it can't be. First of all, it brings back nothing for the people who have lost. It certainly doesn't bring back any lives. And if anything, this is not justice. This is not how justice works. This case does nothing for the people who have already lost everything. Many of the people sitting in this courtroom. And it does nothing to bring back the tragedy that unfolded on November 30th. At this point in time, the prosecution cannot prove that Mrs. Crumbley avoided exercising ordinary care that would have saved lives. The prosecution cannot prove that Mrs. Crumbley was aware there was a danger that existed by her son that required her to exercise reasonable care. They cannot prove that she was grossly negligent and that there was any way she could foresee that this would happen, as awful as it is, and we all stipulate it is. At this point in trial, I always have to sit down. This is how the court rules work. Prosecution gives a closing, I give a closing, they have an opportunity for rebuttal, and then I don't get to say anything else. And I'm sure you can see from my demeanor in trial, when the prosecution says something that I know I have an argument against, I get anxious, you can see a reaction, and I'm not going to do that. But I am going to tell you that as they argue, I will have many things that I wish I could get up and say, that's not true, and argue against. So what I would ask is that when you go back in the jury room and begin to deliberate, you think about and ask yourselves, what would Shannon Smith have said in response to the rebuttal where they get the last word? I would just ask that you consider that in your deliberations, because I guarantee you I'll have a very hard time sitting here knowing that the prosecution gets the last word when I know the defense would disagree with it. And I am asking each of you to vote that Mrs. Crumbley is not guilty because she is not guilty, and because a not guilty verdict is the only fair and just result in this case. Thank you.
Yes.
Oh, here we go. Yep, they're going to do it right now. I hate that prosecutors get the last word too. I think it's wrong. I think they should each get a chance to go and then stop.
And that's why we get the last word. And it's a burden I embrace. It's the burden to prove beyond a reasonable doubt that Jennifer Crumbley is guilty of involuntary manslaughter. It's not a burden that I have to prove every single fact about the case.
I swear to God, I thought you just said it's not a burden that I have to poop.
That's what she told you the law.
I thought that's what she
It's not
said.
the law.
Alrighty
You
then.
have to prove every element beyond a reasonable doubt. Beyond a reasonable doubt. Not any doubt. Beyond a reasonable doubt.
He's trying to lower that standard.
Gets to decide how they present their case.
Yep.
They get to decide that. She gets to stand up and say what she said. But your job is to listen to the facts of the case. Your job is to listen to what the judge.
Yeah, the facts
tells
suck
the
for
law
you.
is. Your job is to tell you to look at the evidence, the people sitting here, not what somebody else wants to have said that they said, but what they actually said. Your job is to consider not what lawyers say about their own life and their own circumstances and their opinion. Your job is to consider the facts and the evidence in this case. I have to address a couple things, and I'm going to be quick. There was absolutely no evidence at all presented to you that anybody at that meeting told Jennifer Crumbley it was no big deal. There was no evidence of that. There was no evidence at all that Jennifer Crumbley was very surprised by how long the meeting lasted. Jennifer Crumbley didn't say that. That's not into evidence. I don't have to prove, the people do not have to prove that Jennifer Crumbley knew that there was going to be a homicide or a school shooting. As Lieutenant Willis pointed out correctly, if she knew exactly what was going to happen, she'd be charged with murder, ladies and gentlemen. She is not. She is charged with involuntary manslaughter. And the elements, you'll get them. I read them to you. The standard and what I have to prove is not that she knew that her son would go shoot up school and kill 4 kids. I have to prove that she had a legal duty. She negligently performed that legal duty. She negligently did not take steps to take care and protect the other children in that school when there was a reasonable foreseeability that ordinary care was required. The smallest of things. The smallest of things. I apologize to the law enforcement in this room and any listening that I have to stand here and to defend their integrity. But I do. Because if you believe that Special Agent Brandon and Lieutenant Willis and the other law enforcement that took the stand
Your Honor,
here, including
I'm objecting because I'm allowed to argue based on what's in evidence, and Miss McDonald is trying to make me sound like I've done something wrong. And I didn't. My argument was proper.
She's arguing. It's my rebuttal.
Yeah, and overruled. You commented on the statements of the police officers. You argued about the statements of the police officers. She gets to argue about the statements.
The exact quote was, they probably did that to all the witnesses in the case. If you believe that, then you believe that the sheriff's office, Lieutenant Willis, Special Agent Brandon, the ATF, the federal marshals, the Detroit Police Department, anyone who the evidence tech, they were all in some sort of conspiracy. That's what you'd have to believe, and I know that that's not what you're going to find. Look at the evidence, apply the law, and decide what the truth is. That's all I've ever asked you to do. That's all the judge is going to ask you to do. Nothing here was designed. Nothing here was made up. And I don't have to convince you of that, because I know that you're going to use your hearts and your minds and your sense of reason, and you're going to look at the evidence. The first statement Jennifer Crumbley makes about this gun, her son's gun, was at the substation after the shooting, and this is what she said. It was hidden. It was hidden. That's what she said. It was hidden, ammunition separately. It was hidden in a dresser. It was hidden.
You are fake news.
That's all she said about it. The school's actions or inactions do not excuse the culpable behavior by defendant. Ladies and gentlemen, he literally drew a picture of what he was going to do.
Yeah, 2 hours before he did it, and the school didn't send him home. School didn't look at his bag.
You are fake news.
Of the gun that she bought him, posted, and bragged about. Blood everywhere. The thoughts won't stop. The world is dead. He drew her a picture.
2 hours before, asshole.
Quiet, quiet, quiet.
Pretty egregious and unique circumstances. And in fact, it is absolutely not true that we have to worry that we'll all be sitting here.
Yes, we do all have to worry that we're going to be sitting there because of prosecutors like you.
Go fuck yourself.
But go fuck yourself.
You should consider it. And when you consider it, I'm confident that you will agree it is not consistent at all. It wasn't even consistent from her direct examination to her cross-examination. She acknowledged sitting here when Mr. Keys asked her about, where's this phone? You said you took the phone. You heard what she said. We took his gun away. We took his gun away.
And she didn't say his. She said took the gun away.
I don't have to prove flight beyond a reasonable doubt. I already told you that. You can infer.
Nobody
consciousness of
cares.
mind. And what does that mean? You run, you delete text messages, and you lie because you know she knew she did something wrong. The question
Bullshit.
about why Jennifer Crumbley didn't take one of these small actions, secure the gun, find out where the gun is, it looms large in this courtroom. There is no one it looms larger for than the victims and the family members of those kids who were killed on that day.
Oh, here we go.
We don't have to prove why. But remember what she said. I wouldn't change a thing. Just hours ago.
Well, she said she would.
I wouldn't
If she
change
could
a
go
thing.
back and change it, she would.
No, she said there wasn't anything she could do. She would go back and change the outcome if she could.
Prosecution is about nothing else
But she said there wasn't anything she thought she could have done differently.
of this case.
So she did say that.
What Jennifer Crumbley did.
But if she said she would change something, then that means that's a catch-22. You're damned if you do, damned if you don't. Because if you say, yes, I would go back and do this, I would not have done this. Well, then you're saying you're culpable. You could have seen it and you
I
didn't.
could make that better. I could appease them, as defense counsel suggests, by charging Jennifer Crumbley. These are the parents of Hannah St. Juliana. These are the parents of Madison Baldwin. These are the parents of Tate Meir. These are the parents of Justin Schilling. And not just their parents, they are mothers and they are fathers and they are sisters and their brothers. And do not think for 1 second that this prosecution takes any of that pain away, because it doesn't. This isn't an effort to appease anybody. Your verdict
Yes,
means
it
one
is.
thing. It means Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter beyond a reasonable doubt.
Bullshit.
And I am not going to stand here and tell you that that's going to take away this pain that these families feel, because it will not. I won't stand here and say that the pain will be gone from Molly Darnell or Christy Gibson Marshall or Special Agent Brandon, who ran out of that office so quickly.
Deny.
His chair
Sit
was
down.
spinning. Or Ed Rogrowski, who viewed the surveillance video to identify the path of the shooter, and it was burned in his
This is
brain
all they
forever.
have, is to traumatize the jury with that shooting footage.
To lead, and maybe the biggest ask of his entire career, but one he did not back away from. Don't render this verdict for the hundreds of kids in that school. It will not appease them. Nothing will. But you are now called upon. You are called upon. You are called upon to do your part as jurors.
Yeah, she's
To keep
pounding the
open
table
and
now.
To be fair, to be honest, to be impartial. You are the ultimate fact finder. But what happened that day?
If there was
You
a
are the
table in
ultimate
front of her,
fact
she'd be
finder
pounding on
of
it.
the truth. We have met our burden. We have proven beyond a reasonable doubt that Jennifer Crumbley is guilty of 4
Oh,
counts
pointing
of
now.
involuntary manslaughter.
We're
for
pointing.
failing to exercise ordinary care when the
What an
smallest,
asshole.
tragically simple thing could
Does
have
no one
prevented
have
it.
any empathy for these parents? None.
It
No
could
one
have
has
saved
empathy for them
Hannah.
at all.
That was the defense's counter, but now she's trying to hit her with a bus.
Yeah. Yeah. Strange. It's like, yeah, you want the jury to hate this woman. And it could have been any one of us. Let's just be totally honest. Jennifer Crumbley could be any of us.
And it could have saved Justin.
This culture is dangerous.
And she sat here and she said she wouldn't do one thing different.
Our kids are in danger every day of being sucked down some horrible rabbit hole on TikTok,
People in this courtroom and a lot of
cutting off their breasts. God knows what they're doing. I mean, honestly.
I know they're all asking, and they want to say, when she took the stand and she testified about her own loss, and she was asked the question, "You lost everything." She said, "Yes." She hasn't lost everything, ladies and gentlemen.
Oh, she hasn't lost everything yet. We haven't killed her yet.
She's still alive. Find her guilty of 4 counts. of
Her son is still alive, but he's in jail for murder. And she can't, I mean, what is she kidding? Oh, she hasn't lost everything because her son is still alive. Well, maybe the state will kill him too, man. Would that make you feel better?
You guys have been so terrific. You've been on time.
I just can't even believe this argument.
I still have 5 alternates.
She hasn't lost everything. We have to take everything away from her. Her son's still alive, so let's take him too.
Newspaper has posted anything on Facebook, has talked to anyone who talked to someone else who repeated it to the court. We appreciate that. You know how hard it is. I'm going to ask you to come back Monday. But I want to instruct you that during the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards.
Yeah, so
For
all
example,
17 are
witnesses
coming
must
back on
be
Monday to then go into
examined,
deliberation.
examine them.
Okay.
Because news reports do not have to meet
Are
these
they going to start
standards,
deliberating
they can
tonight,
give you
though?
incorrect or misleading information
No?
that might unfairly favor one side.
That's
So to
surprising.
be
I
fair
don't
to
know
the
why.
students,
You would think they
That
would.
it's only
Do
4:30.
not go on social
They should
media. Do
deliberate
not
at
post
least
on
through
Facebook.
dinner.
Do not read Facebook. Do not do research. Do not discuss the case with
Why
anyone.
give them the weekend
I'm
and
going to
instead
ask you
of
to come
just
back
let them start
on
deliberating
Monday.
right now?
You'll all come into the courtroom. Can you come back at 9 o'clock on Monday? I'm going to give you instructions. After I give you the
Oh, that's right. They
instructions,
haven't read
5 of
instructions.
you will be drawn by lot.
Oh,
But you will still be sequestered in a separate jury room. So you'll still be required to be here. All right. Do you have any questions about the schedule? Did you all order lunch on Monday? All right. No questions about the schedule.
Bring them lunch.
We have come this far. Please follow my instructions. It's very important.
You're getting like $5 a day. The least you can do is buy them lunch.
Have a good weekend and stay healthy. All right.
All rise for the jury.
Lunch entrees are going for $15 and you're paying for a third of it. Like, Jesus Christ.
yeah. Jury's going home and going to watch YouTube all weekend. Well, I hope not. But I think it was very risky for the defense attorney to mention the press to them. That was very risky. As far as they knew, no one's talking about this case until she told them that there are TikToks.
The captain graciously volunteered to have deputies here late into the evening, but it is late enough that would be very difficult. So at 9 o'clock on Monday morning, I'm going to instruct the jury. I'm going to have the 12 jurors deliberate, but I'm also going to sequester the 5 alternates. All right, any questions about that?
No, thank you, Judge.
No, Judge.
Thank you. So can you wait till the jury's done?
Wait till I hear something.
Okay. All right, yeah. I'm gonna check, so thank you. Have a good weekend.
Thanks, Shannon.
All right. Is she going to talk to the lawyers after that, Brad? Keep an eye on it just in case if there's stuff happening with the lawyers.
Yeah.
But I want to bring up this article because this really bothered me. I just found out about this. Thank you in the chat to the person in the chat who brought it up. Trans teen who planned mass school church shootings and wrote chilling manifesto sentenced to 6 years. Only 6 years. She shot like a kindergartner in the head. Transgender Colorado teen who admitted to plotting mass shootings targeting at least 3 schools and who had penned a chilling manifesto praising infamous killers. Isn't this the same one who killed kids? Or did this one not kill anybody?
I don't think she killed anyone. I think the one that killed kids was the
Oh,
one
she
that
got
taken out
killed.
by police.
That's right. That one got killed. Okay, this one didn't kill anybody, but she planned on killing people.
Yeah.
Okay, and she only gets 6 years. Is that a joke? What? We're not a serious country.
And given credit of 306 days.
Oh, for time served. Okay. Given Whitworth's transgender status, it was not immediately clear whether. Wait, is this a girl or a boy? Because I'm not. Is this an actual girl?
That's a trans woman.
Wait, I don't understand. That's a boy.
That's a boy. That's says
All right.
it's a
Well,
girl.
then I'm not using she pronouns. No fucking way. No, not doing that. Lily, born William, learned his fate in an Elbert County courtroom Tuesday. He was given credit of 306 days for time served. Given Whitworth's transgender status, it was not immediately clear whether he would be sent to women's prison or a men's facility. Oh my God. Oh my God. You know what? At this point, just open up a new facility to put all the trans people in. How about that? Because I think we have enough trans criminals now where we can just open a trans jail. And you can call it the women's facility where you put all the boys, and you can call it the men's facility where you put all the girls. How does that work? Because I don't think that anybody should be put in danger by putting boys and men in women's prisons. Ridiculous. And I don't see a whole lot of biological women making arguments to get into men's prisons. Do you? Have I ever seen that?
No.
Never. 6 years only for planning and plotting a horrific shooting.
At the middle school that she previously attended.
Yeah. Disgusting. Disgusting. I hate this. Just pointing that out. I hate it. Meanwhile, we're trying. So we put an actual shooter, someone who said they were going to do this. We put them in prison for 6 years, and we're trying to put Jennifer Crumbley into prison for I don't even know how long. I don't know, but I bet it's at least 6 years for not having anything to really do with this. So
do we charge Lily's parents for
Yeah.
allowing their child to?
Yes, that's a good question. Do we? Do we charge Lily's parents? Manders, thanks for the gifted memberships. Welcome to the Fox Den, all of you new people. Glocky McGlockface says she slid down the fireman pole. I don't.
Oh no.
Oh no.
That's what she said.
The affair was a fireman.
Oh, he was a fireman? Okay. Sarah Adams says, Megan, I just can't quit you. Thank you. Duncan, Idaho. Okay, defense argument sucked, then started in a good direction, then changed to slightly more crappy. I wish she would find it and keep it. I actually thought her closing was really good. I did. Duncan, Idaho says, this jury is also going to find the defense attorney guilty after all these confessions. Right, right. But I think that was her entire point of saying,
Court's done.
I've done this too. Court's over. Okay. Choosy Heretics, thanks for the $2 super chat. Appreciate that. Appreciate you. Duncan, Idaho says, in so many trials, I don't actually see a human when I look at a prosecutor. I see a political actor and the greedy, grasping fingers of government. Excellent comment. I agree. I see the same thing. Fubar Temp, I brought this up because I wanted to address this. Fubar Temp says, that's not true at all, Megan. Your kids, and I would say 99% of the kids of the parents in this chat would never do what that shit kid did. Okay. Statistically speaking, that is correct. But you would always think this until it's you, until it happens to you. I am not willing to go out on a limb and say my child would never do something like this because I don't know. I don't think they would. I've tried everything in my power to raise other human beings with empathy. And I think I've succeeded. Well, it's too soon to tell with the 9-year-old, right? I mean, you can't really tell when they're little like that yet. When they get older and they're teenagers and they show you that they understand what empathy is, when they're 9, you're still trying to teach them what that means. But my teenagers, I don't believe my teenagers would do anything like this. No, but am I willing to go out on a limb and say they would never do anything to hurt anyone else? No way, man. Because guess what? They are their own person. They're making their own decisions. They have their own personalities, their own flaws, their own quirks, their own mental state that I am not responsible for at some point. And if the government decides that they can try Ethan Crumbley as an adult, you cannot have it both ways. You cannot say on one hand, because we can give him a bigger sentence, he's an adult. But on the other hand, his parents are responsible for everything he did. No. And I'm just not going to go out on a limb and say, oh, my children would never do anything like that. Because I really believe that parents whose children do these things are caught completely off guard. There are very few parents who I think are involved or grossly negligent when it comes to stuff like this. I mean, look at Jeffrey Dahmer's parents. You look at what Jeffrey Dahmer's parents and how they raised him and what they did, and his mother did something really stupid. She left him alone his senior year of high school while his father was traveling, I think. And she left with a boyfriend and left him home alone. And that's when a lot of the bad stuff happened. But was it that one thing? Or was it a series of things? Was it a lot of things all together? And that one thing was maybe just like what made it worse, or look, we didn't hold Jeffrey Dahmer's parents responsible. What about the Columbine parents? I mean, we've listened to them give interviews, and I think most people felt a lot of empathy for them because it didn't seem like they had done anything wrong. And everybody wants to say, oh, well, she bought him a gun. They bought him a gun. That is not illegal. It is not against the law in America to have guns and teach your kids how to shoot them. As far as they were concerned, they thought that he was doing family bonding time with them. If they had thought, I believe that if she had believed that her son was dangerous with a gun, I think she would have gotten rid of it. You know, I just don't, I don't think she saw this coming.
I think the one thing that the defense did do really well is breaking down the scenarios where parents buy their teenage kids items, but just because they bought them for them doesn't mean that they are the sole possessor of them. She used the kitchen block example. She used laptops, cell phones.
Forerunners, horses even. You buy your kid a horse. That doesn't mean you have carte blanche to run around on the horse all day long. I bought my child a car, or she has a car. That car is not for her to use whenever she wants to, however she wants to. Although I call it her car, you know, but it's not her car, it's my car. And if I want to take the keys because she's being punished, I take the keys. I pay the insurance. It's my car.
Yeah, I ended up having the keys taken from me from homecoming one year.
Oof.
That was a rough
that sucks.
evening.
Yeah, I haven't had to take the car yet because she's really good. She's a good kid, and like she deserves the things that I've given her. She's very responsible. But yeah, parents do not give teens these big items, big ticket items, and then they're like, okay, use it however you want to. There are rules. If you buy a gun for your child, that doesn't mean you give the gun to the kid and you're like, okay, have fun.
Go wave it around at people.
Go wave it around. Nobody does this. They clearly had rules for it. They clearly only took it to the gun range. They weren't like, was he posing? I didn't see any pictures of him posing with it on social media. Did they have any? Did I miss that? Because I will tell you this, if there were one of those and you didn't take the gun from your kid, I may change my mind. Was there one of those?
I didn't. Yeah.
Did anybody see a picture of Ethan like that he had posted to social media with the gun? Anybody know? I don't know, because I missed a couple of days of this trial. I saw day 1, day 2, because I think kids who do that, and their parents, if their parents knew they did it, they should take that gun and never, ever, ever give it back, ever, because that's crazy. I hate that. I hate that shit. All right, let's go back to Duncan says we really are not a serious country. It's true. We are not serious at all. Duncan says it's sad that the defense argument in the beginning, I think it turned out to be pretty good. She's a bit of a wild card, but she's got a fire in her. I agree. I thought it was great. I thought it was a good closing. Duncan, Idaho. Kids are great at hiding things from their parents. Ask any 13-year-old boy who's just discovering the internet. I know, it's terrifying. Do you know how and as a parent, you get like really scared that you're missing something, and then I want to be like, oh, give me your phone, let me look through your phone. But when you do that, and I've done it with my kids, I've said I want to see your phone, it causes a rift, a very serious rift between parent and child, where the child, who it turns out didn't do anything, now thinks you don't trust them. They get offended, they get upset. So it's a risk too to your relationship when you're like, let me invade your privacy. I don't think children should have privacy, but then again, I kind of think unless they've never given you any reason to believe you need to. Like, I don't think you should be invading their privacy for nothing, for nothing. The only time I've ever done that is when one of my kids acted suspicious when I walked in the room, and like closed something. And I'd be like, no, hand it over. Let me see. And not once have I found anything egregious. It's just stuff I had told them not to watch. Nothing like, terrible. But then it gives you like a reason to be like, okay, well, now I have to monitor you because you didn't obey. And that's unfortunate. But that's but I don't want to be like want to destroy the relationship you have with your kid. You want your kid to come to you to tell you things. So you can't always be up in their grill and down their throat about everything. You know, like I don't know. I don't know where this ends, but it's like you're putting parenting seriously like under a microscope, and nobody is the perfect parent. And that's what I liked about the defense's argument. She was like, I am not a perfect lawyer. I'm actually really bad at some things. I'm really unorganized, and I say things I've had to apologize to you all the time. And, I'm sure that maybe some of you don't even like me very much
Don't
because
let me near this laptop.
yeah, I can't touch. That would be me. Like, I'm not going to push any buttons because I'm really bad at all of that. I thought that was a really good argument, because how many of us can say with a straight face, I know there are a lot of us who like to think that you're the perfect parent, who like to say that I'm better than other people. And you like to say, this one is bad and that one is bad, but I'm not. But deep down, you know damn well that you are not perfect. You are not a perfect parent. You're not a perfect person. You have made mistakes. You've made some embarrassing mistakes that you hope nobody ever finds out about. You hope that the police never come and get your phone, because there are things in there that would embarrass you, that would make you, that would humiliate you. And we're all like this. There's not a single person out there who could be like, here, take my phone and go through it, and I won't be embarrassed by anything on it. You know what's on my phone that would embarrass the shit out of me, and they would totally splash it all over the UK Guardian? My before and after pics. Like, okay, I'm on a diet now. I have to take these pictures so I can see any changes. So here's my big fat belly pictures. Like, I've got tons of those. Luckily, though, I cut my head off of all of them so that I have plausible deniability in case they should ever go public. Everybody has those, don't they? I don't know. I don't have any videos of me doing squats, though. Brad, do you have any before and after pics on your phone in your underwear? Brad left. He got scared away by the. He doesn't want to see. He doesn't even want to answer it.
No, actually, I've had worse.
Oh, really? What's on your phone? Do tell.
Actually, I don't even think it's on my phone anymore. But
oh, it's all in the cloud.
I mean, no, surprisingly not.
How'd you get it off the cloud? I need you to delete some shit off my cloud.
Because I think it was direct to a person, not saved elsewhere.
Oh.
But
well.
Before I got married, I call myself a womanizer back in the day, because I was in a bad emotional spot, and I needed a relationship in order to validate my existence. And I was serially going through women like water.
Oh my.
But
it happens. It happens.
It does happen. And the problem was that at a very young age, I was involved with a girl. I mean, and the stupid backstory was, in the 3rd grade, I looked around the room and I was like, okay, well, I got to choose the person I'm going to be with forever. And I chose the one girl. And then we ended up moving away. And I still harbored feelings for this girl. And then our school does separate elementary schools for the entire county, and then they throw them all together in one middle school. So I was able to see her again, and then we started dating. We got a little hot and heavy, and then we broke up. But I needed to have that intimacy in order to feel like I belonged. And it was rough. And I went throughout high school. If I had a girlfriend for more than 6 months, I would be surprised. But I mean, that's how high school is. You're with someone, then you're not with someone. But I would go through these like panic attacks if I wasn't with someone, and constantly trying to find the next person. And then that went into my military life, and then on.
I mean, everybody makes mistakes, and everybody has their own stuff. And just, I don't want to see people put on trial for that. I just don't. I just do not. I don't want to see people put on trial for this. I think we've given the state has enough ways to put us in prison. Let's not start adding to it. Let's not start adding to the all the different ways the state can incarcerate us, you know? Like it's enough. And I think the state makes enough mistakes that we don't need to be giving them more rope to hang us with. Duncan, Idaho, thanks for the super chat, says this is for the squats videos. There aren't any. I've never taken any of myself doing that. Okay, I've got good news and bad news. The good news is that you guys, we have just hit enough super chats to open the Ruckus cam. The bad news is the show's over.
Yeah.
So
we're going home.
We're going home now. So here's what we're going to do. The next stream I have, we'll just open the Ruckus cam right away and give him his frozen peanut butter treat. I'm leaving it in the freezer till the next stream. He doesn't need it. He's a big enough fatty. So don't, just make sure you come back for the next stream. And when is that next stream going to be? Probably Monday. I guess we're in for a penny, in for a pound. So I'll be doing trial coverage on Monday. I do have a guest scheduled on Monday, at least somewhat. And during at least I think it's tentative at the moment. So I may have a guest sometime in the middle of Monday's stream. And also there are new documents in the Laura Owens v. Clayton Eckerd tonsil twins case. There's a big document dump that just happened. I got to go through them all and see what I want to read. So there might be another live stream before Monday. I don't know. We'll see how my weekend goes. But pay attention to meganfox.locals.com because you're going to find out there first when the live streams are, because my schedule's not completely set all the time. All right, so that's about it for me. And then Brad and I have to get together and figure out when we're going to do the Vince McMahon lawsuit read-through. I'm going to assume it's going to be after the Crumbley trial is over. So Crumbley trial is probably going to end in the beginning of next week, Monday, Tuesday, Wednesday. So maybe, Brad, we should think about Thursday or Thursday or Friday for that stream.
I know that Nick just did his last night.
Nick did it? He did?
Yeah.
Good, because I sent it to him. I was like, you've got to read this. Oh, I've got to watch that. That's going to be hysterical. Okay. All right. We're out of here. We got to go. I don't think there's anything else I need to do.
You can go
know
anywhere,
what we're
but
going to
you
do?
can't stay here.
Yeah, you can go anywhere, but you can't stay here. But let's do some squats. 8 hours and no squat breaks? What are we, crazy? Do your squats.
You impose fatness on you. You did it by going, oh, I want the butter on the popcorn. Oh, I want the butter on the ice cream. Oh, I want the butter on the sandwich. Oh, I want the butter on the salad. Stop eating butter. Can you just get up, walk 1 mile?
To squat!
Walk farther. And if you can't walk, crawl, roll, get dragged by a goddamn forklift. Whatever is wrong with you, just move. Ever. Get off the chair. Get off the couch. No one is coming to service you while you sink into that furniture, while you become one with the pleather your poor ass got on that Walmart couch. Can you try not floating into sadness? Stop eating, stop drinking, start walking, start doing anything that you haven't been doing, you fat piece of shit!